Okay, you're all set.
Great. Good morning. You're here with the Energy, Utilities, and Technology Committee. I am Mark Lawrence, the Senate Chair of the committee. And in a moment, I will ask members of the committee to introduce themselves and go around the horseshoe. I am from Southern York County. I represent District 35, which includes the towns of Kittery, York, Ogunquit, Elliott, South Berwick, and part of Berwick. And I'll ask my House Chair, Representative Berry, to introduce himself next.
Good morning, everyone. I'm Seth Berry, and I represent House District 55, which is Bodenham, most of Richmond, and beautiful Swan Island on the Kennebec.
Great. And next, I'll go to Representative Nathan Carlo.
Good morning. I'm Nathan Carlo, State Representative for District 16, which includes part of my hometown of Buxton and Hollis and part of Saco in the state legislature. Good to be with you.
Next to Representative Scott Cuddy.
Good morning. My name's Scott Cuddy. I live in Winterport and I represent House District 98, which is Winterport, Frankfort, Searsport, and Swanville.
And next to Senator Eloise Vitelli.
Good morning, everyone. I'm Senator Eloise Vitelli, representing Senate District 23, which is all of Saginaw County and the town of Dresden in Lincoln County and the beautiful island of Swans Island as well in the Kennebec.
Next, Representative Foster.
Good morning. I'm Steve Foster, representing House District 104, which includes the towns of Dexter, Garland, Stetson, Exeter, and Charleston. Joining you after spending 3 days with my grandkids on the ice. All I caught was a cold.
Next, Representative Sachs.
Good morning, everyone. My name is Melanie Sachs. I'm honored to represent House District 48, which is Freeport and part of Powell. Thank you.
Next to Representative Nathan Wadsworth.
Good morning, everybody. Nate Wadsworth. I represent House District 70, the towns of Hiram, Porter, Brownfield, Freiburg, and Lovell.
And next to Representative Paige Ziegler.
Good morning. Last but not least, I'm Representative Paige Ziegler from District 96 in Waldo County. There's 7 towns of Belmont, Liberty, Lincolnville, Montville, Morrow, Palermo, and Searsmont.
Great, thank you very much. And I'm sure you won't be the last, Paige, because I expect other members will be jumping on. And as they do, I'll ask them to introduce themselves. And for members of the public, the lack of all the members being here at this point is not a reflection on their disinterest in the 2 pieces of legislation we're hearing today. It's a reflection that many of the members of the legislature serve on multiple committees. So we have multiple places to be at one time. And we're also presenting bills and testifying on bills in other committees. So we're often going back and forth between different committees to present bills. So as people come in and as people come out, I will ask them to introduce themselves. As we're starting today, Representative Berry and I did get a letter from the presiding officers on decorum that they asked all committee chairs to go over with members of the committee. And these aren't, this is not anything new for our committee, and we certainly don't have any issues in our committee that I am worried about. But they've asked us just to go over the rules of decorum in committees with each committee. So as we approach the halfway point of this legislative session, the presiding officers have asked committee chairs to take a minute to review both with legislators and with public participants the rules of decorum that are integral to the legislative process. Rules of decorum are long-standing in the legislative process and apply to both conduct in the House and the Senate and conduct in the legislature's joint standing committees. These rules vest in the chairs of the legislature's joint committees the same authority as presiding officers have in their respective chamber for upholding the integrity of the legislative process and ensuring fair participation. Under the joint rules, the decorum in the committee are modeled as rules of procedure, similar to the rules of procedure in both the House and the Senate under the joint rules. Here's how that translates to our committee work. Committee members are required to show respect at all times to witnesses and to other committee members. All discussion must be conducted in a manner that is not disruptive. Impugning the motives of another committee member is prohibited. Excuse me. And engaging in the discussion of personalities of other members is also permitted. The chair has the authority to limit testimony at public hearings as necessary for the orderly conduct of hearings. That applies to work sessions as well. And that applies to the ability of the chairs to turn off essentially microphones for members if rules of decorum are being violated. Debate, discussion, and questions in the committee have the same rules of decorum as conduct of members on the floor of the House and Senate. Members shall refrain from interrogation that is argumentative, oppressive, repetitive, and unnecessarily embarrassing to hearing participants. In an effort to maintain order and decorum, all questions must be addressed through the chair. All speakers must be recognized first by the chair before speaking. And all questions related to the order are to be decided by the chair, subject to appeal by one of the members of the committee to the entire committee. If a participant violates the rules of order or decorum, the chair can take action to limit the ability of the participant to continue disrupting a meeting or a public hearing. Every single person who appears before this committee deserves respect, as do our esteemed colleagues who serve on the committee. I want to thank each of you for your efforts in helping us meet our duty to civility outlined in the joint rules and Mason's manual of legislative procedure and precedents from centuries of legislative process in our country. Thank you. And if you have any questions about decorum and order, you can certainly ask me at any time. So having done that duty, I'll now go on to give you the explanation of the public hearing process. The purpose of the hearing is to invite testimony from members of the public regarding proposed legislation that is pending before this committee. The committee will hear testimony from persons present, include those participating by Zoom or by phone, who wish to speak for, against, or neither for nor against the bills to be heard today. With leave of the chair, committee members may ask questions of any person testifying today. Other questions are not permitted, and that specifically goes to members who are participants or invited to be panelists. We're not committee members are not allowed to ask questions of others. Whether or not you testify, you may submit written testimony to the committee. Please be mindful that testimony is public and is available to all once it is presented. Written testimony will be posted on the legislature's website for viewing by interested persons. And I'd encourage everybody testifying today to submit written testimony. This is a committee that reads a lot of written testimony. We hold on to it. We refer back to it as we work bills. So please, if you can, submit written testimony. Persons testifying at the public hearing are advised that the hearing is being broadcast and streamed over the internet and may be heard by persons listening online and to that video stream. It is also being recorded and will be archived on the legislature's webpage. If you wish to testify, please state your name, your residence, and the organization you represent, if any. Testimony shall be heard in the following order: sponsor of the bills, who will present the bill, and any co-sponsors of the bill. Then it'll be those speaking in favor of the bill. In other words, those who want the bill to pass in this form or some amended form. Those speaking in opposition to the bill, those who do not want the bill to pass, those want us to reject the bill in its form, and those speaking neither for nor against this bill. And that last category, I'd encourage people to use that to speak neither for nor against the bill. It's not a way to testify in favor of the bill, but have yourself appear as neither for nor against the bill. bill and neither in opposition. That's used by a person who's neither testifying for or against the bill, but wants to provide the committee with additional information. We will limit testimony today to 3 minutes for people testifying, and we've asked people to sign up in advance. If it looks like one side is going to be going beyond half an hour, we'll alternate. I'll try to alternate between proponents and opponents and neither for nor against to allow them so that people don't have to sit through the whole long hearing to hear each side. In your opening statement, I'd just discourage you from doing repetitive statements or irrelevant testimony. If you could summarize your testimony to 3 minutes, and if you have detail you wish to present to the committee, that's where the written statement is so effective in preparing that detail. The purpose of the 3 minutes is to summarize the testimony you're presenting. Members, people will have signed up in advance on the committee website and through our clerk. And I'm going to ask our clerk just to come online and introduce himself.
Hi, I'm Jason Elleding, EUT clerk.
So Jason is the one who's kind of like the doorkeeper on our committee and like a clerk of courts. He's required to keep all our paperwork and everything. So we ask that if you're interested in testifying, you get your name to him as much in advance, because there's a lot of prep work that goes into preparing what we need today for the chairs and for the committee members. So Jason is key, and I know that those of you who testify frequently before the legislature know this. Get your information to him in advance, and those who it may be a first time, it's always good to get that information as soon as you can to Jason. We also have a legislative analyst for our committee. This is part of the nonpartisan staff that provides us with legal and other advice on questions we may have. And I just ask Lindsay to introduce herself.
Good morning. I'm Lindsay Laxon, a legislative analyst with the Office of Policy and Legal Analysis.
And Lindsay will be taking notes during this hearing, and she will be preparing a summary for us for our work session. Following this public hearing, we will have one or more work sessions to work through these bills. Lindsay will be just giving us a refresher on who testified on what on the committee. She'll also be taking notes if committee members ask questions or ask people to follow up with information for the work session. She will be, in essence, keeping them honest and making sure we actually did get the information, and reminding committee members that we asked for this and what we asked for and why. So with that, we'll go into our first bill. And let me bring it up on the screen, and I apologize. Many of us are working off multiple screens today. And every day now that we do it on Zoom, so when people like Representative Foster is doing is looking away, it's not that we're disinterested in what's going on. It's just that we have a bunch of different issues to come up. Our first bill today, we're going to be taking them in reverse order today, is LD 1959, an act to ensure transmission and distribution utility accountability. And it's being presented by its sponsor, and I'd ask you to beam across Jason, the sponsor, Senator Brennan, and any other legislators who are going to be testifying in favor of this bill.
Senator Lawrence, one
I
procedural
apologize.
note, if I may.
You have a question?
I just wanted to share our procedures for use of the chat.
Thank you.
Want to welcome everyone who is new to the committee process, and you're probably used to using the chat on Zoom. It is very handy, but we ask that people refrain from using it for the purpose of legislative hearings, for the reason that the chat is not part of the public record, and we are required to document everything. So the YouTube stream that's picking this up will be recorded and posted for posterity, and the chat is not visible there. Your written testimony, of course, on the website is also part of the public record, and that's why it's so important to submit written testimony as well if you can. But we do ask that if you have a procedural question, that rather than using the chat, that you do contact our committee clerk directly And again, that's Jason Allerding. You can look him up online at legislature.maine.gov as well. And one other note, just so you're aware, you've already heard the categories for, against, and then neither for nor against, but within those categories, the testimony is arranged in the list that Senator Lawrence and I have by first name alphabetically. So if your first name is Anthony, you're going to be pretty high up in the order. And as we move through the order, if someone had something come up, we will give a chance at the end for folks to testify. If for some reason, we know people have busy days and are taking time in many cases out of their work lives, so we will circle back if we miss you during the hearing. Back to you, Senator Lawrence. Thank you.
Thank you very much. And as usual, Representative Berry is remembering all the things I forget. And I do want to go over that. It's not usual that we take people alphabetically by the first name. We usually take them in order that they sign up. So unfortunately, the list we're getting is not in that order on how people have signed up. So we may bounce around a little on the list to get to people, and we're working with Jason to get it in the order that people sign up on the list. And occasionally people will request of the chairs, and we'll move people around who have to get out of here on a reasonable time. And with that, I'll recognize the sponsor of this bill, Senator Brenner. We need a microphone on.
All right. Good morning, Senator Lawrence, Representative Berry, and distinguished members of the Joint Standing Committee on Energy, Utilities, and Technology. I'm Senator Stacey Brenner. I represent District 30, which includes Gorham, most of Scarborough, and part of Buxton, and I'm here today to present a governor's bill, LD 1959, an act to ensure transmission and distribution utility accountability. I'm proud and pleased to have the opportunity to serve as the lead sponsor of this important and necessary legislation, and let me tell you why. Over the past several years, our utility companies, which are supposed to be here serving us and providing the most essential services we rely on as Mainers, have had their priorities backwards. We've seen inaccurate billing affect thousands of ratepayers, folks going weeks without having their lights turned back on, and terrible customer service, to name just a few examples. The shareholder financial interests of these massive companies have taken the front seat, and it's been to the detriment of all of us. It's why I'm passionate about these issues and why I've been a vocal advocate in the legislature for ways we can fix this broken system. Last session, I testified as a proud co-sponsor of LD 1708, an act to create the Pine Tree Power Company, a nonprofit utility to deliver lower rates, reliability, and local control for Maine energy independence. Many of the reasons why I supported that bill are why I support this legislation before you now. No matter what party you identify with or what part of the state you live in, I think we can all agree that more transparency and accountability for the transmission and distribution monopolies is a smart and much needed step forward. This winter, we've seen even more hardship fall on the backs of Mainers with skyrocketing energy bills. While that increase is not due to increases in the transmission and distribution portion of the bill, Maine consumers just see it as one more insult to injury after years of being neglected. It has brought new urgency to our work and highlighted its importance, not just for high bills, but also for these issues that folks have been forced to deal with. This legislation represents an opportunity for us to do something now, not years down the line, to hold our utility providers accountable and to ensure that going forward, ratepayers receive reliable service at reasonable rates. Maine people are counting on us to take action. LD 1959 strengthens and expands the regulatory tools available to the Public Utilities Commission, including quarterly report cards on service quality with penalties for poor service, and ultimately a forced sale for consistently poor service, financial audits for the larger utilities, expanded whistleblower protections, and requirements for utilities to address the inevitable impacts of climate change. Taken together, this bill will provide greater utility accountability and greater ratepayer protection against high rates and poor service. Under the report card program, the PUC will select specific service standards against which all transmission and distribution utilities will be graded quarterly. If the utility consistently receives failing grades, an administrative penalty may be imposed. If administrative penalties do not result in improved service, the PUC may force the owners of the utility to sell the utility to a purchaser selected by the PUC that can better serve Maine people. This bill also directs the PUC to conduct periodic financial audits of CMP and Versant. This will help the PUC identify expenses that should be carefully reviewed the next time the utility files for a rate increase. The bill also strengthens our existing utility whistleblower statute that protects utility employees who come forward, often at great risk to their careers, to inform this committee or the PUC of the questionable activities being undertaken by the utility. The bill proposes several changes to the statute, including protecting potential whistleblowers who are contractors providing goods and services to utilities, and requiring utilities to inform their employees and contractors of their rights under the whistleblower statute. Although we cannot predict how often the statute will be used, it's a tool to make sure employees, Maine residents, and ratepayers themselves feel empowered to speak truth to power in instances that demand such action. While we all hope and expect actions by these companies are conducted with the best interests of Mainers in mind, it's easy to imagine a situation where just one whistleblower's action could result in significantly lower utility rates and/or better service. Finally, LD 1959 addresses the climate change crisis by requiring the T&D utilities to file a 10-year plan every 2 years, laying out how it intends to protect its assets and operations from the impacts of climate change, such as flooding and storms. For too long, utilities have put their bottom lines first and Maine people last. This bill won't solve every issue, but it moves us in the right direction at a time when we can't afford to delay. When I testified in support of 1708, I shared the following. I make my living as a farmer. Reliable power and transparent engagement with my energy provider is a principal concern for business solvency. Like many farmers, we've been working diligently to convert the power sources on our farm to electric. Farming is an exercise in controlling nature and harnessing power to affect temperatures. Whether it's heating our seedling greenhouse in the late winter and spring to running our walk-in coolers to keep products fresh and quality high, affordable and reliable power is essential to all of these basic farm business needs. Power is second to labor in expenses for our farm business. For those same reasons, I stand before you today asking for you to support this important bill. Thank you for your time. Thank you, Governor Mills, Public Advocate Bill Harwood, and Governor's Energy Office Director Dan Burgess for the opportunity to work with you all on this legislation. I'd be happy to try and answer any of the committee's questions, and those who follow may have better answers about the legislation and be able to provide greater detail. Thank you.
Thank you very much. Are there questions from the committee for Senator Brenner? Seeing none, thank you. And I know for co-sponsors, I've asked Senator Stewart, Representative Wadsworth, they're not interested in testifying. I forgot to ask you, Senator Vitelli, are you interested in testifying?
Yes, please, sir.
Okay, go ahead.
Thank you, and good morning, everyone. Senator Lawrence, Representative Berry, and fellow members of the Energy, Utilities, and Technology Committee. My name is Eloise Vitelli, and I represent Senate District 23, which includes, again, all of Saginaw County and the town of Dresden and Lincoln County. I thank you for the opportunity to speak in support of LD 1959, an act to ensure transmission and distribution utility accountability. For years, this committee has heard testimony from Maine people and businesses about their frustrations with Maine's electric transmission and distribution utilities. In response, we've worked on piecemeal fixes to address issues with billing, arrearages, disconnection notices, and more. We've also considered bigger systemic changes, but those have not yet been successful. What we have not done is address Mainers' frustration in any comprehensive way, and the cries for action have only grown louder as a result. It is clear that Maine people are at a breaking point. They've been handing over their hard-earned money in increasing quantities, and in return, they've received poor customer service and what feel like empty promises. Mainers are demanding more accountability from their electric utilities and they're demanding it now. This bill lays out concrete steps we can take to make T&D utilities more accountable to Maine's people immediately. Using tools ranging from quarterly performance report cards and penalties for poor service to increased protections for whistleblowers and others who want to speak out, this makes sure that utilities are being honest with Mainers and putting service to them, not to profits, first. Our utilities must not only be accountable to the Maine people of today, but to the Maine people of the future as well. I'm glad that this bill includes provisions that require T&D utilities to plan for climate change and the effect it will have on their ability to continue providing Mainers with needed electricity. This committee has done great work in recent years to modernize our grid and prepare for the changing climate, and the utilities must be a partner in this planning. Electricity is not a luxury. It is an absolute necessity that every Maine family, senior, student, and business relies on. Maine's electric utilities have a tremendous responsibility to Mainers, as does the legislature. Today, fulfilling our responsibility to Maine people means ensuring that our utilities are fulfilling theirs as well. I'm looking forward to working alongside all of you to make sure that we do just that. Thank you, Mr. Chair, and I'd be happy to try to answer any questions, but again, others who follow may be able to provide more detailed responses.
I think we do have one question. Representative Sachs.
Thank you, Mr. Chair, and thank you, Senator, for your testimony this morning. I'm asking you as opposed to Senator Brenner because you've been served on this committee, and I am wondering how the provision around penalties for T&Ds who do not meet certain metrics for customer service. My understanding is the PUC has that ability, in fact, just rescinded some of those penalties because they felt like customer service had improved, and they did that recently. How does this bill change their current power or strengthen it or anything along those lines?
Thank you, Representative. That's a great question. One, I'm not sure I can answer in any detail. I think you're correct. The PUC does have certain powers currently to levy fines for various infractions. I think the intention here is to strengthen that and to put it in the context of a failure to meet performance standards specifically.
Thanks. And
but
I
you
did
may want to pose that question to others.
Right. And I did read their testimony coming, so I'll be looking forward to foreshadowing, going to be asking that question. Thank you.
Good move.
Any other questions for Senator Vitelli? And I apologize, my dog, to the public, my dog has been through surgery a week and a half ago, and he's very needy right now. So you'll occasionally see his nose appear on the screen when he needs some attention. Okay, I'm looking at the bill. I know I had heard Speaker Fecto may want to testify on this, but I do not see him in the attendees list. Is he not there? Is that right, Jason?
I do not see him here.
Okay. If he does come, we'll make special provisions to get him through and get him back to his business so he doesn't have to wait through all our testimony. So having done that, we've heard from all the sponsors and the co-sponsors, and we'll now go on to proponents. And I will just remind everybody again about the 3-minute rule, and please summarize your testimony and submit additional information in writing. So I'll recognize to start off, excuse me, Dan Burgess from the Governor's Energy Office. Dan, why don't you bring him over? The next one will be, excuse me, Tony Buxton from IECG, and then followed by Beth Ahern. Good to see you, Dan. Why don't you go ahead?
Great. Good morning, Senator Lawrence, Representative Barry, and members of the Joint Standing Committee on Energy, Utilities, and Technology. My name is Dan Burgess, and I'm Director of the Governor's Energy Office, and I'm here to testify in support of LD 1959. Governor Mills presents this legislation with bipartisan sponsor support to significantly reform and strengthen the state's approach to the oversight and accountability of Maine's electric utilities, protecting the interests of Maine ratepayers, improving the operation and service of Maine's electric utilities, and increasing oversight and accountability. As Governor Mills noted last session, we are well beyond the point of debating whether our utilities can do better. They can and they must. Our utilities, which are granted a monopoly over the vital service of delivering electricity to main consumers large and small, must provide the high quality, reliable, efficient, and competent service that Maine citizens and businesses expect and deserve. As Governor Mills noted, Maine's electric utilities have demonstrated a need for improvement in their provided services to Maine people and businesses. From service reliability, responses to customer complaints, and accuracy of billing and interconnection and service restoration, it is vital that we hold our utilities accountable to a quality of service that Maine people deserve. This legislation provides for that accountability and transparency now. This is achieved through a requirement that the Maine PUC establish minimum standards of service that utilities must deliver for Maine ratepayers. The legislation empowers the PUC with enhanced authority and direction from the legislature to crack down on utilities that do not meet these standards by imposing harsher penalties. To the earlier question, it is a doubling of the penalty from $500,000 to $1 million and or 5% of revenue to 10% of revenue. Imposing those harsher penalties and even forcing the sale of the utility for inadequate service. We must have confidence in our utilities to provide safe, reliable, and affordable service, as well as being a partner in meeting Maine's clean energy and climate goals. This proposed legislation would aid in providing additional tools to the PUC's oversight and require a higher standard of performance, or else face those financial penalties or forced divestiture. Legislation does this in 5 key ways, and I won't read through them. Happy to provide them. And this was written. Legislation was written closely with the new public advocate, and so look forward to having his testimony and assistance answering any questions you may have. But it requires new quarterly service reports and imposes those harsher penalties. So it requires the PUC to set minimum standards for safe, reasonable, and adequate service to Maine customers, and then to issue quarterly reports on whether a utility is meeting those standards. There are not increased incentives for meeting minimum standards, but minimum standards that must be met. These reports will address key areas of utility operations, customer service, such as billing, and initiatives to combat climate change, such as interconnecting renewable projects. If these quarterly reports determine that a utility is consistently failing to meet the standard, then again, they will impose a new harsher penalty of up to $1 million or 10% of the utility's revenue. New approach also establishes an ongoing system that is transparent to Maine people in a way that is not done today, and provides direction to the PUC for additional accountability mechanisms. Again, the second piece is forced divestiture. Legislation establishes a process under which the PUC determines if an electric utility is unfit to provide safe, adequate, and reliable service at just and reasonable rates. If the PUC determines that the sale of the utility is necessary to protect the interests of ratepayers, it will then invite bids from qualified bidders and select the purchase proposal that provides the most benefit to customers. Legislation also stipulates that if the PUC were to invite bids, it must also consider a bid to create a consumer-owned quasi-municipal corporation for the purposes of purchasing the utility. And it creates a mechanism whereby the PUC could evaluate whether investor-owned utility or consumer-owned utility is in the best interest of the state. Third is the legislation provides for new periodic financial audits. If T&D utilities have gone more than 5 years without a rate case, the legislation requires the utility to make a filing with the PUC comparing its actual expenses to the estimates used in previous rate cases. If there is a discrepancy greater than 10%, PUC may conduct a financial audit. Fourth, it strengthens whistleblower protections, as was mentioned previously, which protects utility employees from retaliation of discrimination by the utility, such as termination of employment, if the employee testifies before the legislature or provides information to the PUC regarding utility operations. Finally, number 5, it improves the ability of utilities to prepare for and respond to climate change. So legislation requires T&D utilities to submit every 2 years to the PUC a 10-year plan for protecting utilities' assets and operations from the expected impacts of climate change. The first time in Maine's history that a report of this manner would be required of our utilities. The PUC would then review the plan with input from stakeholders and may order the utility to take necessary action to protect the Maine ratepayers. This new process ensures that the utilities are prepared as much as possible to reasonably possible worsening storms, flooding, fires, or other climate-related catastrophes. So to conclude, regardless of the structure of the utilities, Maine people deserve to know that the utilities are providing safe, reliable, and affordable service This legislation makes necessary changes to ensure our utilities are held accountable for the quality of that service and not at now and not at some distant point in the future, and allows for serious financial penalties for non-compliance. Maine people must have confidence that their utilities are being held accountable, and I urge you to support this legislation. Thank you for your consideration. I'm happy to take any questions.
Thank you, Dan. And I know both you and the public advocate were involved in drafting the legislation. We do have the public advocate up next to try to get the technical questions answered. But are you prepared to answer Representative Sachs' question, or do you want to defer to Bill Harwood?
Oh, sure. I tried to note it generally, but the current penalties that are required of the PUC are $500,000 or 5% of utility revenue. And this legislation increases the ability of the PUC to $1 million per penalty or 10% of the utilities revenue, no more than 10% of the utilities revenue. So it is an increase in the PUC's ability or the amount that can be penalized.
Representative Sachs, did you want to follow up on your question?
Thank you, Mr. Chair. And I have several, but I'll start with that one, Mr. Burgess, is what is their insulation? I've heard the word affordability several times in this, and this will be a theme throughout my questions about how this is actually going to help affordability. And so is there any guarantee that, given the fact that this is an investor-owned model, and this is not to debate whether COU versus IOU, but to state how is it that those penalties will then not be shifted onto ratepayers because they are facing less profits for their shareholders?
Thanks for the question, Representative. I mean, the legislation would have those penalties come from shareholders and not from ratepayers. And I think that there's a system in place through the Public Utilities Commission to make sure that that happens. They review any rate increase or approval, or a proposal to be approved very closely. And I think those penalties, as you've seen from the ones you've mentioned previously, are clearly coming from shareholders and not ratepayers. So there's a system in place to do that.
Okay, thank you. And Mr. Chair, may I continue on with my question?
Yes, go ahead.
Thank you. I also am wondering, how would you see this? The only place I heard you talk about affordability is because of this new 10-year climate action plan that is a little short on specifics at the moment. Can you elucidate about or let me know a little bit more information about that?
Thanks, Representative. Just to clarify, more information about the climate plan or about costs, or
about how the climate plan will increase or assure affordability of rates.
Okay, thanks,
that was your testimony, I believe.
Currently, there is not a system in place for which the utilities are required to report anything related to their overall climate preparedness. And so as we look at the daily impacts of climate change from forest fires out west to flooding to the recent report from the National Ocean from NOAA, there are impacts that are already going to be baked in related to climate change, sea level rise, increased and more intense storms. And so this reporting requirement will be the first look at our utilities' physical operations of where they might be vulnerable. And I think that requires planning to happen as a result of those 2-year plans. For example, just in the paper a week or two ago, when utility regulation was being discussed, the substation in Bath that flooded in 2015 was highlighted as being a significant incident and one that required additional resiliency. And so we should be looking at those now to ensure that we're dealing with those issues now, not when they have impacts on the costs and service of our electric utilities.
Okay, and so my final question.
Go ahead.
Thank you. Did I miss any other pieces around affordability in your testimony about how this bill would assure affordability?
Thanks, Representative. I did try to keep my testimony to the allotted time, though I may have gone over. And I think there is a few different things in here related to rates and costs. I think, overall, I think it's just really important to understand the reason that rates have gone up on the supply side. We are seeing, as a result of our over-reliance on the New England region's over-reliance on natural gas, we are seeing price increases or rate increases as a result of natural gas prices going up. Natural gas sets the price for electricity in New England, and we are susceptible to that because we're over-reliant as a region on natural gas. This legislation does address or provide for opportunities to address rates. I think first and foremost, the financial audits is an increased look at the operations of a utility. The climate preparedness piece, I think, is an important piece to look at the long-term system. And then the whistleblower protections allows for increased protections for whistleblowers. And so I think there are a few ways at which rates are addressed here. Obviously, we have the overall over-reliance on natural gas, the opportunity to add more cheap, clean energy resources continues to be a part of the opportunity. And then I would also say that the opportunity to adjust programs and tweak them as we move forward, I think, continues to be there. And so this bill is, I think, it does provide some focus on rates, but then there are also other opportunities as well.
Representative Sachs, any follow-up?
Can I just point out, this bill doesn't have anything to do with the supply side of natural gas rates. I understand that you wanted to talk about that, but this bill doesn't have anything to do with that, correct?
Thanks, Representative. No, I just wanted to point out the reasoning for the increased costs that we're seeing on the delivery side that are being experienced.
Totally get that. I'm trying to focus on the bill. Thank you, Mr. Burgess. I appreciate that.
Thanks, Representative.
Representative Barry, you had a question?
Sorry about that. I was muted. I do thank you, Mr. Chair. I have a series of what I hope are short questions, if I may. And Director Burgess, thank you for your testimony. And I just wanted to ask up front if it's true that there is an interest in further amending and adjusting the bill from the governor.
Chairman Barry, I think that we've heard from a number of different entities, a variety of interests who have put forward potential changes to the legislation. I think there could be improvements made, and I think there's an openness to work on legislation to make it better. That being said, I think it'll also be a balance of this committee and of my office and the public advocate to look at how broad the changes would be. But I think there's definitely a willingness to improve if there would be changes that would do that.
Thank you.
Representative Barry, I'm going to ask you, just continue with your questions. I have to step out. The medication for my dog has certain effects on his need to go outside. So I'm going to stop my video and allow you to ask your questions. And I will keep him outside and have him take care of himself.
Okay, thank you, Senator. So, Director Burgess, affordability just came up. I think we can all agree that this is about the delivery side of the bill, not the supply side. And we all understand that delivery has been a major cost driver. In fact, when I started on the committee in 2007, it was much less than half of the bill. It is now typically more than half the bill. And if we're not for the sort of one-time spike in natural gas, I think it's temporary, we would still see it as more than half the bill. It went up by 13% for CMP customers in August. It went up by 17% and 17.5% for Versant customers in November. That's 2 to 2.5 times the rate of inflation. Is the governor willing to make affordability one of the standards by which our utilities are judged?
Thanks, Representative. Without Chairman Lawrence here, I'm just going to go ahead and answer, and I hope that's okay. I think the affordability of rates, and I'll just say, our office is also paying very close attention to the affordability of delivered fuels and energy costs are having on Maine residents and businesses broadly. I think we're very concerned about the impact of these increased rates. I think that the increases that you mentioned, I think it's also worth clarifying that those were increases passed on to, if we're talking about the same ones, that were passed on to Maine ratepayers as a result of federal requirements that for reliability that ISO New England passed on, and so those were merely, if we're talking about the same ones, passed on as a result of requirements from the regional grid operator. So clearly concerned about affordability and rates. It's a complicated issue that we work very closely with the Public Advocate's Office and Utilities Commission, and Chairman Bartlett is our representative for the New England States Committee on Electricity. It's a complicated issue when it comes to working with ISO New England and the other states, but clearly concerned about rate impacts and affordability.
Thank you. And I think, sorry, there seems to be an echo. I think you're right that the federally regulated transmission component is a big cost driver, and was the reason for this 13% CMP rate increase. But let's remember that storm restoration costs were deferred until next year. So those are still, that increase is still coming, presumably, on the distribution side. And for Versant, I think it was not related to federal decisions in that instance, at least not exclusively. But affordability becoming a standard would be helpful. I don't really see it elsewhere in the bill. I want to shift to climate and ask about the climate component, because that's been talked about already today considerably. The only climate provision I see here is to require utilities to protect their own assets. And I wonder if something additional, perhaps as a standard for the report card, would be amenable, if the governor would be amenable to that.
Thanks, Representative Berry. I think the standards that are put forward, the 5, are getting a little feedback. Can you hear me?
Yeah.
Okay. The standards that are required, one of them is interconnection to renewable projects, and so I do want to note that. But if there are improvements to those standards or to the climate plan as discussed, I'm happy to look at what those might be.
That's great. A major cost driver, Dr. Burgess, for our utilities is capital expenditures. That's the profit center under the Bluefield decision by the United States Supreme Court 100 years ago. Capital expenditures are what drive profits. And so when we talk about affordability, we have to acknowledge that we are bound, as policymakers, as regulators, we are bound by the Bluefield standard. Capital expenditures are the determining factor. And we must compensate those at a high level of profit, typically 10 to 12%. So if that being the case, our regulators have to look for imprudence. And if they find imprudence, they can disallow expenditures. If they don't, then they go into our rates with the profit. So what can be done under the whistleblower provision to provide that someone who is reporting imprudence is protected, because that's not in the bill at present?
Thanks, Representative. I think I'm happy to talk with you and others that are interested in that piece a little bit more. As not an attorney or an expert in kind of the whistleblowing piece, I do want to be careful about that. But a public advocate may have more to say on that as well. But if there are improvements, then happy to talk more.
Great, thank you.
Anything
And just a
further?
final question is, there's I think we all agree that there's a need for greater public accountability to the public in our public utility system. And I'm wondering if you contemplate any changes to bring the public in more on the decisions that are made as envisioned in this bill.
Thanks, Representative. I think what the bill directs is, for the first time, that I'm aware of, very clear and transparent reporting of metrics that the public can understand without having to read a couple 100-page docket from the Public Utilities Commission. I think that's a really significant piece of this, is providing that transparency to Maine people and businesses. And if there's a way to improve connectivity to that process or engagement in that process, I think, I don't want to speak for the Utilities Commission. I think they've been working hard on how to reach the public, but happy to talk through more of that if there are ideas.
Thank you. And I think my question was clumsy. I was referring more to decision making and involving the public in a more meaningful way in decisions that are made with respect to our energy future.
Thanks, Representative. Always happy to hear ideas on that point. So it's a key one, and happy to talk more about that.
Any other questions from the committee for Mr. Burgess? Representative Grochowski?
Thank you, Mr. Chair, and thank you, Director Burgess, for being here with us this morning. I just had, I think, two questions, one of which came from your last answer where you talked about the quarterly scorecards providing transparency. The way that I read it, we're just going to get an a quantitative score. I don't know if it'd be a letter or a number, but it's not clear to me that there's any requirement that the justification for that score be made public. Is that, and I think it would be buried within some sort of docket, and it would be quarterly, which would, quite frankly, I think, overwhelm most of us, including the PUC. But, are you open to having that scorecard include the actual, justification for an average person to read about why the utility received the score they received? So I think that would increase transparency.
Representative, thanks for the question. Yes, I think the answer is yes. I think that in some way through the process, if a utility were to get a failing grade, they'd want it known why it was failing and what could be done to improve it. And I think the public would as well. And on the flip side, if they were getting a high level passing grade, others that are unhappy with the service would want to know why as well. And so I think the plan, the purpose here is to provide that increased transparency and in a way that is accessible to Maine people and businesses. And I don't want to speak for the Utilities Commission. They do some regular reporting related to some of the metrics that have been out there before. And so I think, happy to discuss quarterly. I think it's something they likely could do, but would be worth talking to the PUC about that.
Any follow-up, Representative Grochowski?
Yes, and thank you for the opportunity. I appreciate that, Director Burgess. I think there's definitely room for improvement in a couple, more than a couple areas in this bill, and that is just one that came to mind. One of the things that I'm struggling with this bill, and I've tried to review all the testimony that was already submitted as of late last night. What is the policy design basis for the components of the bill, especially the first section, that can help us understand what positive effect this will have on our constituents? It seems like a really nice list of things that we care about, but I mean, was there a consideration of what's happening in other jurisdictions, what's working, what's not working? I'm just not sure the evidence that exists that this policy will have a positive effect for our constituents.
Thanks, Representative. I think as I tried to lay out in the testimony that this really does provide direction from the legislature to the Utilities Commission to set baseline performance standards for utility operations. And I think the 6 categories picked in there are the ones that we felt were the most appropriate, looking at how other states regulate their utilities. Many of them, again, provide incentives for good behavior. And what we've done in this bill is set a minimum standard for behavior that, if not met, will lead to penalties. And I think from looking to how to explain this, it is really about setting the minimum bar and providing transparency for Maine ratepayers to understand how their utilities are doing when it comes to service.
I may just
follow-up,
follow up to
Representative
that.
Grabowski?
Yeah, thank you. I appreciate hearing that you and other policy people who design this policy looked at other states. It would be super helpful for me, at least, if we could get some sort of, maybe just a chart comparing what's happening in other states and evidence that it's working. It's one thing to look at a policy that another state has. It's a second thing to see what the effect of that policy is. And I think this is so important to Maine people that we do something meaningful, that I would really want to know that there's evidence that this is going to make a difference, so that my constituents will see a positive outcome and not just say, oh, look, it's more government doing stuff to say they're doing stuff. And I'm not saying that's what this is, but I would just like the evidence that it is indeed going to have an effect. Thank you.
Thanks, Representative. Happy to provide that with another follow-up.
Are you all set, Representative Grabowski? Okay, Representative Foster.
Thank you, Mr. Chair, and thank you, Director Burgess. Your testimony, you said a mouthful, and I'm wondering, I didn't find it fair for this on the drop. I'm wondering if you have that written testimony, you can get it to the clerk so we can look at it as we continue work on this bill. Thanks.
Thanks, Representative. I was not out ice fishing, but you and I appear to have caught the same cold. So testimony was submitted this morning, and we'll make sure it does get to you on writing, and then obviously happy to answer any questions that you have between the work session.
Any follow-up, Representative Foster?
No, thank you.
Seeing none, thank you. Any other questions for Director Burgess? Seeing none, thank you. We'll go on to our public advocate, William Harwood.
Good morning. Thank you. Senator Lawrence, Representative Berry, distinguished members of the committee. My name is William Harwood. I'm here as the public advocate this morning to testify in strong support of LD 1959. I was honored to work on this proposal with the governor and the governor's energy office, and I applaud her for her foresight in bringing forward this important legislation. The bill strengthens electric utility regulation in Maine by filling in some glaring gaps in the statutes regulating Maine utilities. As public advocate, I welcome these new provisions and urge the legislature to adopt them so that the OPA can use them to better serve and protect Maine ratepayers. 1959 will enhance the PUC regulation of the state's utilities in 5 discrete areas: quarterly reports and related penalties for inadequate service, enhanced financial audits, increased whistleblower protections, a process to determine if a T&D utility is unfit to serve, and finally, climate change response and preparedness. I want to address each of these separately, but it is important to recognize that the combined impact of all 5 elements of the bill will provide greater accountability and greater ratepayer protection against high rates or poor service. I'm going to skip reading the rest of my testimony. I think the previous proponents have done a nice job of laying it out. I'll simply conclude by saying this proposal has already garnered bipartisan support in the legislature and has received the endorsement of multiple environmental organizations. Mainers are struggling right now with rising cost of their electric bills this winter, and the time to act on this is now. We must ensure that electric customers are not being taken advantage of by unchecked utilities, and this bill gives the PUC the tools to do so. Thank you for your time and attention. I look forward to working with you and will be available for the work session.
Are there any questions from the committee for the public advocate? Representative Berry.
Thank you, Mr. Chair, and thank you, Mr. Public Advocate, for your testimony and for the work you're already doing. You've hit the ground running. I want to ask in particular about the question of imprudence. As you know very well, as a longtime utility lawyer, the financial incentives, the logical corporate behavior is to improve capital expenditures. That's where the profit center is because of the Bluefield decision by the United States Supreme Court 100 years ago. The whistleblower provision as drafted does not deal with the problem of whether it's contractors or their employees or utility employees being too afraid to come forward and report imprudent or potentially imprudent expenditures on the part of the utilities, which, if not discovered as imprudent, are put into our rates with a built-in return on equity, typically double digits, for the investors in those utilities. Are you and is your office willing to work with the committee on further amending this bill to protect employees or contractors, or for that matter, employees of contractors who see something and would like to say something?
Absolutely. I'm glad you, Representative Berry, I'm glad you pointed out the whistleblower protection. I think this may be one of the most important pieces of this. So maybe this is the sleeper piece of this bill. I am very confident that the whistleblower protection, additional protections in this bill will lead to future whistleblowers, and that will help us control costs. I'm a little puzzled by the issue of imprudence, because I would assume that any whistleblower with any information related to the activities and operations of a utility could easily include imprudence. And I think that we will see people coming forward. I can tell you I've been in this job now just 3 weeks, and I already have one whistleblower who I'm working with. And it was interesting to me when I asked her if she would be willing to let me use her name. She declined and said, I don't want my life turned upside down. Now, I would hope that this strengthening of the whistleblower protection law would allow me to go back and say, can we discuss ways that you might be willing to come forward and share your information? But this is something that I think is real. It gets to affordability, it gets to imprudence, and I can assure you that my office will be looking for any evidence of imprudence on any future utility rate case where we can disallow costs that shouldn't be passed on. And I also think the financial audit piece of this is another way in which, outside of a rate case, the PUC financial team can go in and look at the books and records of CMP and Versant, and they may spot areas where there is potential imprudence that needs follow-up in a future rate case.
Any follow-up, Representative Berry?
Thank you. So Mr. Harwood, for the work session, maybe you could just help us understand the reading that I had of the bill was primarily that the whistleblower protections were for potentially illegal activity on the part of the utility. So if you can help us to just be absolutely certain that imprudence is protected, reporting potential imprudence is protected, that would be great. And secondarily, I believe that employees of contractors are often the people who are most well aware, and I do not see their any protections for them in this bill.
Yeah, good, 2 points. The existing law talks about any information related to the utility. There are many whistleblower statutes that are triggered off illegality. The existing law, although unfortunately weak, does talk about any information related to the utility. So I don't think we're there. With respect to your second question, I think this is an important discussion that we should have with this committee. At this point, the bill did not include employees of contractors of utilities. Those contractors are not regulated by the PUC, and it was decided that at this point, going and adjusting the employer-employee relationship of a business that may do very little business with CMP or Versant, maybe they plow the driveway, maybe they maintain the printers in the office, and to get inside their organization and regulate the relationship with an employer-employee struck me as maybe going too far, but obviously it will be up to you and the committee to make that call, and I look forward to discussing that with you further.
Thank you.
Any
And
follow-up, Representative Berry?
I appreciate that answer, and perhaps for the work session, you could advise us on contractors who do most of their work, if not all of their work, for the utilities. So they're really, if an employee were to come forward, they could potentially lose the entire business because so much of their revenue depends on the one utility or two utilities that they work with. So that can be for the work session, and thank you for the answers.
Representative Sachs.
Thank you, Mr. Chair. Good morning, Mr. Harwood. Nice to see you again.
Good morning.
I did read your testimony, and I see that the section around the PUC forcing the sale of a utility not living up to its statutory duties is already in statute. I understand you worked on this legislation, and you're saying that hopefully by expanding it, the protective effect of the law will be strengthened. Can you help me understand what it will be different about this? For me, when I read your testimony and the bill, it feels like there's just a process outlined, which doesn't necessarily strengthen the law. Can you elaborate on that just a wee bit, please? Thank you.
Sure. Yes, that law has been in effect for many, many years. It has never been used, but I think it is valuable. I think it has a prophylactic effect. It sort of reminds the utilities that if they don't live up to their statutory standards, this is a consequence, albeit a dramatic consequence. The PUC has never had to use it. Hopefully it will never have to use it, but it's important that it be there. Now, this strengthens it, as you say, by the process. It lays out a more detailed process, which I think gives the utilities additional pause. It also introduces this concept of whether a consumer-owned utility or an investor-owned utility will be better. If the PUC gets to the point where the existing utility is no longer doing its job, then it will look for others to come forward to purchase the utility. And where we've made a significant substantive change is to put in place a system in which a 5-person committee would present an alternative purchaser, namely a consumer-owned utility. So I think that's further strengthens this statute.
Any follow-up to that, Representative Sachs?
Just one, Mr. Harwood, why do you think that and again, I'm drawing on your years of experience in this field of saying, given the fact of the absolute deluge of information that these two utilities have underperformed, and I'm just saying that from a factual basis, why has the PUC not, and would they ever truly, a 5-person appointed body, ever make that decision, such a drastic decision? Why do you think they have not so far?
Well, that's because the 3-person commission is the one who hasn't done it so far. The 5-person committee I referred to is the one who would present the alternative for a consumer-owned utility. I think that this is a dramatic remedy. This is the shotgun behind the door that you hope never has to be used, but it's there if you need it. I can't say exactly why the commissioners have never had to use it. It does have a number of complicated pieces to it to figure out how to go about divesting the utility. And what we've tried to do is put a little flesh on the bones so that this committee and the legislature can give the PUC guidance should it be needed. But I can only assume that in the past, the PUC has decided that penalties should be sufficient to get the utility management's attention to reform its ways, and it didn't need to go to this extreme remedy.
Thank you, Mr. Harwood.
Are you all set, Representative Sachs? Thank you. Representative Foster?
Thank you, Mr. Chair. Thank you, Public Advocate Howard, for your testimony. I'm just wondering, to follow up on a bit on Representative Sachs' questions. If you could, are there some of these proposals, and looking at your testimony, you've kind of ticked off the items that you see are very important. Are there any of these that the PUC doesn't have the ability to handle now that you see this bill? And you've already talked about a couple of them, but for example, the ability to levy larger penalty finding As I understand it, they have, within the last year or so here, they did levy a $1 million levy fine. And so I obviously they can go above the limit that this bill proposes to raise. So that's the kind of thing I'm looking at. Is there really anything here that the PUC, either through statute, current statute, or rulemaking, can't address that you feel is very important with this bill? Thank you.
Thank you, Representative Foster. I'd first point out the whistleblower. As I said, the whistleblower is one of the more important parts, and there is a number of changes to strengthen that. That is something the PUC couldn't do on its own. The penalties is more interesting. What the PUC has done in the past is, in the middle of rate cases, they have looked at the efficiency of the utility, and they have created something called a management efficiency adjustment to the return on equity. And it's a mouthful. I'm not sure that many of the ratepayers I represent or the constituents you represent can really understand what a management efficiency adjustment to the return on equity is. It's buried in a document that's usually more than 100 pages long and has lots of detail and analysis about why a rate should go up. Typically, the media will report that, the utilities rates are going up 8.6% or 9.7%, and then buried down in the article will be a management efficiency adjustment to account for poor service. What we're proposing with this bill is that we take this out of the rate case. We have a quarterly report card, and if it is unsatisfactory, they go directly to an administrative penalty. What I envision coming out of this is the headline will not be CMP or Versant's rates raised 9%. The headline will be CMP or Versant penalized for X million dollars for poor service. That will get their attention. That will focus on this. So I think it is a very substantive, different approach to this by doing a quarterly report card and having the administrative penalties hanging over that report card. It is as simple as, if you don't get your homework in every week, you're not going to get it allowed to go out for recess next week. That is the cause and effect that we're trying to get, rather than having it buried in one of these massive rate case proceedings.
Representative Foster, any follow-up?
No, thank you.
Representative Grochowski?
Thank you, Mr. Chair, and thank you for being here. Mr. Public Advocate is maybe the right phrase. I'm trying to wrap my head around exactly who is going to influence the process of creating the standards. So if the legislature says to the Public Utilities Commission, we'd like you to create standards on these general topics, which I believe they already have the authority to do, but we're now saying you shall do this. I've attended a couple proceedings at the Public Utilities Commission, and I find that it is largely staffed or stocked with utility lawyers. So how can we be sure that these standards are going to really be strong and really benefit main ratepayers, as opposed to being carefully crafted by the utilities and the sort of national utility interest groups like that Edison Electric Institute, for instance? I think it was mentioned in one of the testimonies. It's just really not clear to me that we're doing anything but sheltering what should be a public process in a place where the public has very little access or ability to influence the outcome. So I just wonder if you can comment on how you see that unfolding and what we could do to improve public participation in this really important process.
Thank you, Representative Grochowski, and it's a great question. I've been thinking a lot about it for the last few weeks. First, this will be a rulemaking proceeding, so it's a little bit more user-friendly than what you may be thinking of with an adjudicatory proceeding. But your point is well taken. There is an element of a closed club that handles most of the litigation before the PUC. We tend to have our own verbiage, our own management efficiency adjustment. We tend to come up with our own terminology, and it makes it very difficult for outsiders to understand, much less participate. And it's something that as public advocate, I'm going to be working hard on. Our office is getting a lot of calls, very frustrated customers with high rates. And I want to find a way for their voice to be heard, for them to participate should they want to do so. I've got some ideas that we are working on, and I look forward to sharing with you down the road. But the important thing is we have got to make sure that this group of very well-intentioned, smart, hardworking folks who tend to be the usual suspects who show up when the PUC opens a hearing are not the only voices that the PUC hears.
Representative Grochowski, any follow-up?
I would just say I really look forward to hearing those ideas. Even in rulemakings that I've been involved in outside the agency, I noticed that it is hard for the public to engage. And so I think the legislative process is really important for that reason, because we already represent a subset of all citizens of the state of Maine. And I think a hearing like we're having today is to determine some of these details is more in line with allowing public participation. But and maybe there's some ideas from how we do legislative hearings and things that could apply. So thank you for thinking.
Representative Ziegler.
Yes, good morning, and thanks for being here. And maybe I missed this, but in making up of the commission, it seems like you have a majority that would be influenced by the present administration of this. My cat's attacking my leg, excuse me. Why did you decide a 3-2, and why is there no, just between the you and the whoever be the president governor to make up that commission?
Yeah, this 5-person committee that is going to be charged with the responsibility of presenting the alternative consumer-owned utility. Look, I have no vested interest in having what my role should be. I think this is something that we could discuss, changing the makeup or expanding it. The idea was to have not just have one person appoint all 5, but to have different people, some of whom have some term limits that may make them less susceptible to swings in partisan voting. And that was really the idea. But I think there's any number of ways to make sure that that 5-person committee represents the public interest, and as they go about putting together that proposal.
Representative Ziegler, any follow-up?
No, thank you.
Representative Carlo.
Thank you, Mr. Chair, and thank you, Mr. Harward, for your testimony this morning. Just to perhaps put a finer point on Representative Grochowski's question, my question to you is going to be very simple. What would your view be on changing in section 1 of the bill, the rulemaking from being routine technical to major substantive?
Yeah, I think that's something for the committee to discuss. I don't feel strongly. I do want to make sure that this process moves along. I think the time to act is now, and I would hope that the PUC would be able to act and implement this as soon as reasonably possible. So I think the thought was to streamline it a bit, but if the judgment of the committee is that it should be major substantive, I don't disagree.
Any follow-up, Representative Carlo? Okay.
No.
Any other questions for the public advocate? Okay, seeing
Thank you.
none, just to focus on where we're at. It's about 10:20. We will be taking a break shortly, our 15-minute break. We've been at this almost about an hour now. So I am going to be shifting back over to, after we hear from the next 2 people, I am going to be shifting over to opponents and going through that process. And to let the committee know, we have about 50 people who want to testify on this bill. So assuming the 3-minute rule and no questions from any committee members, that would take us 2.5 hours to get through those 50 people. So I'd ask committee members to keep that in mind when asking your questions. And what you can get at a work session, please do get at a work session. And we also have another bill after this. So with that, I'll recognize Tony Buxton from the IECG.
Thank you, Senator Lawrence. Representative Berry, members of the committee, I'm Tony Buxton from Pretty Flaherty. I live in Stroudwater, Maine, obeying your rule. And I'm here to testify on behalf of the Industrial Energy Consumer Group in support of this legislation. This legislation is an intensification of existing authority that the commission has, and it is also an intensification of your reliance on the commission, which was established in 1913 for the very purpose of controlling entities to which we grant monopolies. The IECG is composed of ratepayers, and our testimony today focuses on issues that some of you have already raised, which is the importance of this legislation, in addition to what it focuses on already, focusing much more intently on cost. We are in a moment where cost consciousness is high, as you know. Our members, just like you and your constituents, are suffering. And for this legislation not to focus on cost would be both a missed opportunity and an indication of a lack of focus on cost. It is interesting, for example, that this legislation does require reports on the ability of the utilities and their success in interconnecting renewable energy projects. Presumably, this is just one more effort to help net energy billing developers. The state's grant of monopoly, however, is based on accountability to the people who pay the bills, not net energy billing developers. We ask that you amend this bill to require reporting by the utilities on their advocacy for lowering costs for consumers, consistent with Section 101 of Title 35A, which you have amended to require the commission to focus on that as well. This would not include violating their fiduciary obligation to their shareholders, but there are many instances where the utilities can and sometimes do advocate for measures at ISO New England, NEPOOL, and FERC, and in Congress that can reduce costs. We've attached such an amendment. We note, for example, that CMP and Versant, unfortunately, in our view, went AWOL on net energy billing in 2019 and have yet to return to duty. We urge you to make clear in this legislation that monopoly utilities have a duty to advise you and the commission and to advocate wherever they can for lowering costs for ratepayers consistent with law. This does not mean they would be obligated to oppose climate initiatives, for example, but it would mean they would be obligated to support climate initiatives, supporting state law, which are the biggest bang for the buck, that is the lowest reasonable cost. Secondly, we urge you to take other utilities, the small utilities and the CEPs, the competitive energy providers, out of the bill. There isn't a problem there to be fixed, and that's just extra work for the commission. Lastly, we would be concerned that you are burdening the commission enormously and unnecessarily. These reviews may be best done annually or semi-annually, not quarterly. It's hard enough for consumers, as some of you have mentioned, to participate at the commission, and starting a quarterly Olympic event on utility accountability is going to make it much more difficult, not only on the public advocate and the staff at the commission, but also on consumers who want to participate. Thank you. I'd be glad to answer any questions.
I have to find myself on the screen to unmute myself. Are there questions from the committee for Mr. Buxton? Representative Foster.
Thank you, Mr. Chair, and thank you, Mr. Buxton, for being here. So you mentioned in your written testimony, and again here verbally, about the IOUs being AWOL when the discussion around net energy billing came about. When ratepayers and my constituents, when I've talked with them about net energy billing and the effect it has and will have on their electric rates, I have taken the position that the utilities, specifically CMP and Versant, have kind of had to stay in the background, if you will, because they need to be seen, or at least this is my opinion, that I feel that they need to be seen as supporting these green energy initiatives and not warning against them, if you will. So my question would be, number one, what do you think that they could have done, should have done, to warn this committee and others as they obviously looked at the net energy billing bill and bills that we've handled on this committee, and how do you see them going forward if this bill were to become law?
Thank you, Representative. I'm going to answer this not to find fault, but to use it as an example of what I think Representative Sachs and others are getting to, which is how do we change this system so that it reduces costs rather than increases it? Here's an example. This legislation gave no authority whatsoever to the commission. It's the first energy program I'm aware of in Maine's history that never gave any authority to the commission. That's the first big mistake. Okay, you're reversing that now, which is good. But you're not doing it on net energy billing, but you're doing it on the performance of the utilities. Secondly, there is no way that even Mr. Harwood or the commission will ever know as much about the utilities as they know about themselves. So we need them to give us information. Part of your bill is about that, but we need it even more than that. For example, when the utilities looked at net energy billing, in our view, they had an obligation to say, hey, wait a minute, you're using the distribution grid for something it wasn't intended to be used for, and that's going to have consequences. Secondly, we don't know how many people are going to use this opportunity. They might have looked at Massachusetts and seen just how many there would be, but they didn't because they were afraid of you. It's a simple fact, and your question highlights that. They don't dare, and they have no obligation to speak up on matters such as this. Their natural tendency is to say, it doesn't affect my rate of return, I'll stay out of it. I don't want to make anybody angry. That has to change. They have to have an affirmative obligation to protect consumers because they are in, quite frankly, the best possible position. Their culture really matters. So there's a lot they could do, and there's a lot they could do still, and they need to be encouraged to do that. We recommend that you require them to advocate for lower costs. It wouldn't have hurt their rate of return to say what they knew about net energy billing and what it could do.
Okay, thank you. I allowed a little bit of latitude on that, but I just want to encourage people to focus on this legislation, not on other pieces of legislation that we had before our committee. I understood that question to be, how would we make this accountable in the way Mr. Buxton was talking? But I encourage people not to visit other pieces of legislation that are not part of this legislation. Representative Foster?
Thank you, Mr. Chair, and I apologize for that. I was simply referring to the written testimony. But if I may, Mr. Buxton, in your written testimony, you suggest an amendment, amend section 1, item 5, advocacy in lowering the overall cost of electricity for customers. Do you feel that would put them in a position, the IOUs and or COUs, where that when legislation comes along, that they will be required to present either to this committee, to the PUC, or to the Public Advocate's Office a response or a testimony that would warn them of rate increases for our ratepayers? Do you think that amendment is going to?
I think there may be better ideas, Representative, but this is what we've thought of that would be consistent with their other legal obligations. And frankly, there are instances where this does occur. It needs to happen even more often.
Any follow-up, Representative?
No, thank you.
Okay, Representative Barry?
Thank you, Mr. Chair. Mr. Buxton, very interested in this recommendation you have for amending the bill to require what I take as a duty to report. And in suggesting that, you referenced the history of our regulatory structure, the obligation of the Public Utilities Commission to impose discipline since there is no free market. So I want to characterize that history a little bit more and then ask you a question about it and about your suggestion. So Maine created the Public Utilities Commission in 1915. It was 12 years before that, I think in 1903 or so, where Samuel Insull recommended to the National Electric Lighting Association that the industry needed to create regulatory commissions in order to protect their own monopoly. They then lobbied across the country to create public utility commissions. They successfully did so. And then 7 years later, the Bluefield standard, which rewarded capital expenditures, which I referred to earlier, was created. The commissions were established not to protect ratepayers, though, exclusively, but to balance the interests of ratepayers and the owners of the utilities. So if we were to create a duty to report that said to utilities, you have to speak in a certain way on certain issues, would that not violate their own freedom of speech? Would that not violate their own First Amendment rights? Would that not violate their own fiduciary responsibility to their shareholders to focus on ensuring a strong bottom line, just as your members, the boards of your own members might do?
Thank you, Representative Barry. You make a good point, and that's one I highlighted earlier. The utilities have a fiduciary obligation under the law with which we cannot interfere to seek the health of their owners or a reasonable return to their owners. It is not our conception that this would interfere with that. This would deal with areas on which they could speak, which are not part of their rate of return analysis. For example, legislation that comes before you. What did they say? When did they say it? Yes, they have the right of free speech, right? But they don't have a right to be a utility. If they want to be a utility, they need to protect consumers, right? There's not much point in having utilities that don't protect consumers. There are other alternatives, as you are well aware. So here, there might be instances where they would say, well, we have a constitutional right to say nothing, but that doesn't mean they can take the fifth.
Any follow-up, Representative Barry?
Yes, it's my understanding that the decision by the utilities was made as part of a stipulation that the decision not to testify on net energy billing and the bills that happened at that time. It was made based on a stipulation involving the New England Clean Energy Connect. So I just who's to judge whether a utility in representing its own interests is within bounds or not within bounds? How do we, given the protections, the broad protections of the First Amendment, impose constitutionally a limitation on their speech?
Well, first of all, you're not limiting their speech. You're asking them to report on the speech they've undertaken. You're not telling them what they have to say. If you penalize them for what they don't say, you might get, if the PUC did that, you might get into a free speech question. But that's not what you're doing here. They're being asked to report on what they've done before, and you could even be specific. ISO New England, the New England Power Pool, FERC, Congress, okay? They'll still have their rights, but they need to be conscious of the obligation to protect consumers. That is clearly within the ambit of granting them the monopoly. For example, the monopoly has always said, the grant of the monopoly has always said you must take all comers and you must charge them the same, okay? And that is a fundamental rule from colonial times on, right? It's in the common law, it's in the constitutional law, right? So there are already requirements placed on monopolies. This is not an unreasonable requirement. And if it can't be placed on this monopoly, then it can't be placed on a consumer-owned utility. And I don't think that's true, with all respect, right? I'm sure that someone can argue against that, but I think this can be done. You're asking them to report on what they've done. I mean, there's no better example of the failure, the cost of their failure to speak, than net energy billing. It is the Vietnam of renewable energy in Maine. And the failure to speak is part of that.
Representative Barry, any follow-up?
Yes, Mr. Buxton, if we were to go down that road, we would not only preclude it, I think we can both agree, agreements like the stipulation that led to that approach, but also we might create a slippery slope with respect to, for example, limiting testimony to require that climate be put first, and potentially that expenses be increased for that reason. Is that not the case?
With respect, I'd be happy to discuss this further offline. The answer is we don't believe so. There's a line here. You're not telling them what they have to say. You're asking them, are they protecting ratepayers? And if the purpose of a monopoly grant is not to protect ratepayers, to promote the public interest, frankly, I'd be surprised.
Thank you. Just one last question, very quickly. Are you aware, Mr. Buxton, of any precedent for this kind of restriction on utility speech?
This is another, thank you. I'm not, okay? And the reason is it was common sense and common practice. When the great blackout of the 1960s happened, right? It didn't happen all of a sudden. It rolled up the East Coast, and CMP's management saw it coming, right? And they flipped the switch at Kittery. So Maine did not go dark like the rest of the Northeast, right? They didn't have to do that. There wasn't a statute. It was common sense. It is common sense that a utility would want its ratepayers to be better off than worse off.
Any follow-up, Representative Barry?
Well said. Thank you very much. I enjoyed it.
We have Representative Grochowski and then Representative Wadsworth.
Thank you, Mr. Chair. And I do have a question, but firstly, Mr. Buxton, I just really need to let you know that I'm a daughter of a Vietnam veteran. My father served in Vietnam. He lost a lot of friends in Vietnam and family. And I just ask that you not liken something like net energy billing to something as serious as that was. Again, thank you. My question was, prior to that statement, was how it is that I'm reading this bill differently than you are, I guess, or the component about the report card states that they need to share information about the responsiveness to requests for interconnection by generators. I don't see anything in there that states it's renewable generators only. I don't see anything in there that states that it's net energy billing generators versus grid scale generators. It could be biomass, it could be hydro. So I just wonder, am I reading that wrong, or did you maybe go down a specific place with your testimony?
There is, thank you, Representative. First, let me answer your question, then I want to respond to your comment. The bill in its list of reports that utilities would have to make would be reporting on how they're doing on interconnection of renewable energy projects. That is one more place in multiple pieces of legislation where you have been asked to assist renewable energy developers in getting interconnected with the utilities. And the only place where I'm aware that's been a problem is, quite frankly, with net energy billing. And so forgive me, but that's my assumption, that this is one more effort to deal with that. There's nothing wrong with that. Okay, that's fine. Have them report, but it certainly isn't superior to cost as a concern. Okay. Secondly, in regard to your relatives, thank you for their service. It is an emotional thing, but I would urge you not to think that the impact of what's happening out there right now without net energy billing starting is already, as you know, very substantial. And when I analogize to Vietnam, it is because I served in the military during Vietnam, right? I understand it. I appreciate it. I lost friends too. We're going to lose businesses and people are going to suffer if we don't do something about the costs that are coming down the road. And I apologize for any other inference you may have taken.
Again, I just want to remind people we are debating this bill and not another bill that was previously before this committee. Representative Wadsworth.
And not Vietnam, I understand. Right.
What? Representative Wadsworth.
Thank you, Mr. Chair. Good morning, Mr. Buxton. You're members of some of the largest ratepayers in Maine. If we don't amend this bill in its current form, how will it affect some of your members?
Well,
just curious if you could respond to that.
The Industrial Energy Consumer Group, unfortunately, is the only consumer group that actively participates in more than a few PUC proceedings every year. And this will create a lot of work for the public advocate, for the staff, and it will make, we need to be careful, as others have said on your committee, that it not create a circumstance that is difficult for people to participate in. When we did the NECEC hearings on a CPCN, there were 38 parties at enormous expense for 18 months. The public advocate can speak for many of us, but not all the time, and people need a chance to participate. So I would urge that you take the advice of the commission, whatever it might be, on how this might be streamlined.
Representative Wadsworth, any follow-up? Okay, Representative Barry, you have additional questions?
I do, Mr. Buxton, because your focus is on affordability, and I share that concern very strongly. I want to share with you some information and ask you to respond to it with respect to the accuracy of the information, and only that. The Public Utilities Commission has shared with me when I asked them directly what the cost of all of our net metering and community solar and renewable energy procurements was to our bills, that the total sum cost at present, which I just heard you say was very significant, at present is 2% of our bill. And that's without looking at the benefits. That's not including the 15% off. That's not including environmental or health benefits. So I just want to be clear, because this is so important, and we all have a duty to report to the public on what's real and what's not. That the Public Utilities Commission says now that all the costs, sum total, not including benefits, is 2% of our bill. And we can debate tomorrow. That's a legitimate question. But right now, 2% is the figure at the PUC. Are you taking issue? Because it sounded like you said it was a very significant cost driver. Are you taking an issue with their math?
If I may, I think your question is, do I agree with the 2% number?
Well, I just heard you say that our policies are currently, and I emphasize currently, costing us a great deal. And some of those, Mr. Buxton, were, we worked on together. But I I just want to ask you, because you're asking to amend this bill for the purpose of including reporting on costs, whether you want to stand by your characterization or whether you would defer to the PUC on that cost.
Yeah, let me be clear about this. The cost of net energy billing is coming. The commission has told you what it will be, right?
Okay, again, last time I'm going to warn people, we're not debating net energy billing.
Okay, I'm sorry. I thought I was answering the question.
We need to keep our focus both on the questions and the answers. We need to keep our focus on this bill.
Okay. I guess, Representative, I'd have to see the numbers. I don't dispute your point. There is there is very little of that program I can't mention that is in rates right at this point.
Thank you.
Any follow-up question, Representative Berry?
Thank you. I think the relevance is simply that if we're going to restrict speech, we need to know what speech we will agree to. So thank you.
Any other questions for Mr. Buxton from the committee? Okay, we'll go on to Beth Ahern.
Thank you. Good morning, Senator Lawrence, Representative Berry, and members of the Energy, Utility, and Technology Committee.
Jason, did we lose her?
I'm not sure. Hold on. Let me see if I can find her again.
I see her.
Yeah,
over
I'm
in
bringing her
attendee.
back over right now.
Yeah, thank you.
Mr. Chair, may I say something in between? I had my hand up for Mr.
Sure,
Buxton.
Representative Sachs.
And I appreciate, I needed to reinforce Representative Grohowski's statement. I felt like that comment around the Vietnam of net energy billing was inappropriate, and I felt like we needed to publicly state that. So thank you for the comment, Mr. Lawrence. Thank you.
Representative Ahern? I'm Representative Ahern. Excuse me, Beth, sorry. I'm getting confused here. Go ahead.
Good morning. Sorry, I don't know what happened. I got lost in the ether there for a while. Good morning, Senator Lawrence, Representative Berry, members of the Energy, Utility, and Technology Committee. My name is Beth Ahern, and I am testifying today as the Government Affairs Director of Maine Conservation Voters. I live in Freeport, Maine, and I am a constituent of Representative Sachs. It's nice to see all of you here today. Maine Conservation Voters is a statewide environmental advocacy organization that represents more than 13,000 members and supporters dedicated to protecting Maine's environment and our democracy. We support policies that keep Maine on a path to an equitable, clean energy future. Today, that means testifying in support of LD 1959 and its intent to hold energy utilities accountable. We see significant opportunities to strengthen the bill and offer suggestions to better ensure that the utilities are aligning their investments and operations with the state's climate and clean energy goals. The way we generate and use electricity is changing fast, as you know, but the way electric utilities are regulated and paid has hardly changed in 100 years, and the current mismatch between utility incentives and consumer needs is hindering our progress toward urgent clean energy goals. Through the Public Utilities Commission, though the PUC has existing authority to regulate Maine's transmission and distribution utilities, the legislature has the opportunity and obligation to provide clear, forceful direction and give the PUC courage to take bolder action. We recognize that many key details and decisions will be made in rulemaking, but the statutory language is critical in steering those outcomes and should be strengthened. More specifically, in these ways, performance standards must be strengthened by defining detailed metrics that incorporate the state's climate and clean energy requirements and assigning penalties, incentives, and report-only conditions for each, with a subset of metrics deemed essential service standards. Planning obligations must be expanded to include integrated transmission and distribution planning for climate resilience and mitigation. Specific additional attention should be given to decarbonization, power sector transformation, load management, and affordability, which has been talked about today. The threshold for acceptance performance and the consequences of failure must be clarified. LD 1959 should require the PUC determine through rulemaking a clear and unequivocal performance threshold that triggers a predictable cascade of penalties, culminating with an adjudicatory proceeding for divestiture. Finally, LD 1959 must work hand in hand with the proposed consumer-owned utility. We cannot wait to begin correcting the poor performance of Maine's incumbent utilities. But given the citizen initiative progress underway and the likelihood of a statewide COU referendum in 2023, we must avoid creating direct legal conflicts between accountability measures proposed here and those already contemplated by Maine voters. Part of our mission at Maine Conservation Voters includes holding politicians accountable to their words, actions, and votes to protect Maine's environment and communities. We commend Governor Mills for proposing legislation that champions that same sentiment for our state's utilities, and ask the committee to strengthen and refine the draft language to ensure that LD 1959 achieves its intent to hold utilities accountable to Maine people and the vision advanced by Maine's Climate Action Plan. We also thank Senator Brenner for introducing the governor's legislation. Thank you, and I'm happy to answer any questions.
Thank you. Are there questions from the committee for Ms. Ahern? Seeing none, thank you very much. We're going to
Thank
be
you very
taking
much.
our delayed break now. So we'll be breaking for 15 minutes. We'll be back at 11:10. I just want to remind people that we have 50 people left to testify on this bill. And to get through, that's about 2.5 hours. We will be taking a break for lunch. And it will be an hour break, probably around 12:30 or 1. So that will have to be factored into our schedule. Then we have the following bill. So I'd advise members, if you have meetings planned for this afternoon or appointments, you probably should consider canceling them or rescheduling them. I would say we're probably going to be here till about 2 or 3 this afternoon. Questions, Representative Berry?
Thank you, Senator Lawrence. I just wanted to call to your attention. I neglected to mention it earlier. I believe there are still 2 legislators wishing to testify, and I had hoped that we would put all the legislators first, as tradition tends to.
But we haven't, my understanding is they're going to testify in opposition, and we haven't gone to opponents yet. So I can recognize, I think Senator Bennett is the one you're talking about. If he has another hearing going to begin. Representative Grochowski obviously is here for the duration. So I'm sure she would defer to members of the public testifying since she's going to be here for the hearing. That was my plan. Any other questions? Okay, if you could please stop your video and stop your audio, that would be great. And I'll see you at 11:10. Okay, I'd ask everybody who's back just to show their faces on screen.
Confirm that with Bill Nateo.
Okay, I think we're good to go. So we're going to shift over to, we're still on LD 1959. We're going to shift over to the opposition, those opposed to the bill who don't want to see it passed. And I don't have any real order because, as Representative Berry said, everybody's listed alphabetically by first name. And the first name who shows up is Adam DeRozier from CMP, but I know 3 people wanted to testify from CMP. So I'm going to deal with them all in order. So I'll go to Andrew Blunt from the Our Power Coalition.
Mr. Senator Lawrence.
Yes.
Did you want to start with the legislators?
Oh, yes. Okay. If we could have Rick Bennett come over, and then I'll go to Andrew Blunt.
And I will note that the chat conveniently alphabetizes people by last name as well, or by first name, I should say.
Oh, the
attendee. Yeah, the attendee panel. So you can see that Adam.
You must get the upgraded version because mine does it by first name.
I have a new laptop. That must be why. I see Adam DeRozier is with us. If you did want to.
He is, but Joe Purrington, who's the president of CMP, had asked to testify, and I think he's going to testify first, and then 2 others are going to testify in more technical detail later on.
I see.
I wanted to bring them all up together. So I kind of wanted to go to Senator Bennett so that he can attend to the important things he's got going on today. And then we'll go to Andrew Blunt. Senator, good to see you.
Good to see you, Senator Lawrence, Representative Berry, distinguished members of the committee. I am Senator Rick Bennett of Oxford. I have the honor of serving 13 towns in Oxford and Cumberland counties in the Maine Senate. I come before you today in opposition to this bill. The title of this legislation is a sham. The bill ensures nothing, certainly not the accountability of our foreign-owned utility monopolies. This bill actually heads our energy policy in the wrong direction to reform, doubling down on the foundational problem of the current system. I'm reminded of Juvenal's famous phrase, quis custodiet ipsos custodes? Who watches the watchers? In the present context, who looks out for Maine consumers as they see their electric rates skyrocket, as they continue with justification to disbelieve their electric bills, to dispute their metered usage, to wonder why reliability in customer service is so poor? Why is nobody held accountable? As a businessman with some success turning around struggling Maine enterprises, I have to observe first that the usual accountabilities of the free market economy are not available to fixing our investor-owned utilities. Their customers are captive, they have baked-in profits, and there is no competition. If CMP were not a monopoly, they would have been driven out of business long ago. We don't need the report card proposed by this bill. The results are in. According to the US EIA, CMP customers suffer from the most outages in the country, bad reliability, and the 11th highest costs. J.D. Power's research has shown that year after year after year after year, CMP's customers rate it the worst electric utility in the country. If you don't believe the independent research, just ask your constituents. Our unelected and unaccountable PUC already has the power to create performance standards and decide if a utility's failure to meet them warrants penalty. Trying to create accountability of these electric monopolies through consolidating more power to the governor's office and the PUC is the path of this proposal. It's wrong-headed and ignores the fundamental problem, foreign investor ownership. We all acknowledge we are driving toward a carbon-neutral electricity-powered economy, but the foreign governments and foreign corporations owning and operating our electric utility monopolies in Maine have been happy collecting ratepayer checks while ignoring this future. As Versant ratepayers pave sidewalks in Calgary, Canada, and CMP ratepayers underwrite the chairman of Iberdrola's legal defense against political corruption charges in Spain, the money Maine needs to invest in our grid is drained away. Last year, this committee endorsed and the legislature enacted LD 1708, which the governor vetoed, which held the promise of true accountability. In contrast to the bill before you today, that proposal, now a ballot measures, opens the door to energy democracy. While keeping full PUC oversight, it empowers all Maine people with an elected and expert board accountable directly to us, conducting business openly here in Maine and in the light of day. Without such provisions, the governor's bill here before you is fatally flawed. The real disservice of this bill is the false hope it offers at a time when Mainers need something real. We need to restore honesty and trust in our electric system and in our political system. We will not achieve this through dilatory half measures. Mainers are a patient people. We're slow to anger, but we have come to realize the game is rigged. That's why a nonprofit, non-governmental, ratepayer-owned utility model is our best shot to achieve lower cost, reliable power under local control, managed on behalf of Mainers and accountable only to us. This bill before us today does not get us there. Thank you very much.
Thank you. Are there questions from the committee for Senator Bennett? Seeing none, thank you. And I just want to remind people again on the committee that we are debating this bill and not any other bill. Representative Barry, did you have a question for Senator Bennett?
Just wanted to know, Senator Bennett, where you learned your Latin?
Mr. Witkowski's class at Yarmouth High School.
Thank you very much. Excellent.
Any other questions for Senator Bennett? Okay, if we could, I think we have Andrew Blunt over, brought over, and if you could bring across Mr. Purrington, if I've got that name right, Mr. Purrington after him, that would be great. Thank you. Andrew, go ahead.
Hi, thank you, Senator Lawrence, Representative Barry, and distinguished members of the committee. My name is Andrew Blunt. I live in Portland, and I'm the legislative director for Our Power, a broad coalition committed to putting the Pine Tree State's energy future in the hands of Mainers. And we strongly urge you to oppose LD 1959. I'd like to start with something that we can all agree with, that our two investor-owned utilities, CMP and Versant, are just terrible on almost every metric. From that point of common understanding, I want to jump back to less than 1 year ago, when our coalition came before you to push for a real solution to that problem, a consumer-owned utility. That hearing went on for 11 hours, and I'm sure that you all remember it well. Your committee overwhelmingly approved that bill, and it went on to pass in both chambers with bipartisan support. That was a visionary model for utility accountability. This bill, LD 1959, is nothing like that. This bill has many flaws, but I will go through the three most crucial today. First, for a bill about accountability, there is no place for the public anywhere in it. This bill relies heavily on the PUC for accountability, but the PUC is deliberately designed as a quasi-judicial authority and is purposefully insulated from the will of the public. In crucial decisions, it too often has to rely on whatever information is selectively provided by utilities. It is simply the wrong body to look to for true accountability. We, especially those Mainers struggling with sky-high bills, deserve our voices to be heard. Second, this bill gives CMP and Versant a blank slate that they do not deserve. The report card system that LD 1959 creates is astonishingly weak, does not set specific minimum standards in statute, and does not mandate a clear course of action when utilities fail to meet them. All of these questions are left to PUC rulemaking, another bureaucratic process that is inaccessible to the public in a body that has repeatedly shown that it is incapable of improving our utility service. Lastly, this bill puts a consumer-owned utility on the table, but does not give a workable pathway to its creation. None of the important details included in our referendum about how to create a consumer-owned utility are included here. The bill mentions the formation of a related committee, but they would all be appointed by government insiders, either the governor or the public advocate. Without these details and public participation, this section is left incomplete and undemocratic. While some of you may see LD 1959 before you as a half step, it is everything but. Do not be fooled, this bill is not moderate policy towards shared accountability goals. It is half-baked, severely lacks important details, and represents a retreat further into a regulatory structure that has failed Maine time and time again. That is why much of the supportive testimony today that you have heard and will hear has called for the bill to be nearly rewritten, because in its current form, it is just bad policy. Rest assured, LD 1959 will not produce the change that we are calling for, that each of the 50,000 Mainers who have signed our petition so far are calling for, and that each of your constituents desperately need. I urge you to vote ought not to pass on this proposal as written, and thank you. I'm happy to answer any questions that you have.
Thank you. Are there questions from the committee? Seeing none, thank you very much. We'll go next to Joe Purrington, and if you could bring over Adam DeRocher and Linda Ball too as well. That would be great. Thank you, Jason.
Senator Lawrence, I think we have two legislators still wishing to testify in opposition.
I did not see that. Why don't you send me a text with their names? Go ahead, Joe.
You got it.
Okay, good morning, Senator Lawrence, Representative Berry, honorable members of the committee. My name is Joe Purrington. I was born in Maine and grew up in Jay. I raised my son in Winthrop and in Westbrook. My grandchildren are being raised in this great state as well. I worked for CMP for 28 years. Then I made a career move to Eversource's New Hampshire utility, later becoming its president. Last summer, I received a call, an opportunity that I had hoped for, an opportunity to come back as the president of CMP, to put Maine back in the Central Maine Power. And that is why I'm here today. First and foremost, we agree with the governor's motivation for this bill: accountability, transparency, tough standards, consequences for failure. So why are we opposed? Because we believe the legislature already got it right. The PUC has the authority it needs to do its job, to ensure safe, adequate service at just and reasonable rates. How do we know that? Recent history. The PUC evaluated our performance for service quality. The commission concluded we weren't doing our job. And what did they do in their response? The PUC used their authority and imposed the largest financial penalty in Maine utility history, the largest financial penalty. And they said, fix it, fix the problems, and prove to us that the problems are fixed. Then they set very stringent metrics for us to meet, specific, measurable service quality indicators. And they put teeth in their decision. By utilizing their power, if we did not do our job, we would face additional financial consequences. So what did we do? We looked in the mirror, we hired more Mainers to fill needed roles, we invested in the system, we reorganized. We are now meeting and exceeding some of the most stringent metrics in the industry. And are those results enough to satisfy us? No, absolutely not. We need to do more, and we are doing more on service, on reliability, on storm response. And guess what? We get it. I get it. Every day, we need to earn the privilege you've granted us, the exclusive right to distribute a necessity of life. I'm passionate about CMP, about having the privilege to serve our customers, and to come back and work with the nearly 1,000 caring, dedicated, hardworking Maine people at CMP. My knowledge of CMP and my experience at Eversource prepared me for this role. David Flanagan started the work, and I'm going to finish the job. Our mission is to provide safe, reliable, and affordable electric service to Mainers. Is of the utmost importance. Our leadership team knows the mission. And before I walk off into the sunset, CMP will once again, without question, be among the best. So I ask for the opportunity for our customers, stakeholders, and regulators to experience our current performance and recognize the hard work of our employees to let us continue building off the foundation we have started. Thanks for your consideration, and I'm happy to answer questions, Mr. Chair.
Are there questions from the committee for Mr. Purrington? Seeing none, thank you very much. We'll go on to Adam DeRocher.
Good morning, Senator Lawrence, Representative Berry, members of the committee. My name is Adam DeRocher. I live in Winthrop, and I've worked for Central Maine Power in frontline operations since 2008. But my roots go back a lot further than that. My grandfather was a lineman at CMP for over 35 years, and I'm proud of my CMP roots, and prouder still of more than 600 employees that work in operations every day. I represent them as the Vice President of Electric Operations. Testifying in opposition to a bill proposed by the Governor of Maine is not easy, but testifying today is part of the job, because I can't just encourage my people to excel, I need to support them when they are excelling. We work in a business that requires measurement about safety, about performance, about reliability. We just don't welcome being measured, we need it. And more importantly, customers deserve tough standards. Every customer in Maine, whether they live in Madison or Waterville or any other community in our state. Obviously, setting these appropriate standards will require active utility participation with commission staff, which is what we hope you are contemplating. On interconnections, as we all know, Maine has seen an unprecedented increase in solar PV requests. Candidly, we were a bit overwhelmed initially by the volume that no one in the state expected. Interconnections to the system are complex, and we have an absolute obligation to make sure these are done safely and done in a manner that does not jeopardize customer reliability. We need to keep the lights on. To deal with the substantial number of interconnection requests, we worked with the developers and others. We streamlined the process, we added staff, and we have a sharp focus internally on interconnection efficiency. The same goes for reliability. In the last 6 months, we've implemented a number of changes to improve reliability. For example, every weekday morning, the operation teams meet. We evaluate any outage that occurred from the prior day, review the cause, if protections operated properly, and what we can do to prevent or reduce future events. The PUC set a regulatory target for reliability in 2018, and we already report on these metrics annually. I call your attention to the graph in our written testimony on page 3. And it's an example of our recent performance. Storm response is also critical in a place like Maine. We have tough winters, and the intensity of non-winter events is increasing. So while industry leaders regularly point to our storm response, planning, capacity, and execution, we know weather is evolving, and we need to evolve as well, particularly as it relates to high wind events. The folks in electric operations are a dedicated, highly trained group, and we all know electricity is an essential service to our customers. We take our job seriously, and if our performance is measured objectively, fairly, appropriately, I'm confident we are up to the job. Thank you for considering my comments today.
Thank you. Questions from members of the committee? So I guess, Mr. Droscher, I was given to understand you were going to testify on technical parts of the bill that you or your company were opposed to. Is there certain parts of the bill that you feel technically will not work?
In an effort to keep our spoken testimony under 3 minutes, most of the technical critiques we had on the bill are attached in our written testimony.
Okay, great. I'll take a look at that.
Yep.
Thank you. Okay, if there are no other questions for Mr. DeRocher, I'll go on to Linda Ball.
Good morning, Chairman Lawrence, Chairman Barry, and members of the committee. I'm Linda Ball from CMP, and I'm here to testify in opposition to LD 1959. What I'd really like to talk about this morning is CMP customer service, how we got here, and where we are now. I want to emphasize, as Joe and Adam did before me, that we don't object to metrics or accountability about our performance, but this bill is simply not necessary. And I believe it's predicated on poor performance from 4 years ago that we've worked so hard to overcome. We've been focusing on repairing our reputation and our relationship with our customers. I know that job isn't done yet, but much of what we hear from customers is still about events in 2017 and 2018. The reality is we've come so far since then, and those problems are in the past. We were taking minutes to answer customer calls back then. Today, our customer service reps are consistently answering calls in less than 30 seconds, and we've been doing that for 2 years now. Back then, we had customers who were waiting months to get a bill, and that's not okay. But that's also not happening anymore. Today, we're issuing almost 99.9% of our bills on time and accurately. That's close to 670,000 bills every month going out on time and accurately, and that's exactly what CMP customers deserve. Despite all the rhetoric in the news and on social media, that's the level of customer service that CMP customers are receiving today, and none of this happens by accident. Following our poor performance back in 2017 and 2018, the PUC delivered a very strong message, directing CMP to basically shape up and provide the right levels of customer service and establishing metrics to make sure that that happened. CMP did exactly that. We hired more people, we provided more training, we reorganized under local leadership, and we've met every customer service metric imposed by the PUC for almost 2 years, and we're committed to meeting them going forward. I would be remiss if I didn't also point out that so much of this has been accomplished during the COVID-19 pandemic. While other businesses reduced hours or offered limited menus to their customers, our employees maintained and even continued to improve our service to Mainers, and we met our metrics, even while these same employees were dealing with the pandemic in their own private lives. We've done this in good weather, and we've done this during storms.
Remind you, Linda, you're a little bit over your 3 minutes.
Thank you. I'll wrap up. But really, when others close early and go home because of bad weather, our folks start early, they end later, and they work harder. And we do all of this because we know how important electricity is and the people are counting on us. In short, I have to say I couldn't be more proud of our team at CMP. We live and we work throughout the state of Maine, doing everything we can to support our customers and our neighbors and deserving excellent service. Thank you for your time, and I can answer any questions you might have.
Thank you. Are there questions from the committee? Representative Barry.
Thank you, Ms. Ball, for your testimony. I appreciate the testimony that you and Mr. DeRozier and Mr. Barrington all gave on behalf of Central Maine Power. I haven't heard specific comments to the bill before us, and so I want to give you that opportunity at the risk of prolonging this discussion. But it seems to me that that's critically important. And I also just want to offer, with respect to the comments you did make, that I believe that the entire committee is incredibly grateful to the employees of Central Maine Power for the work that they do day in and day out, and certainly the concern around affordability, who pays for that improvement, who pays for that work, and how the affordability and other standards are judged is no reflection on the employees of the company. So can you speak to the bill itself?
Sure. We did provide very detailed comments in our written testimony about the bill itself. Again, we don't object to metrics or to performance being judged. We're accustomed to that as a regulated utility. And speaking especially for customer service, we've been providing our metrics on the 4 service quality standards that the PUC imposed every quarter for about 2 years now, and we've committed to doing that on a going forward basis. We also do provide reliability reporting on a very regular basis. I do think there's a question of whether or not quarterly is the appropriate period for every single metric. And our written testimony will talk in more detail about that. I do appreciate your comments about employees, Representative Barry. I think that's important for them to hear.
Representative Barry.
Thank you, Ms. Ball, and I have continued to say that and will consistently continue to say that. I wanted to just check on something I thought I heard you say, that reliability had improved since 2017. The EIA data tells a different story. Energy Information Administration, the federal government reporting, which, you know, I think it's important. You note yourself, is we already receive reports through the EIA on much of the data that's required to be filed under this bill. So I think I share some puzzlement in what the bill accomplishes in that regard with you. But the outage minutes reported to the EIA by Central Maine Power were actually higher in 2019 than they were in 2017, 2018. And then they were even higher in 2020 than they were in 2019. So Did I misunderstand you, or what am I missing?
I didn't specifically speak to whether reliability has improved or declined. That's really Adam's area of expertise, and I think that would be an interesting conversation to have in the work sessions. I did hear Adam speak to storms becoming more intense and us having to adjust our techniques as a result. I think we all know that weather is getting more uncertain, and we do need to deal with more storms on a more regular basis. And I think Adam's doing an awfully lot of work in that space to improve reliability for customers.
Thank you. And one last question, if I may, Mr. Chair.
Go ahead, Representative Barry.
Does Central Maine Power or Avangrid or Iberdrola or any of the shareholders of Iberdrola have an opinion to share with us on the possibility of protecting employees, contractors, employees of contractors who come forward with concerns about prudence or other activity, potentially even illegal activity on the part of a utility?
Avangrid, Iberdrola, and CMP already have existing protections for employees. There is a zero tolerance policy for any retaliation for customers, for employees who feel the need to use whistleblower techniques. My hope is that every employee who sees something they don't believe is correct would say something and let us address that. I don't think we need the protections in this bill, but I'll certainly leave that to the committee to decide. But again, it's a zero tolerance policy at CMP already. There can be no retaliation for anyone speaking the truth.
Thank you. So there would be no objection then to our making that a legal requirement and protection, since it's already a utility policy, and extending that to contractors and employees of contractors?
So I think we've got a lot of discussion about that in our written testimony, Representative Barry, and I think we'd be happy to talk about it in the work session.
Thank you.
Sure.
Any follow-up, Representative Barry?
All set.
Representative Foster?
Thank you, Mr. Chair. Thank you, Ms. Ball, for being here. We heard earlier some concerns that this bill may add costs to the Public Utilities Commission. As a matter of fact, in reviewing their written testimony, which I assume is coming later, their testimony, they are concerned about that. Some of us lose sight, I think, sometimes of how many customers and how many bills are sent out by the IOUs. I'm wondering if you have had a chance to look at it, because when I reviewed your written document, which was submitted by Kathleen Newman, and glancing through it, I didn't see where anything was addressed as to what costs may be incurred to, if there are any, if this bill should be passed as is written. Thank you.
That's a really good question, Representative Foster. Thank you. I don't have costs at my fingertips now, but I'd be happy to gather some information and bring it to a work session. I think that's really important to recognize. In our written testimony, we did talk a little bit about cost to serve and determining the right metrics and what's important to customers. You'll see particularly around the speed of answer, we've got a little bit of language that says, I'm not entirely sure if customers need to be answered in 30 seconds or if customers would be happy in 45 seconds. And there's a cost implication to all of that. So we can talk about higher levels of service, and we're happy to provide that, but there are often costs associated. And I think that's a great conversation to take up in the work sessions.
Thank you.
Follow-up, Representative Foster? Seeing none, any other questions for Ms. Ball? Seeing none, thank you. I understand we have a representative who wishes to testify. She wasn't on our list, but I'm going to go over and ask you, Jason, to bring over Laurie Osher. And I would at this time also to let members know, Speaker Fecto, who had wanted to testify in favor of the bill, can't be here, but he is submitting written testimony, which should be here shortly. Representative, are you there? Great, if you could unmute yourself.
I am here, and I am now unmuted.
Thank you. Go right ahead.
To find my My testimony disappeared when I joined you. Okay, here it is. Good morning, Senator Lawrence, Representative Berry, and the esteemed members of the Joint Standing Committee on Energy, Utilities, and Technology. I'm Lori Osher, and I represent House District 123, and that's the majority of Orono, including the University of Maine campus. I'm here today to testify in opposition to LD 1959, an act to ensure transmission and distribution utility accountability. Across the nation, the most important features of electric service have always been reliability and cost. But here in Maine, 2 privately owned utility companies are providing unreliable electric service at extremely high costs. Our citizens who are served by Versant and CMP are so accustomed to power outages that they hadn't realized it doesn't have to be that way. They don't know that citizens served by the consumer-owned utilities in the state experience much more reliability. Our constituents are complaining about cost, and as of January 2020, CMP and Versant charged 49% more per kilowatt hour for residential delivery than Maine's existing consumer-owned utilities. The PUC allowed CMP a 13% increase and Versant a 17.5% increase in the last 6 months, and the increased costs, combined with all of the other hardships our constituents have endured, are preventing many from being able to cover the most basic costs of living after they pay their electric bills. LD 1959 proposes to create a performance report card that the PUC would use to evaluate all of Maine's electric utilities, and proposes methods for changing the ownership of utilities that perform poorly. However, the proposed report card isn't designed well to address these issues. The bill presents categories of minimum standards, including reliability of service, frequency of customer complaints, and timeliness and accuracy of bills, but does not define these terms. LD 1959's proposed report card places reliability after 5 other utility report card factors. It doesn't even list affordability in its categories of minimum standards. Leaving affordability out of the conversation ignores the hardships Mainers are struggling, the hardships of Mainers struggling to pay their bills. The PUC has allowed Versant and CMP, both companies owned by foreign corporations, to have some of the worst reliability and highest cost electricity in the United States. Last summer, the House and Senate both approved a meaningful step towards energy democracy, affordability, and real accountability, LD 1708. Tens of thousands of Mainers have already signed petitions to send the consumer-owned utility proposal to the ballot. This bill, LD 1959, is a poor alternative to a public process that is championing real change. This bill puts a consumer-owned utility on the table, but doesn't specify how it would be created. The important details included in Our Power's referendum, which are taxation, worker protections, credit, without the need for state debt, governance specifics are not included. The Our Power referendum articulates how such a transition would occur, and it requires more planning than this bill allows. This bill also leaves open the possibility of handing off our power grid to another investor-owned utility that would be able to continue providing high-cost, low-reliability electricity to captive Maine customers. I appreciate the opportunity to speak in opposition to this bill. Maine needs real accountability for CMP and Versant. We don't have that now, and LD 1959 will not create an environment for that accountability.
Great. Thank you very much, Representative. Other questions from the committee? Representative Berry.
Thank you, Representative Osher, for testifying. And I know you represent the Versant area where there was a 17.5% rate increase in November. Do you have the sense that your constituents feel able to participate in Public Utility Commission proceedings, especially the more quasi-judicial adjudicatory processes that are contemplated in this bill?
I have a very interesting district. We have the university, so I have faculty and staff of the university. Those that can afford to live in Orono, which is much more expensive than the surrounding towns, tend to be more engaged in the process. And so I think that they would feel confident participating. I also have lots of students. I have lots of elderly constituents. and many people in low-income housing. And they are the people in low-income housing and the elderly, especially the elderly in low-income housing, have contacted me about the cost, but they're not understanding how they would participate. So, you know, because it's a mixed district. And then I have been talking a lot with students, trying to encourage them to vote in our local election that's coming up in March, and they're really unfamiliar. So as an former educator, I used to be a faculty member at the university. I would love to see more participation, but I haven't seen the PUC reach out to encourage participation or educate people on how to do that. So I would say that those who are already quite well educated in the process would participate, and the others don't even know what's going on and how to access a way to have their voice heard.
Thank you very much.
Representative Barry, any follow-up?
I'll say.
Okay. So I'm trying to look at the attendees list to see who's here. I do not see an Ann Morrill, but I do see one telephone number. Jason, do you know if we have Ann Morrill here? If not, Jason, could you bring over Austin Sims? I do not see Ben Smith here. If you could bring over Bill Dunn and then Cole Cochran. Okay, Austin, I think you can probably hear us now. If you unmute yourself, go ahead and present your testimony.
Thank you, Mr. Chair. Good morning, committee members and staff. I speak today in opposition to LD 1959, an act to ensure transmission and distribution utility accountability. While this draft legislation may be well-intentioned, it falls short of actually ensuring accountability and does nothing at all to address multiple other legitimate grievances Mainers have with utility reliability, affordability, and oversight. My impression, based both on the shortcomings of its language and the late submission date, is that this bill was drafted with the primary intent of winning points. It offers milquetoast and ill-defined alternatives to the real and meaningful change represented by LD 1708, a bill passed last year by both chambers of the legislature, which enjoyed broad support, but was subsequently vetoed by Governor Mills. The path towards a consumer-owned utility presented in LD 1959 is unrealistic, undemocratic, insufficient towards combating climate change, and seemingly destined to fail. I am deeply concerned that this bill will act as a roadblock towards real reform, and thus am compelled to enumerate other specific concerns I have. The draft language provides no mechanism for accountability, instead relying on the Public Utilities Commission to develop their own mechanisms. The PUC is an unelected board, unaccountable to the people, and this bill opens no avenues to right this anti-democratic consolidation of power. The draft likewise does not define the minimum standards the law would seek to uphold, instead deferring to the aforementioned unelected PUC. If all of these significant shortcomings were not enough, if the threat of climate change did not behoove us to immediately make sustainable our electric utilities, if democratic governance were no concern at all, this bill will still fall short of doing anything about Maine's exorbitant electricity costs. Indeed, the bill before you does not even seek to address this concern directly. Mainers paid the 11th highest rates in the country last year. CMP and Versant continued to jack up cost per kilowatt hour, such that our customers pay nearly 50% more than do Mainers living in communities with COUs, which I believe is roughly 91 communities in the state. I urge you to vote against the bill in its present form, as well as any subsequent amendments that do not address these glaring issues. I thank you for your time.
Thank you very much. Are there any questions from the committee for Mr. Sims? Seeing none, thank you very much. I'll go on to Bill Dunn.
Thank you, Chairman Lawrence and committee members. My name is Bill Dunn. I have 50 years experience in the electricity industry, and in all that time, I have seldom, if ever, seen such poorly performing electric utilities in a developed country as are the large electric utilities in Maine. I'm testifying here as an unpaid resident of Yarmouth. I've also submitted written testimony. The purpose of my testimony today is threefold: to point out that the performance of CMP and Versant has not improved, to question aspects of LD 1959, which I oppose, and to question the ability of the PUC to improve the performance of Maine's IOUs. In a just world, CMP and Versant would already cease to exist because of their long-term poor performance. They would have had their monopoly franchises revoked and been bought out by competent management, or preferably been converted to a customer-owned utility or consumer-owned utility. That has not happened. Despite claims that the performance of Maine's IOUs has improved, it has not. I've added the EIA reliability data for 2020 to the data I provided to the committee last year. In 2020, the Maine IOUs continued their long-term record of having the worst reliability in the country, with each customer averaging 28 hours of outages and the average outage lasting 7 hours. I also added the JD Power 2021 residential customer satisfaction data for all large and mid-sized utilities in the US to my previously submitted data. The results show the continued failure of Maine's IOUs to meet the needs of their customers, as they were again 2 of the 5 worst utilities out of 121. I doubt LD 1959 will fix this. It leaves the development of the routine rules for monitoring performance to the PUC without public input or requiring legislative approval. Is the PUC up to the task, or will they rely on advice from the utilities themselves and their representatives? LD 1959 is also extremely vague on how the performance will actually be monitored. How the 6 different standards will be combined to determine failures is not defined, and neither is what is consistently fails to meet a standard. PUC has not held CMP and Versant accountable in the past, and I have no confidence that they will in the future. They just lifted an existing CMP financial penalty, citing the company's recent customer service improvements, while at the same time, the Office of the Public Advocate filed information indicating that 3 of the 4 key benchmarks for the company's performance showed clearly consistent retrogression since last February. There is much more detail in my written testimony. I thank the committee for your consideration, and I'm happy to address any questions either now or for the work session.
Thank you. Are there any questions from the committee for Mr. Dunn? Representative Barry?
Thank you, Mr. Dunn. Your written testimony is extensive. It's impressive. It's evidence of your 50 years consulting internationally in the energy industry. And just, for my sake, if you could just hit the high points, I don't want you to go through the whole, compendium of charts you put together, but what are the takeaways that you hope we will understand from that comprehensive data that you've put forward in terms of reliability, in terms of service? If you could just elaborate a little bit.
I mean, over time, and this is not a recent event. I mean, over time, CMP's and Versant's reliability data, for example, is always much worse than the reliability data for other investor-owned utilities throughout the United States, and is even the difference is even greater relative to public power utilities. It's their performance on reliability compared to other New England states is also much worse. The number of outage minutes last year, or the last year for which the EIA has published data in 2020, Mainers had almost 1,700 minutes of outages, whereas the average for other IOUs is 462. So almost 4 times as much. And like you asked in a question to Ms. Ball, the number of outage minutes in Maine was higher in 2019 versus 2018, and then was higher again in 2020 versus 2019. So how they can be saying that performance is improving is beyond me. And the similar data for number of outages and then for customer satisfaction, it's while last year They were, I think it was 117th and 121st out of 121 utilities. That's not a recent event either. In 2020, Versant was 140th and CMP was 142nd, dead last. In 2019, they were the two lowest rated utilities of 142. 2018, CMP was actually a little better. It was only the 22nd lowest, but Versant was the second lowest out of 138. So there has been no improvement. You know, maybe they're answering the phone more quickly when customers call, but that doesn't mean the person who answers the phone can resolve the issue the person's calling about. So I don't know where these claims of improvement are coming from.
Another question, Representative Barry?
Just a quick clarifying point. The JD Power survey that you're citing, first of all, am I correct that that's all large and mid-sized utilities? Because
Yes.
the very small utilities like Kennebunk Light and Power are statistically difficult to sample.
Right. It's Versant and CMP are both in there. CMP considered a large utility and Versant considered a mid-size.
Great. And just one additional clarifying point. Are you aware of any other more reliable, comprehensive, and authoritative data than the sources that you have cited, the EIA from the federal government, Energy Information Administration, and the JD Power customer service rankings? Or are those really the gold standard?
From my understanding, they're the gold standard. A year or so ago when we were working on 1708, I remember some other entity put out some reliability data, and CMP Versant were again at the bottom of that. But I would have to go research my files to find out who did that.
Thank you very much.
Any other questions from the committee for Mr. Dunn? Seeing none, thank you. I'll ask you to bring over Kevin Matson. And if we could go to Cole Cochran right now.
Thank you. Senator Lawrence, Representative Barry, and honorable members of the Energy, Utilities, and Technology Committee. My name is Cole Cochran. I am the legislative coordinator for Maine Youth Action, an organization intended to represent youth interest regarding climate and politics. I am presenting testimony on the organization's behalf in opposition to LD 1959, an act to ensure transmission and distribution utility accountability. Maine's public has had a tumultuous relationship with utility companies CMP and Versant. We've seen egregious rate hikes, deceitful business practices, poor customer service, and an overall uncooperative experience with these utility companies. They rank lowest in customer service, but have an average rate of 16.79 cents per kilowatt hour, 31% more than the national average. Maine Youth Action wants to see meaningful action, holding these companies accountable, as well as seeking alternatives like consumer-owned utilities. However, LD 1959 lacks just that, meaningful action. Upon reviewing the bill, this is merely a piece of legislation that is purely superficial in its context, providing no meaningful reform to our current system. Changes virtually nothing in energy affordability, climate action, or accountability measures. From my perspective, LD 1959 appears to only distract from meaningful changes to our energy system, like consumer-owned utilities, or public control in our energy projects, all of which would serve better the interest of the public than what is in this bill. If the youth stakeholders in our state were to support this bill, it would need amendments intended to provide substantive matter. This might include more public participation within the accountability process, addressing increasing energy costs, or addressing the climate issues our state faces. I do not claim to be an expert in energy policy, but it doesn't take an awful lot of prior knowledge to see that this bill is purely covering up what actually needs to be done. I urge the committee for a motion of ought not to pass for the sake of focusing our crucial time and efforts on relevant, impactful legislation aimed to fundamentally change our energy system. I appreciate the time. Thank you.
Thank you. Are there questions from the committee for Mr. Cochran? Representative Barry.
Mr. Chair, Mr. Cochran, we appreciate your testimony, and I don't often ask folks this, but I do find it particularly impressive that you're here. Can you just share with the committee, first of all, whether you're paid to be here, and secondly, how old you are?
Yeah, I'm 17 years old. I actually recently got contracted by Maine Youth Action to get paid, but I've been doing this voluntarily for the past 3 or 4 years.
Very impressive. Thank you.
Thank you.
Other questions from the committee? Seeing none, thank you very much. And we'll go on to Kevin Matson.
Senator Lawrence, Representative Berry, members of the Utility Committee. My name is Kevin Matson, and I live in Freeport, Maine. Thank you for giving me the opportunity to speak with you today. I'm here to testify in strong opposition to LD 1959. I come to you today from the perspective of a business owner, but also as someone who has had the privilege of working with the committee in the 1990s, which obviously dates me, when the state was wrestling with the seemingly insurmountable problem of deregulation. As such, I have a perspective on this issue which may be slightly different than those who speak to you today. My company, Dirigo Capital, is in the business of rehabilitation and redevelopment of historic properties. We have placed back into service hundreds of thousands of square feet of commercial and residential real estate throughout the state of Maine over the last few decades. Like many businesses, I've had the opportunity to see firsthand how poorly Central Maine Power has performed over the last few years. I felt the feeling of complete powerlessness to deal with issues such as a sudden unexplained increase in billing, long waits for hookup times, and a process to connect solar projects to the grid, which is measured in years and not months. When your business depends on a critical partner, in this case, your power provider, who is your only choice for this service, there has to be some sort of accountability which actually has an impact. To date, that has only been accomplished directly by the people through referendum. This bill purports to hold the utilities that provide our service accountable and to put in place a series of checks, balances, and penalties. It is a very well-meaning piece of legislation. I believe, however, that it will have the undesired effect of prolonging the agony of ratepayers, both commercial and residential. For years, we've watched the PUC do almost nothing while complaints mounted. The PUC has no real direct accountability to the public, and the organization has been unable to deal with the many failings of the utility over the last decade. The idea that it will now be able to affect change to actually remedy these problems that plague us is not a reasonable. The penalties offered in this bill for noncompliance are so meager that they represent a small fraction of what CMP paid just last year in their attempt to defeat the referendum that represented the ultimate expression of public frustration. The utility will see this as nothing more than the cost of doing business when it is levied, like a traffic ticket. Rather than a path towards addressing the failings of the utility, this bill will instead extend the suffering that ratepayers are now feeling. It will give more time for bureaucrats to fiddle with an existing system that is hopelessly broken. LD 1959 might have been a solution for the last decade before the untold revelations of mismanagement and overbilling. We are well past the hour where anything other than a wholesale systemic change will address the situation we find ourselves in. We're dealing with a state-sanctioned monopoly that guarantees an equity return to overseas investors. And unless that is changed at a fundamental level, this legislation will not alter that. And worse, will delay the inevitable solution, which is a consumer-owned utility. The legislature passed a historic piece of legislation last year, one that will put us on a real path to partnership with the utility and the people it serves. The veto of that legislation was unwise and unfortunate, but as was the case last year, the people will in the end hold this monopoly accountable through referendum. We only ask that in the interim, we don't grasp at well-meaning but ineffectual solutions that will only prolong the inevitable transition to an accountable, affordable power partner. That is why I must ask you to please vote on not to pass. And I thank you for the opportunity to speak today.
Thank you very much. Are there questions from the committee for Mr. Matson? Representative Berry.
Thank you, Mr. Chair, and thank you, Mr. Matson, for your testimony. There was a lot there, and I just, because you're a successful business person, and we've heard from others this morning as well, but is there any instance in your experience where a business can perform at the level that our utilities have performed and still stay in business?
No, not at all. Not, and particularly not for something as fundamental as water, power, basics for what we need to conduct business and really have life. No.
So a report card might prolong the agony, and to use your words, because it would sort of start with a clean slate and essentially create new rules and drag out a process which should have already concluded. Is that right?
That's correct. If this was going to work, it would have worked 10 years ago. The PUC has had these tools for a long time. This is not going to change that. It will only prolong it.
Thank you very much. Thank you.
Thank you very much. Are there other questions from the committee? Seeing none, thank you very much. We'll go on to David Bilski. Go ahead, David.
Yes, thank you. Thank you, Mr. Chair. Good morning, Senator Lawrence, Representative Berry, and esteemed members of the committee. I thank you for the opportunity to submit testimony in opposition to LD 1959. My name is David Bilski. I'm a resident of New Harbor in Lincoln County, and I submit this testimony as a citizen ratepayer and also as a member of the state UU State Advocacy Network. As written, I believe that LD 1959 is a deeply flawed bill in so many ways. While my submitted written testimony takes a somewhat more comprehensive view of the bill, I'll comment on just two aspects of it here. First, the establishment of a report card is central to this proposed legislation. However, for all intents and purposes, the Public Utilities Commission is already engaged in assessment and enforcement of the utilities requirement to provide quality service. Just recently, we've been reading in the Portland Press Herald about the PUC's launching of a full investigation into how Avangrid's management of Central Maine Power may have shortchanged Maine's users. And we've had 2 years of PUC's administrative penalties on CMP for substandard customer service and billing practice malfeasance. Supplementing the PUC, we have J.D. Power's recent damning report card for CMP and Versant, and the current Federal Energy Information Administration's dead last rating for their reliability. We don't need a bill that calls for report cards. It merely further institutionalizes needless paper shuffling and delay. We already know the utilities ratings. They flunk, and they flunked for years. Second, regarding the 800-pound gorilla in the room, there's no talk of affordability in this bill. And there can't be, because of the effectively guaranteed rate of return for investor-owned utilities. T&D rates within the existing utility structure will simply keep climbing as they have for years. As a response to the exigencies of our climate crisis and the resultant need for beneficial electrification of the energy sector, we're facing a roughly $10 billion build-out of the electric grid over the next decade or so. PUC report cards won't do anything to guarantee rate relief against the steep rate increases that will come as an inevitable consequence of the IOU's cost of money. Our primary tool for injecting affordability into this picture is through revenue bond financing, with their dramatically lower interest rates. Some type of quasi-governmental body, such as a consumer-owned utility with the authority to issue revenue bonds, is likely our most promising path forward, at least where affordability is concerned. Instead of the delays associated with redundant report cards, Maine citizens need a bill that, one, boldly tackle our growing problem of affordability. 2, create a utility that's actually accountable to the ratepayers instead of an ethically and morally challenged utility that's currently in Maine Supreme Court trying to overturn the will of the citizens. And 3, catalyzes profound statewide efforts at countering the perils of our climate crisis. Thank you very much.
Thank you. Are there questions from the committee for Mr. Bilski? I don't see any. So we've had an hour of testimony in opposition. So we're going to go back to proponents. And again, we have numerous people to go through. So I'll just ask committee members to keep their questions concise. I've been on committees where people ask questions and say the question is make speeches, and the question is, do you agree with me? So that doesn't help us move along through the witnesses, and that doesn't help us get along to the end. So I'm going to ask people if they will be kind to the people waiting to testify to limit their questions to substantive questions and allow us to get through our list. I'll ask you to beam over Jeremy Payne and Oliver Tully.
Okay to go, Senator Lawrence?
Yes, go ahead.
Okay. Good afternoon, Senator Lawrence, Representative Berry, members of the committee. My name is Jeremy Payne. I'm the Executive Director of the Maine Renewable Energy Association. Here to testify in support of LD 1959. As you've heard from many others, and we certainly concur, it's abundantly clear to many customers of our investor-owned utilities that their service must improve and improve fast. Definitely do applaud Governor Mills and the bipartisan sponsors of this legislation for supporting these efforts to improve service reliability, customer service, billing, interconnection request processing, and storm-related service restorations. And I myself, somewhat coincidentally, have been without power twice in the last week, although only for about 5 or 6 hours. So interesting timing. But, to be clear, certainly don't believe that this legislation is perfect and don't believe that the administration has indicated that it is. I think there's ample opportunity for you all on this committee to continue to shape this bill so that it meets your goals. I would encourage you to do so, and happy to participate in helping you to do that if there's a role for us to play. Notably, the legislation looks to create the quarterly report cards on key metrics so that policymakers, customers, and most importantly, the investor-owned utilities themselves understand what is expected of them. Ultimately, the legislation looks to provide the PUC with the tools it needs to hold our utilities accountable for their effective and/or ineffective delivery of electrical service. If a utility has clear, consistent, and demonstrable underperformance at meeting or exceeding these metrics, the bill instructs the PUC to open an adjudicatory proceeding to determine whether to require the utility to divest. This is clearly a significant step with major ramifications and should not be taken lightly, as that type of outcome would have impacts for Maine's entire energy landscape, including the issues that I typically come before you on related to additional renewable energy. However, the fact that the governor has brought forward this piece of legislation demonstrates that there have been ongoing and significant problems with CMP's performance in recent years, to state the obvious. So while we support many of the areas of focus the bill speaks to, we recognize there are likely other items that should be considered. I think you've heard affordability pretty consistently. However, LD 1959 does create lots of room for the PUC to clearly implement the standards via rulemaking. This is the latest example where the devil's in the details. So if this bill does become law, we look forward to participating during the rulemaking portion of the implementation of this legislation over at the PUC, and respectfully urge you to vote to pass. I'll be happy to try and answer any questions you may have.
Representative Berry.
Hey, Mr. Payne, for your testimony. And on the matter of affordability, if we were to amend the bill to require a report card element on affordability, just for the sake of argument, would you recommend that affordability be focused strictly on the transmission and delivery system, or reach into the generation space, and if so, why? if you whatever your answer, please give a rationale.
Sure. I think the challenge with affordability, Representative Barry, is according to whom and when. So some people may have concerns about the cost of a particular source of electricity today, but it may have significant benefits over over its lifespan. So something that may cost a little bit more today may have tremendous payback and benefit to all consumers, particularly as it relates to having a consistent price over the life of a project. So certainly happy to participate in any of those discussions. I mean, I don't have any real specific ideas of what that affordability focus could or should be. But as the committee starts to hone in on that, as I suspect you will, I'm happy to offer you some additional perspective, but I don't have anything in mind off the top of my head.
Senator Barry?
Just to clarify, would it be safe to assume that you would prefer that we only look at affordability for delivery?
I mean, yes, we believe that the marketplace is the best place for the cost of electricity to be addressed. T&D rates has obviously been something that the PUC has been regulating for about 2 decades now. We would certainly encourage that to continue. But happy to consider any ideas that this committee may have. But yes, that's certainly where we have been consistently for many years.
Thank you. And one quick final question. The discussion around utility imprudence and its importance as a potential cost driver. Is it possible that employees or managers at renewable energy companies might have a valuable perspective to offer on prudence from time to time?
I think that's very fair to say.
Thank you.
Any other questions? Representative Foster?
Thank you, Mr. Chair, and thank you, Mr. Payne. I'm just wondering, in regards to affordability, would you agree that purchase of 1 megawatt of renewable energy at a lower price versus the same megawatt or type of renewable energy at a higher price would be beneficial to ratepayers?
Representative Foster, I knew we wouldn't have a hearing where I testify where we couldn't have a conversation alluding to net energy billing. So certainly happy to have a detailed discussion with you as it relates to the cost comparisons and benefits related to distributed generation versus grid scale. But as you've heard me say pretty consistently, I believe there's significant consumer benefits of both.
Thank you, Mr. Chair.
Any other questions? Seeing none, thank you very much, Jeremy. We'll go over to Oliver Tully.
Senator Lawrence, Representative Barry, members of the committee. I'm Oliver Tully, a policy strategist at Acadia Center. Thank you for the opportunity to testify today on LD 1959. Acadia Center is a nonprofit research and advocacy organization headquartered in Rockport, Maine, committed to advancing a clean energy future. Acadia Center testifies today in support of LD 1959. To better serve Maine's residents, the state must transform the way that utilities are regulated. This bill is a good first step in holding Central Maine Power and Versant Power accountable for their performance on affordability and reliability. But we think utility regulatory reform can go even further to relieve customer energy burdens and to ensure that the state's utilities are strong partners in advancing a clean energy future. Acadia Center supports the bill's proposal for regular utility quality service reports and penalties for substandard service. If designed effectively, performance metrics and penalties can help address the misalignment between existing utility incentives and state policy goals. The Public Utilities Commission is currently leading a proceeding to investigate utility performance metrics, docket 2020-00344. We encourage the committee to coordinate with the commission to develop performance metrics that prioritize environmental and equity provisions, including affordability, grid modernization, state energy and environmental policies, and distributed energy resource interconnection. In addition, Acadia Center believes that comprehensive energy system planning is essential and supports the bill's proposal that Maine's utilities proactively prepare for and respond to the impacts of climate change. In addition to the climate change protection plans, Acadia Center believes we need long-term energy system planning that comprehensively assesses Maine's transmission and distribution grid needs and the system upgrades necessary to achieve the state's emission reduction requirements while advancing equity and environmental justice. Acadia Center believes that all-encompassing energy system planning should be part of deeper reforms to ensure that utilities are better serve energy customers in the transition to a clean energy economy. Our organization has begun to outline potential reforms in a proposal called RESPECT, which stands for Reforming Energy System Planning for Equity and Climate Transformation, which addresses three problems as we see them. Energy system planning is conducted in silos. It ignores equity and environmental justice, and utilities have a financial interest in the outcomes of their planning decisions, creating major conflicts of interest. The proposal puts forward two reforms. Maine should conduct more comprehensive energy system planning that looks across fuels and resources to meet customers' energy capacity and thermal needs. And a new statewide planning entity should be established to coordinate long-term planning in a way that is neutral and independent and considers a broader range of stakeholder voices. While the RESPECT reforms are aimed at fundamental changes to utility regulation, LD 1959 is an important first step to create greater accountability for Maine's utilities and to improve utility performance. We look forward to working with you on the bill, and thank you again for the opportunity to testify.
Thank you very much. Are there any questions from the committee for Mr. Tully? Representative Grochowski.
Thank you, Mr. Chair. Thank you, Mr. Tully, for the testimony, especially the consideration that you gave to planning. I think that's a big concern for all stakeholders, and we've had a lot of questions about how to move forward with that. So firstly, if you have anything that we could look at with regards to your work on the RESPECT framework, I guess, I'd appreciate seeing that. But secondly, whereby all this bill asks for is for the utilities to engage in planning around climate resilience to protect their own assets. Do you feel like that's a step even worth taking without a bigger planning framework coming first? It just seems like I don't know how the two things would work together, and will it send us in the wrong direction, thinking that we're planning when we're only looking at a very small piece of the entire grid planning and modernization needs. So I'm just curious how you see these two things fitting together, if at all.
Sure. And firstly, we would definitely be happy to share more information on the reports. We were able to have a conversation with Representative Berry on it a number of weeks ago and would love to share more information. In terms of the climate planning, I believe that the way that the bill outlines assessment of climate planning is an important part of the broader consideration of issues around the impacts of climate change, but we do think that it is, as you say, one small piece of a much broader set of issues that needs to be considered in terms of potential impacts of climate change and the ways that utility activities can either mitigate or help to manage those impacts. So we think it is a broader conversation that needs to happen. And there are a lot of things that go into that assessment of long-term energy system planning.
Any follow-up, Representative Grochowski?
Yeah, just to be clear, so you think it's okay to start with that sort of, I would call it loosely structured and not very binding section of this bill to like do something while we think about a bigger, better planning mechanism? Like, or do you think that they're at odds?
I don't necessarily, I think that they're at odds. I might have to think more about it and follow up. Yeah, I'm at the moment, I don't have more to say in terms of timing or process, if that's what you're getting at in terms of how this is articulated. I think there might be ways to strengthen the planning components of this bill, but would very much be happy to follow up on that.
Any follow-up, Representative Grochowski? Representative Sachs?
Thank you, Mr. Chair. And I just wanted to reiterate actually Representative Grahowski may have said the same thing, but if the pieces of the RESPECT plan, Mr. Tully, could be forwarded before the work session, that would be incredibly helpful. So that I read your testimony. I'm particularly interested in sort of the end pieces of that. So if there's some materials you can forward before the work session, that would be most helpful. Thank you.
Certainly.
Representative Berry, question?
Thank you. Same topic. I am interested in the RESPECT framework and what it might offer. I do note that it's a third-party planning entity doing a much broader look than the utility, focused utility assets focus that's in this bill done by the utility itself. So would it be possible specifically to follow up on Representative Sachs' question to bring to the work session at least the outline of actual legislation? What would it look like? What would the entity be that would do the planning work? What would be the scope? How would it be? How would the plan be put together and approved? By whom would it be approved? How often would it be adjusted? I realize that's a lot, but we have about 8 weeks left in the session and only about 4 weeks left for the committee to do its work, perhaps less. So yeah, if you could get us something fully fleshed out, that would be ideal. I realize that's a lot to ask, and if we can't do it in this session, then it will wait until next January and a whole new legislature.
Sure, yeah, and I really
No
do
pressure.
appreciate that opportunity. We'll do all that we can to give you as much useful information as possible.
Thank you.
Representative Grahowski.
Thank you, Mr. Chair, and I'm just thrilled so many EUT colleagues are as excited about planning as I feel that I am. I think that's actually more important than a lot of the contents of this bill in terms of our energy future and providing cost-effective solutions for our ratepayers. But I am curious, and it sort of goes back to an original question I asked of Director Burgess. If your organization, in addition to telling us how to do planning in your view, has any evidence that a policy like this is actually effective in any other places in the United States, I just really feel like I need to understand and see evidence for this policy design in order to be able to better understand it and possibly support it in the future. So if, in preparing this testimony or another work you've done, you have run across any information like that, I would really appreciate that, because I'm just still struggling to be sure that this is evidence-based policy design. Thank you.
Sure, and if I could just ask to clarify, you're referring for other potential examples that might reflect what we're proposing in our RESPECT framework, rather than examples of the kinds of things that are articulated in the bill as it's written?
I guess both, and thank you for that clarifying question. I mean, you've come in saying you're supportive of this bill, so there's a lot of content in this bill, especially the report card, the penalties, all those structures, possible divestiture that seem really neat, but do they work? I'd like some evidence that that's the case, because we have compiled evidence that other solutions do work in other places and in the state of Maine. So I guess I would like evidence for any policies that come forward. And I'm only picking on you because your testimony was well constructed in my view, and I thought you might have some information to share in addition.
Sure, yeah, we'll definitely plan to send over what information we have. I will say that the kind of really fundamental changes we're thinking about in terms of long-term planning are quite novel. There are other examples from around the country where they're taking different forms and approaches to planning, and we could gather some of the information and send that over.
Great. Other questions from the committee? Seeing none, if you could have Pamela Corcoran come over and Phelps Turner. Great. Pamela, why don't you go ahead?
Thank you very much. I'm wanting to say thank you for your patience and your diligence as we've been working our way through the citizens who are offering comment. It's a long process and I really appreciate your service. Chairs Lawrence and Berry and the Joint Standing Committee on Energy, Utilities and Technology. My name is Pamela Corcoran. I'm from Belfast and I am a volunteer advocate with AARP Maine. As many of you know, AARP Maine is a nonpartisan and nonprofit organization with more than 200,000 members here in Maine. I'm here today to testify in support for AARP Maine of sections 1 and 4 of LD 1959. AARP Maine is pleased to support certain provisions of the governor's bill to mandate more accountability for utility service quality and customer service. Section 1 and 4 of the bill requires the PUC to adopt minimum service quality and customer service performance standards and publish routine reports on compliance. A serious penalty of up to $1 million can be imposed on the transmission and distribution company for failure to meet those standards. AARP Maine supports setting service quality and customer service performance standards. Our explicit policy urges state and federal policy makers to adopt minimum service standards and consumer protections that ensure fair terms and conditions for all utility and telecommunication services. Regulators should habitually report on utility performance, and those standards should include the key attributes of customer service and service quality identified in LD 1959. Of course, reliability is key to essential electric service, and we agree that the PUC should adopt specific and enforceable reliability standards. Furthermore, the consistent failures to meet reasonable standards should indeed be subject to stringent penalties. Please note that AARP does not take a position on sections 2, 3, and 5 of the proposed legislation. We note that section 2 appears to alter the standard rate-making policies that govern utilities. The commission is always empowered to initiate a rate case to review a utility's costs and revenues based on a test year and projected expenditures that are explicitly included in rates. However, it is a concern that this proposal might be viewed as allowing for a deterrence of certain expenditures without any finding of imprudence, a policy that might be questioned as unfair and potentially violating due process. With regard to section 5, AARP does not take a position on whether any public utility should be investor-owned or publicly owned, but rather we demand that any utility, regardless of its ownership structure, be required to provide affordable rates and good customer service. We do thank Governor Mills and the sponsors and co-sponsors of this proposed bill. Thank you very much.
Thank you very much. Are there questions from the committee? Representative Berry.
Thank you very much, Ms. Corcoran, for sharing that testimony with us. And I'm curious about affordability. I'm hearing from senior citizens in my district who are very concerned about affordability, both with the most recent spike in supply costs, but also with the ongoing, double-digit year-over-year increases in delivery, which is part of our utilities profits. And I was just surprised that ARP didn't come forward and ask for affordability to be one of the report card criteria. I was a little surprised also that the request from ARP to protect the utilities rights was mentioned. So I'm just wondering if you could comment on those two things. And I don't know if you're the one who drafted the testimony, or if it was someone someone else that you'd want refer us to for these answers. But can you comment on making affordability part of the report card, and on why ARP is concerned about protecting the utilities?
I can briefly, and what I will say as a volunteer and as a utility customer with a very limited income, that there's really a trifecta of challenges related to affordability, especially for senior citizens, relative to utility costs, medical coverage, in particular prescription drugs, and finally, a concern about managing overall inflation as it relates in particular to food security. So affordability is key. It is important. The specifics about the position of AARP, as you may know, is a deliberative process that involves staff as well as volunteers' experience. And so in that regard, I would suggest that Japhet Els, our Associate State Director, be made available to participate in your work session to address affordability and the particulars related to utility. Does that address your concerns, Representative Berry?
It gives me a person that I can speak with. Yes, thank you.
Okay. And I will make sure that he's aware of that request.
Thank you very much.
Any other questions from the committee? Seeing none, thank you very much.
Thank you.
And we will now go to Phelps Turner and Rebecca Schultz.
Thank you, Senator Lawrence, Representative Berry, members of the committee. My name is Phelps Turner and I live in Portland. I'm a senior attorney at Conservation Law Foundation. As many of you know, CLF is a member-supported organization that works to ensure that laws and policies are developed that protect and restore our natural resources, that are good for Maine's economy and environment, and that address the climate crisis in a manner that recognizes its urgency, all in a just and inclusive manner. I've submitted written testimony to the committee on behalf of CLF, and I'll focus briefly on 2 points today. First, LD 1959 is an important step toward greater accountability for our electric utilities. And second, LD 1959 can be strengthened to ensure even greater accountability. We appreciate the efforts of the administration, the bill's presenter, and its co-sponsors in bringing LD 1959 forward, because it does improve oversight and accountability for our electric utilities. These utilities play a key role in our power system, but there is much room for improvement in their performance, and we need additional mechanisms to ensure improved performance. LD 1959 provides some of those mechanisms. For Maine to comply with its energy and climate laws, our electric utilities must provide a reliable power system. Significant reductions in greenhouse gas emissions will come through the electrification of our transportation and building sectors, but this will only be successful if our electricity service is reliable. LD 1959 will help ensure our utilities provide a more reliable system, which is necessary to support economy-wide decarbonization. Turning to my second point, we believe that LD 1959's aims can be further advanced by adding 2 sets of requirements. First, by adding several categories of utility performance. While the bill calls for the development of minimum standards in several important categories, including reliability, as I just discussed, it would not require performance standards in several other important categories, some of which we've already heard about this morning: affordability, grid modernization, state energy and environmental policies, and expanded consideration of interconnection. Several other jurisdictions are exploring and have developed effective quantitative performance standards in all of these categories, including report-only standards. And LD 1959 should be expanded to include these categories so that Maine can adopt similar standards. Development of metrics in these categories is more appropriate for PUC, Public Utility Commission rulemaking, but the bill should provide direction to the commission by including these categories. And I refer you to my written testimony where I provide further details on each of these categories. Finally, in addition to the utility resiliency planning required in Section 6 of the bill, LD 1959 should be expanded to require utilities to conduct regular, ongoing planning on how they are pursuing and advancing climate change mitigation. Thank you. I look forward to any questions.
Thank you. Representative Berry, your hand has been up throughout his testimony. Do you have a question or did you just forget to put it down?
I forgot to put it down. Thank
Okay,
you.
great. Are there other questions from members of the committee? Representative Grochowski.
Thank you, Mr. Chair. And I think you probably heard my question to the previous testifier, Mr. Turner. If you have any evidence of policies like these working in other places to actually improve service quality, cost, climate mitigation, not just resiliency planning, I'd be happy to look at that information so I can assure that our constituents are getting real positive gains from policy that we might pass in this committee.
Thank you, Representative. It's a great question. I did hear you pose it to Mr. Tully. I provided some examples in our written testimony. I'd be happy to speak with you separately about those and others, and also happy to participate in any work sessions that might be helpful. There are several jurisdictions, as I just mentioned, that are pursuing performance-based regulation, either on a limited or a broad scale in various parts of the country. Particular highlights would include Hawaii and New York State, but others might include Illinois. And certainly the regulatory context in which some of those performance-based changes are happening are different than here in New England, in particular in Maine. But I think there are lessons to be learned. Many of the initiatives are newer, so the results are not necessarily on their effectiveness, but I think there are several jurisdictions leading the way on this, and I think Maine has a chance to be a leader here. And Mr. Tully also referenced an important docket that the Public Utilities Commission has been pursuing on performance metrics, and I think there's opportunity there that hasn't advanced as far necessarily as we'd like to see it, but there is that docket that's open, and I think this bill could really empower the commission to do more in this area.
Thank you. And I would just follow up by saying that, yes, and I appreciate what's in your testimony is largely about things that you suggest we add to the bill, but not so much, I think, about what is already in the bill. So having that background about those items would be helpful. And yeah, I'm a little bit concerned about performance-based rate making and what the cost implications of that will be to our constituencies. So it's kind of hard for me to say, I appreciate that you recognize that there may not actually be evidence that it's effective since it's newer in these jurisdictions, but if there is evidence, or maybe even elsewhere in the world, I'd be interested in know that, because I'm very worried about our rates, and that adding incentives to do basic quality service is maybe not what our constituents need. Thank you.
Yeah, sure. Yes. Thank you again, Representative. And I think that there's also, as I alluded to in my oral and written testimony, there's a spectrum of options. It doesn't necessarily just have to be financial incentives. There can be penalties. There can be report-only metrics. There's a spectrum of options available. And certainly one of the reasons that we added affordability in our comments, in our testimony, is that we think that as the Maine Climate Council recognized, we need a reliable power system, but it also needs to be affordable. Otherwise, this is not going to work. And decarbonization, it cannot be equitable without affordable rates.
Other questions from the committee? And next we have Rebecca Schultz.
Hi, hello, Senator Lawrence, Representative Berry, and members of the committee. My name is Rebecca Schultz, and I'm the Senior Advocate for Climate and Clean Energy with the Natural Resources Council of Maine. I'm testifying also in support of LD 1959 with suggested changes to strengthen the legislation. We believe that the bill provides an opportunity to establish a framework that requires Maine electric utilities to perform, face penalties, or be replaced, but it needs substantial amendments to be successful. We believe that the Our Power referendum can proceed on a separate track. That process will allow Maine people to decide which business model our electric utilities should follow, investor-owned or consumer-owned. But strong accountability and performance measures should apply to either approach. And this bill provides an opportunity to put those measures in place now. My testimony will focus on 3 areas where the bill should be improved: the performance metrics, which need to reflect the state's statutory greenhouse gas reductions and clean energy targets; the pathway to divestiture, which needs to be viable, and the planning obligations, which need to address climate mitigation, the integrated or holistic transmission and distribution planning. So with respect to the performance report card, the PUC should be required to open a rulemaking to develop metrics across a comprehensive suite of performance categories, including, as we've talked about, affordability, distributed energy resources, grid modernization, and support for Maine's climate policies. The PUC should assign penalties, but also, as Phelps just said, report-only conditions for metrics that it develops in each of these categories. Report-only conditions can be useful to gather data and establish benchmarks, track progress in complex areas of power sector transformation, for instance. Importantly, the penalties must be levied automatically for a subset of essential service standards. The point here is to be objective, forceful, predictable, to send strong signals to the utilities to realign their profit motives. As it's currently outlined in the bill, an adjudicatory proceeding should be launched to determine whether or not penalties are necessary in the event of a failing scorecard, and that seems excessively burdensome. With respect to the divestiture, similarly to the penalties, the PUC should be required to set a clear and unequivocal threshold for poor performance that would trigger an adjudicatory proceeding for divestiture. In deciding whether and which proposals to consider, the Commission should explicitly take into account the achievement of the state's climate goals. And then as to the consumer-owned provisions, we view that the current process as it's laid out in the bill to be unfeasible with the 5-member committee. And we recommend that Section 5, subsection 2 be stricken from the bill to prevent potential confusion and or conflict with the ongoing referendum effort. We encourage the committee to provide legislative oversight in the event of a divestiture order, and that might be a way to ensure that a private option is not the only option. Private sale is not the only option. And language, especially pertaining to the standards and planning pieces, should be screened for compatibility with the consumer-owned utility referendum language. And finally, on climate change planning, as has come up just now a couple times, this section should be expanded to include integrated transmission and distribution planning to achieve the state's climate goals. These planning activities would be a cooperative effort between the PUC, Efficiency Maine Trust, and the utilities, including load forecasting that incorporates beneficial electrification, load flexibility, distributed energy resources. These periodic plans should be used by this PUC to ensure that utility operations and investments align with state climate goals and to inform the development and revision of these performance metrics. So it's really the cornerstone to the whole piece of performance. We believe that a new operational planning division should be established at the PUC to support this work, staffed and resourced accordingly to make sure that the PUC has the capacity it needs to review, evaluate, and align utility plans with long-term public policy objectives. So in closing, we support the core concepts of accountability that are motivating this bill, but believe that it must be significantly strengthened to achieve its purpose, and recognize that key decisions will be made in rulemakings, but the statutory language needs to be strong to steer those outcomes, to curb PUC's discretion, but also empower it to act boldly. Thank you for the opportunity to testify on this.
Thank you very much. Are there questions from the committee? Representative Barry.
Thank you. Thank you, Ms. Schultz. I wanted to ask if you could elaborate slightly on what is meant by in the event of a divestiture order, the bill should provide for legislative oversight, including an opportunity to ensure that private sale is not the only option. I concur that the process laid out is not feasible because of the complexities that need to be established, and obviously this committee tried to do that with another bill, but how exactly would legislative oversight provide that opportunity, given the time frame and the complexity of an acquisition, as we've recently experienced in the case of Versant, for example?
I mean, I think that's right. I think it's not really viable the way it's outlined right now. And so if there were to be an adjustment here to permit a review of applicants or review of the process somehow by the legislature. Perhaps that would be a way to make sure that things are thoughtful enough at that juncture. I'm not really sure. I think I'd have to give more thought to it, but mostly the thing that I want to express is that we should be trying to ensure that this does not conflict with the referendum effort at all, and that it's applying a oversight and accountability framework that can apply to either an IOU or a COU.
A follow-up, if I may,
Any
Mr.
follow-up
Chair?
question, Representative Berry?
Yes. I think the key phrase I'm still puzzling over is an opportunity to ensure that private sale is not the only option. What would that look like? How would that work?
You know, I don't know. I need to give it more thought, but I think the lack of legislative oversight in this whole process is what is striking. And rather than have the determination and evaluation of the bids all rest with the PUC, it seems to broaden that conversation so that there is more public input and accountability with respect to making those decisions and ensuring that bids across a range of considerations be taken into account. But I can give more thought to that and get back to you.
Could you, and for the work session,
follow-up?
Thank you. Yeah, for the work session, if you could flesh that out with some, at least bullets, preferably language, that would be great. Thank you so much.
Representative Foster.
Thank you, Mr. Chair. And thank you, Ms. Schultz, for your testimony. I'm curious, you mentioned expanding the planning obligations of the utilities to include integrated transmission and distribution planning for climate mitigation. I'm wondering how we would hold them accountable when, at least in the last few years, the legislature has managed to jump in the middle of things and change. Change is happening all the time with what the utilities have to react to in regards to the renewable energy that we ask to be built up, and location and so on and so forth. So it's a big concern of mine as well that we need a detailed plan, but I'm wondering why you would think that the utilities need to be held accountable for that when there are a lot of other people with their fingers in the pie, so to speak, that can change things that they are not responsible for. Thank you.
I think the point is that because of the urgency and speed at which the power sector must transform right now, there are many considerations at many different timescales, be them 2 years or 5 years or 10 years, that need to be taken into account in order to ensure that cost-effective decisions the appropriate decisions are being made at every juncture for cost-effective investments and operations. And so I think that there is a conflict of interest there. That's why this question of who should do the holistic integrated planning always sort of holds up conversations, because it shouldn't rely exclusively with the utilities, because these public policy objectives are not the utilities' objectives necessarily. And so that's why a lot of thought has been given to this in the MRDI process, for example, which was a broad stakeholder set of discussions. Maine Utility Regulatory Reform and Decarbonization Initiative with us last year put out a list of recommendations, and top of the list there was holistic integrated planning. So there's broad consensus that we need planning, long-term strategic planning, in order to do this cost effectively. So this seems like a smart way to put that in place now, to begin moving in the right direction, regardless of the ownership structure of the utilities.
Thank you.
Any follow-up, Representative Foster? Okay, that completes testimony of those in favor of the bill. We're going to be breaking in about 6 minutes for our 1 hour lunch. Actually, I'll ask committee members, are you willing to have it be just half an hour, given how much we have to go through? And I'm seeing everybody say yes. We have about 30 people left to testify, but before we break, we haven't gone to neither for nor against, and there is one person in the neither for nor against. It doesn't seem to be representing an organization that just seems to be here from Bath. So I'm going to go to her and see, I believe it's a her, see if she's can testify now. I think it's Jean Gazzetti. Can you beam her across if possible, Jason?
Yes, she should be coming.
Okay, for testifying neither for nor against. Jean, are you there? I'm not sure she is. So what I will suggest is that we just go right back to having our break, and we'll be back at 1:30. And we have about, as I said, about 30 people still willing to testify against, and about 5 or 6 people neither for nor against. I just wanted to take a moment to remind committee members about the joint rules. While the joint rules do say that while regressive and probative questions may sometimes be appropriate, members shall exhibit respect for the witnesses and for one another. And it says that members shall refrain from interrogation that is argumentative, oppressive, repetitive, unnecessarily embarrassing to hearing participants. I'm not going to put Senator Stewart on the spot and ask him what a leading question is, but to the extent we can, avoiding leading questions. And leading questions is, you know, saying something, given X, Y, Z, and A, B, C, isn't it true that your position is incorrect? That requires a leading question, requires a yes or no answer. That tends to be an argumentative question first. It doesn't add anything to the debate, the discussion. So our questioning needs to be focused on getting more information out of the people testifying that will be helpful in making our decision, and should not be an opportunity to debate or to show our skills as the next Perry Mason. So with that, I'll send everybody off to lunch and ask us all to be back at 1:30. And if you could mute and turn off your video, that would be great. Thank you. Okay, I'm going to ask people who are on to come back on and to be Cherry Representative Cuddy. Smile. Okay, we got 1, 2, 3, 4, 5, 6, 7. So I think we're ready to start up again. Everybody feels refreshed and has the energy they have to do this afternoon. No pun intended. Jason, you there? You all set?
Yes, I am.
Okay. So what I would propose to do is, we haven't heard from anybody, neither for nor against, and I hate to make them wait all this time, but we do have numerous members of the public who want to speak in favor. So I'm going to try to pick and choose, against people from the public who wish to, don't look like they're representing an organization, but look like they're here as average citizens. And I'm going to see if I can pick and choose enough to testify. We'll have probably a half an hour of testimony, and then I'll go over to neither for nor against. So I don't have the ability to scroll down through all the attendees, Jason. So I'm just going to call out some names and you can tell me whether they're still there and interested in testifying. So let's go with Ezra Sassaman.
I'm promoting him. I'm promoting him
Ezra
now.
is still there.
Yep.
And then we'll go with Faith Woodman. Good afternoon, Ezra.
Ready?
Ready? Go ahead and testify.
All
Let
right.
us have it.
Thanks for having me. Senator Lawrence, Representative Berry, and members of the Joint Standing Committee on Energy, Utilities, and Technology. My name is Ezra Sassaman. I live in Bar Harbor and work for two Maine-based climate groups, the Climate to Thrive and Maine Youth for Climate Justice. I support accountability, democracy, transparency, and public participation in all aspects of government. My work at Maine Youth for Climate Justice supports young people who want to engage with the political process and advocate for environmental justice policies in our state. Just as we intuitively understand the importance of democracy when it comes to our system of government, we need to draw from that same spirit of public participation when it comes to utilities. In my view, LD 1959 does not do enough to further this democratic spirit. Instead, the bill largely keeps the existing centralized system in place where power is concentrated in the governor's office. The bill as written also maintains reliance on the PUC's existing powers to improve and regulate private companies such as Central Maine Power and Versant. The PUC, however, is unelected, unaccountable to the Maine people, has already failed to use its existing powers to address steadily growing transmission and distribution costs caused by these two companies. This is one of many reasons why we need an entirely new system of accountability and transparency. As you've heard before, there's already a plan to achieve the most important goals laid out in LD 1959, a bipartisan bill to create a statewide consumer-owned utility passed Maine's House and Senate, but was unfortunately vetoed by Governor Mills. This plan will likely become a citizens' initiative next year. In contrast to LD 1959, this plan includes important details regarding taxation, workers' protections, governance specifics, and a more complete planning process in terms of transitioning to a consumer-owned utility. Additionally, a statewide consumer-owned utility would allow for more accountability, democracy, transparency, and public transportation in Maine's energy future than a strategy that keeps private companies like CMP and Versant in place. In addition to its other shortcomings, LD 1959 does not address Maine's exorbitant electricity rates, and does not focus enough on environmental issues. Meaningful reform must prioritize working with a utility that's a leader and a partner in innovative grid technologies, from solar to storage to other resilient environmental solutions. Young people, above all, understand the importance of serious, tangible strides to meet decarbonization goals that science demands. We also understand that large private companies like CMP and Versant are often more interested in protecting their profits than supporting renewable power generation. Any plan that does not significantly challenge their power does not go far enough. For the above reasons, I urge you to vote ought not to pass as drafted on LD 1959. Thank you.
Thank you very much, Mr. Sassaman. Does anybody from the committee have any questions? Seeing none, thank you for coming to testify. We'll now go on to Faith Woodman.
Good afternoon, Senator Lawrence and Representative Berry and other distinguished members of the committee. My name is Faith Woodman. I live in Bath and I'm a constituent of Senator Vitale. I'm here on behalf of the Maine Unitarian Universalist State Advocacy Network, or MUSON. Thank you for the opportunity to speak in opposition to LD 1959. This bill is well-intentioned, but it doesn't deliver the results we need. I don't need to tell you that the public is surly and angry about our high electricity rates, and there's a perception that the PUC historically has given a free pass to CMP and Versant to the public's detriment. Furthermore, the PUC, whose members are appointed by the governor, is not accountable to the public, although this bill would give considerable power to it, and especially to the governor through appointments. It would also cut out the legislative oversight and public input. Never a good idea when checks and balances are essential for a well-functioning democracy. Nor does the bill deal with our most pressing problem, high rates. A great many Mainers support a consumer-owned utility to replace CMP and Versant. This bill jeopardizes that. Don't mess with it. We need transparency in rulemaking, and missing from the bill are clearly defined, quantified standards that should not be left to manipulation by PUC insiders and influenced by utility lawyers. We already know that CMP and Versant are failing. We don't need an extensive and costly process to tell us that. Also, we want real constructive results and best industry practices, not the standards that are set by the utilities trade group, the Edison Electric Institute. Their aim is to look out for the utilities' best interests, and they have more than a $9 million lobbying arm to influence legislators and regulators. If this legislation is adopted, it will do little to hold our two largest utilities accountable, and certainly not in a timely manner that would reduce high utility charges and provide a clear path to divestiture if Versant and CMP continue to fail. With its weak regulatory rules and tax accountability, it would not do enough to ensure future progress in reducing our rates, assuring reliability, and meeting the state's climate goals. Please don't give the public false hopes that this bill will provide the accountability and results we need, because it won't. I urge you to vote no on LD 1959. Thank you.
Thank you very much. Are there questions from the committee for Ms. Woodman? Seeing none, thank you. We'll go to Gordon Weil of Harpswell and then John Clark of Holton.
Mr. Chair, I think that Mr. Weil may have dropped off, so we can try to get him back.
Right there.
Oh, I was wrong. He was in cyberspace.
Gordon, are you there? How about John Clark? Have you found him?
I'm trying to bring him over, but he must not be acknowledging the promotion.
Okay. I'll keep going. How about,
Hello?
There's Gordon. Go ahead, Gordon.
Senator Lawrence, Representative Berry, and honorable members of the committee. My name is Gordon Weil. I live in the town of Harpswell. I'm testifying as a private citizen. I'm not going to go into a great deal of my relevant experience other than to say I was the state's first public advocate and I was involved in the negotiations that led to the creation of ISO New England. This bill is not serious. It's an illusion. People are given the impression that this is a way to hold utilities accountable. And I think that's probably the intent, but it doesn't work. And the principal reason that I'm testifying against it, that demonstrates how lacking in seriousness it is the bill in its very first section talks about performance report card for T&D utilities in the state. That includes consumer-owned utilities. There's no problem with consumer-owned utilities in Maine. There's no need to make them go through this process of quarterly reporting and being held accountable. It's interesting that recently the state government proposed providing assistance to low-income customers of CMP and Versant. Never made a proposal to do anything for low-income customers of COUs. Why? They don't need the help. The COUs have much lower rates to begin with. COUs can be used as a benchmark. They can be used to measure the performance of the investor-owned utilities. That's done in other states. That's the standard. That's the expectation. A lot has been said in opposition to this bill that makes a great deal of sense, and I won't repeat it. But one thing that is worth noting and why this won't work is the need is now. Consumer concern is now. Rates are high. Reliability is low now in 2022, and it's been in the last decade. But this process has no end. Reading the bill, there's not a deadline in it. This can go on, performance reviews can go on for years, and the PUC can find that the performance is adequate, or can use its discretion and simply say, we're not going to move on this. The PUC is not the right body for this. This has been stated by others. I won't repeat it. This is a judgment that should involve representatives of the people or the people. And they're nowhere in there. There's only one elected official in this bill, and that's the governor. The governor appoints the PUC, appoints the committee that's established, the majority of the members of the committee that establishes the consumer-owned utility. And there is no role for the legislature. You pass this bill, it allows for routine technical rules on one of the most important utility decisions ever made in the history of the state. The rules of the PUC would just be routine. The legislature doesn't have to review it. And the reason we're told that is we're in a big hurry. You don't have time for the legislature to do that. If we're in a big hurry, where's the deadline in this bill? When does it end? When is the decision made by the PUC? Purely discretionary, doesn't ever have to be made by the PUC. And what does it cost? There is no cost here, and it's a guaranteed rate increase, this bill, because to pay for the study of the consumer-owned utility alternative, to pay for the additional staff that the PUC must need, unless they're all sitting around doing nothing, which we know they're not, then you need more people. You need to pay them. Who pays them? Ratepayers. It doesn't go to the taxpayer. It goes into the electric bill, these costs. So where's the mention of that? It's fine to say this is a good idea. It'd be nice to say how we're going to pay for it before we get carried away with what is in fact not a good idea. It's an illusion. It won't work.
But you can't see it. Thank you very much, Gordon. Are there questions for Mr. Weil from the committee? Seeing none, thank you very much. Oops, sorry, Representative Grochowski.
Thank you. It sometimes takes a moment to find all the buttons in the right order, as you all will know. Thank you, Mr. Weil, for being here. You mentioned that the consumer and utilities don't need to be included in this bill, or at least the first section where they were not explicitly excluded because they already have such great performance and their customers by all accounts I hear, are very happy. Is there anything we could learn from the consumer and utilities regarding standards that they meet on a day-to-day basis that would be useful in evaluating our investor-owned utilities, as opposed to asking the industry itself how to evaluate them?
Yeah, yes, Representative Gahowski, that's what I alluded to. Frequently, you'll find in the literature relating to consumer-owned utilities that they are the benchmark or the yardstick by which utilities ought to be measured, because their owners are their customers. They have no fiduciary responsibility to shareholders outside of their customers. And as a result, they have every incentive to be efficient and to keep rates down and service good. As a result, they can be used as a standard of measure for utility performance. I have to note here with regard to consumer utilities in this bill, in fact, it's theoretically possible in the later section of the bill when you get to evaluating who can take over a utility. Again, it's not about CMP and Versant, it's about T&D utilities. So you literally could have this process result in an investor-owned utility at the order of the PUC taking over one of Maine's existing COUs without ever consulting the owners of the COU, namely the members, because there is no public participation in the decision-making process here. So yes, because the public owns the utility, they operated in a way that is inevitably in their interest. And what's their interest? Has been said before, reliability at the lowest possible cost. It's a good benchmark that could be used for IOUs.
Representative Berry, a question?
Yes, thank you, Dr. Weil. It's been said here today, I can't remember by whom, that this bill as written wouldn't affect the referendum that you referred to. Is why not do both?
Well, I'm not going to comment on the referendum because I know that's another issue. Senator Lawrence is very careful about that. But I will say why they shouldn't do both is because you shouldn't do this. The referendum is whatever it is. This is an illusion. This is not serious, this bill. The substance here is non-existent. When you have a process where you have people who are not politically responsible to anybody, the legislature is born. You pass this bill, you don't have another role in it until the end when it's done by the PUC. So it's not serious in that respect. And clearly the people themselves have no say in this. Show up at a hearing, with due respect, you're listened to, but you have no idea whether your views are taken seriously. So there is, the answer to your question is, I don't know why you should do both, because you shouldn't do this one.
Other questions for Mr. Weil? Seeing none, thank you very much. We'll go
Thank
to.
you. I apologize. I had a quick follow-up, if I may. I was muted.
Go ahead, Representative Berry.
Thank you, Dr. Weil. There have been some suggestions that
just one moment. I hate to interrupt you. I've already put him back to attendee. I'll have to bring him back over.
We're moving fast.
And of course,
and he'll have to accept it. It's all right. I can follow up with him offline.
Okay.
Thank you, though.
My apologies.
We'll go to John Clark, who is coming us. Are you coming to us from Linnaeus or Holton? You need to unmute yourself, John.
Okay, can you hear me now?
Yes, are you coming to us from Linneus or Holton?
From Holton.
Great.
Linneus is a suburb of Holton.
I know it very well.
And, oh, you do? Okay.
Yeah.
Well, anyway, my name is John Clark, and I'm retired from the Holton Water Company as the general manager, having spent 32 and a half years here. My education and work background is in engineering and business. And Senator Lawrence and Representative Berry and committee, thank you for allowing me to testify. As you know, I'm in opposition to this bill, and I have to echo a lot of what Gordon Weil just told you. Gordon and I have fought many a war against the old Maine Public Service company, and we actually won every time. But regardless, I think I have written testimony and I have sent that in, but I'm going to concentrate on two areas. I heard Senator Bennett earlier this morning saying this bill was a sham, and I agree with him. I believe the bill is being put forward only so the governor can say, look, I'm doing all I can to keep rates down. We're going to give the PUC more regulatory authority. So with regard to this referendum coming up, you can forget that. It doesn't. It's not going to have any consequence because this will take care of it. I think the PUC presently has all the tools it needs to. I say shame on the PUC for not doing their job. If you had the tools there, which was alluded to by Bill Harwood, who I respect a lot, and Bill said that they actually have the tools, but they're not using those tools. So that's, if you got them, use them. The other thing I'd like to point out is this bill lumps COUs in with the CMPs and the Versants of the world. And COUs are completely different. First of all, their boards are elected by the citizens of their communities. Those boards have the ability to change management and set policy. And if the board does not do their job, the board is voted out. So the ultimate hammer of control is with the citizens. It's not with stockholders, unlike CMP and Versant. It is with the customers. The other part of this is, as Gordon Weil said, you take away local control. You lump COUs in with this, and they lose control of their utility. They can be sold without their consent. So to me, this is ridiculous. Those are the main 2 points I'd like to make, and I'll open it up for any questions.
Are there questions from the committee for Mr. Clark? Representative Berry.
Thank you, Mr. Clark. Is two questions. You're retired, I believe, and you're testifying as a private citizen, but is Holton Water Company, are you aware whether your former company, Holton Water Company, will be represented here today?
Yes, well, unfortunately, Ben Smith has submitted testimony. It's written. Ben could not testify live today, but he and the existing general manager of the Holton Water Company is sitting right here beside me. And if you have questions for him, I'd be glad to put him in this chair.
Thank you.
Sherman.
Thank you. Good to see you, Mr. Sherman. I just wanted to make sure that that if it's a technology issue, which I understood it might be with Ben Smith, that we offer to accommodate him however possible. I understand it was a broadband issue, so perhaps a phone line is possible. I'm not sure. We'll have to look into it.
I can respond. I had a meeting today, an appointment actually that I could not miss, so I didn't know how long this was going to take. So I asked Ben Smith, our attorney, to speak on my behalf. Deb Hart is here as well. She's going to speak on behalf of the COUs, which we are part of. So if you have any questions, I reiterate, I'd say ditto to what John and Gordon were speaking on. I think the COUs are a different animal and they need to be left out of this bill. We're very responsive to our customers. If there's a complaint, somebody can come in, knock on my door, as they did for John for 32 years. If there's any issues, they come talk to him, and if it's not resolved, it goes to the board. So, you don't have to, wait for the PUC to fix your problem.
Yeah, the model for success with electric utilities already exists in the state. As Holton's rates are half of what CMP's are. The energy rates are half. Now that's not luck. That's been going on for years. In the last 14 years, we've saved our customers over, that's the last 9 years, saved our customers over $14 million on standard offer alone, which has nothing to do with delivery rates. So, this is not rocket science, okay? It can be done.
Yeah.
Other questions for Mr. Clark?
Just one last clarification. So that's 14 million over roughly how many towns?
5.
9.
Five towns. Our load's about 20 megawatts.
Yeah.
We sell about 120 million kilowatt hours a year. So, and our current rate, our all-in rate, including the standard offer rate, is 10.5 cents compared to 20 some for CMP and Versant. So, and it's not because of me; it's because of the gentleman sitting right here, all the hard work he did for years and years and years. So,
well, it's not me, as you all know, it's a team effort. We've had good people working here for years and continue to have good people. So there's no one person does anything.
Thank you very much.
Any other questions for Mr. Clark, Representative Foster?
Yes, thank you, Mr. Chair. In regards to those savings for your ratepayers, can you tell us what type of energy production is involved? What you're buying, where you're purchasing your power, what type of energy is being supplied? Thank you.
Today, it's coming from NB Energy Marketing, and it's 86% renewable. So they have hydro, they have wind, they have all those facets. So we're beating, the state mandated numbers that are what, by 2030, I think we had to have a certain percentage. So we're at 86% today, based on where we're getting our energy.
Thank you.
Any other questions for Mr. Clark? Seeing none, thank you very much. So we'll go to, actually, if you could bring Deb Hart over and then Jill Lindsay. Hi, Deb. Go right ahead.
Good afternoon, Senator Lawrence and Representative Barry. Hold on just a minute. My name is Deborah Hart. I'm a resident of Manchester, Maine. I'm speaking to you today on behalf of all of the Dirigo Electric Cooperative companies that, as you know, include Holton, Eastern Maine Electric, Kennebunk Power and Light, Madison, Van Buren, and Fox Island Cooperative, and we are speaking in opposition to this legislation. Attached to my testimony is an outline of the structure of the companies. I think I said that separately to you. It's titled Additional Information. It talks to you about the structure of each one of the utilities, whether they're a municipal, quasi-municipal, or a cooperative, how their boards are set up, how many years they serve for. As you know, Section 1 of the bill sets up a performance report card based on standards for operations for reliability of service, timeliness, and other things. The COUs believe that reliability of service, attention to consumer complaints, billing issues, and service restoration are all taken very seriously, and that's why there are so few customer complaints in the COU territories. I unfortunately was between this committee and another committee all morning, but for the time that I was with you on and off, I never heard a consumer-owned utility mentioned when they were talking about issues with these issues of reliability and billing complaints. We just haven't heard them. We don't see an added value for these type of reports. It would definitely cost the utilities some time to have extra people to put on board to have these quarterly report cards. quite frankly, the makeup of the boards of directors is such on these utilities that you already have the oversight. If the managers of these utilities are not doing a good job, they won't be there anymore. And that reliability of service, et cetera, will be taken care of. We are appreciative of the fact in section 2 that you took the COUs out of it by saying that it was a utility that served fewer than 50,000 customers. So by taking us out of the audit provisions, we feel that you've already in some way insinuated that that's not a problem for us. The COUs do have utility contractors that they employ for things such as a very, very large project, tree trimming. However, those are not under the control of the utility. So to have them give the rights of an employee, we think is very problematic. We go down to section 5 on divestiture. A little troubled about that because it says that you can take over an IOU and sort of make them a COU, but we're already COUs. So we're not sure what would be served by us being a part of that section either. Actually, one of my companies, and I haven't had a chance to check with every one of them to go through their private and special laws, but one I know already has a provision in place in their charter for divestiture if something were to happen. The 10-year plan addressing climate changes. We appreciate the fact that everybody is talking about climate change, looking outwards. Right now, the COUs are not building high power transmission lines, and they don't have huge fleets. So we could put something together, but it seems again to be a little bit that it's not something that is so important for these small utilities. I did hear this morning someone mention penalties going to shareholders and not ratepayers. As you know, the COUs do not have shareholders. Their shareholders are their ratepayers. And I think that's about all that I have right now. I do want to correct one thing just for the record. Versant and CMP were approached to give assistance to their low-income ratepayers, as you all know recently, by way of getting an amount of money back on their bills because the rates are very high, and we're in a little bit of a different situation. But having said that, the companies that I represent, as you know, represent very, very rural parts of the state. And so to that end, I have spent the better part of the last week with others in my group working to see if we can somehow take advantage of that for our low-income ratepayers also. Even though the utility rates have not gone up that high, their energy rates, their fuel oil, their transportation rates, everything certainly has. So we're working with a group of people to see if we can correct that. So I just wanted to bring that to your attention. I'd be happy to answer any questions. I do hope that you'll consider our comments, as you always do, with these small utilities that I think, you know, are really kind of a gold standard of how to do things well. I'm very proud of them, as you can tell. That's all I have for you.
Are there questions from the committee for Ms. Hart? Seeing none, thank you very much. We'll go to Jill Lindsay. Jill? I think, Jill, we need you to unmute yourself.
Sorry. Senator Lawrence, Representative Berry, and distinguished members of the committee. My name is Jill Lindsay. I live in New Harbor, and I serve as co-chair of the Climate Change Group for the Maine Unitarian Universalist State Advocacy Network. I'm here today on behalf of our statewide organization to express our very clear opposition to LD 1959. We've had the opportunity to read Gordon Wile's very thorough analysis of the bill in his article in the Maine Monitor, as well as hear his presentation on the bill. We take Dr. Wile's analysis very seriously. Why do we need to create a report card now for CMP and Versant when they have so consistently over the course of a number of years failed time and again by their own industry standard? What new revelations are going to come from the very drawn-out process that this bill outlines that we don't already know, a process that offers no deadlines. There's a much larger and growing number of Maine voters who are paying very close attention to how state government is handling our utilities than many may realize. The referendum vote last November to stop the CMP corridor project should be a wake-up call to everyone in state government. The public no longer wants to do business with CMP. We're tired of their high-paid lobbyists and lawyers, their deceptive ad campaigns, their lousy service and exorbitant bills. We want and need a change. We don't want a bill that appears on the surface to hold CMP accountable, but on closer examination really doesn't. We don't want a bill that hands all of the power over to this process to the governor through appointments to the PUC and public advocate and removes legislative oversight and a mechanism for public input. Some of us are opposed to the bill are motivated by our very serious concerns about what's happening with climate change. Our window of opportunity to act to stop it from getting much worse than it could be is rapidly closing. And climate change is all about energy use. Addressing this critical issue should be central to this bill, and it's not. And there are other issues that unite all Mainers. Everyone is concerned about local control of our energy and the rising costs of our utilities. It doesn't matter if you're a Democrat or Republican or an independent. We're all concerned about rates and how expensive our energy costs are now and are going to be in the future. If we're looking for a win for the people of Maine, how about a bill that directly addresses those concerns? Thank you.
Thank you very much. Are there questions from the committee for Ms. Lindsay? Seeing none, thank you. And we'll now go on to Linda Loomis and Lee Henry. Are either of those in the attendees list still? I see Lee Henry is. And then after Lee, if we could do Marty Fox. So Lee, you have the floor. Why don't you go ahead?
Great, thank you. Good afternoon, Senator Lawrence, Representative Barry, and distinguished members of the committee. My name is Leah Henry. I live in Portland and work as the finance coordinator with Our Power. Thank you for allowing me to testify, and I urge you to oppose LD 1959. This bill provides no path to real tangible changes to our utility accountability and performance, and it fails to address the major issues of our current utility system, from incorporating renewable energy on which our future depends to the safety of our communities. This fall, my partner and I were awoken at 6 a.m. by a transformer exploding outside our window. Disoriented by the flash and the bang, we concluded something in the basement must have been the culprit, until our neighbors assured us it was just the transformer, a sentence they delivered as if this was common occurrence and something that will surely happen again. To them and to so many Mainers, weakened and corroding utility infrastructure is just part of a Tuesday morning. Until, of course, it isn't. We lost power that day, but had a spark from the transformer landed differently, we could have lost our home. A lack of preventative maintenance across Maine is just one example of how our current utility systems, CMP and Versant, are failing Mainers every day, and a perfect illustration of what this bill for utility accountability misses. Focused on making as much profit as possible, CMP and Versant will never be motivated to take on preventative safety projects or invest in the critical renewable energy our future so desperately demands. Mainers need stronger accountability tools, and LD 1959 does not get us there. It simply reiterates tools the PUC already has at its disposal and have thus far not have been used effectively. It is clear during this committee hearing and throughout Maine that we have a failing utility. Immediate change is critical. LD 1959 may aim to patch up our current holes in accountability, service, and performance, but It falls immensely short of setting up a system that will achieve real, tangible results. I urge you to vote ought not to pass on this bill as written. Thank you so much.
Thank you very much. Are there questions for Leah from the committee? I don't see any, so we'll go on to Marty Fox.
Good afternoon, Senator Lawrence, Representative Berry, and members of the Energy, Utilities, and Technology Committee. My name is Marty Fox. I'm a concerned electricity consumer. I live in Wiscasset, Maine. I usually support Governor Mills' policies, but I cannot support the bill before us, LD 1959. I will address the 5 topics mentioned in the bill's summary. The penalties to the transmission and distribution utilities for poor service is inadequate. If the T&D utilities can spend millions of dollars to defeat the consumer-owned utility referendum, $1 million penalty is a slap on the wrist. Are there not standards and audits that the T&D utilities need to meet already? Why require new unspecified regulations? The bill requires T&D utilities to address the expected effects of climate change. But why are the T&D utilities resisting the addition of renewable energy to the grid? How is the bill going to change the utilities' attitude towards renewable energy? Number 4, yes, it's okay to have a mechanism for a T&D to sell to a qualified buyer. Any sale of a utility needs to be approved. But how many years do we consumers need to live with the lowest rated T&D utilities in the country? It will probably take many years to hold the utilities accountable, not to mention the lawsuits they will file against the state of Maine. Yes, number 5, yes, it's good to provide protection for utility contractors and certain employees of the public utilities, etc. The right to provide information to the legislative committee, the PUC, and the public advocate. But what about the protection of employees of privately owned utilities? But most of all, LD 1959 only delays the governor's climate change goals, whereas a consumer-owned utility, which this committee and legislature passed, would expedite the time to achieve Maine's renewable energy goals. I encourage the EUT committee to vote ought not to pass so Maine can move forward with a consumer-owned utility to best meet the needs of Maine's electricity consumers.
Thank you very much. Are there any questions from the committee for Mr. Fox? Seeing none, thank you very much. I'm going to shift over now. We've just spent about 40, almost 45 minutes on those opposed. So I'm going to shift over to those who have patiently waited, who are neither for nor against. We'll start off with Ben Lucas. And I don't know if she's still here. I do see still the name Jean Gazzetti listed, and then we can go on to Patrick Scully, and followed by Stephen Weems.
Good afternoon. Senator Lawrence, Representative Berry, members of the Committee on Energy, Utilities, and Technology. My name is Ben Lucas. I am a resident of Portland, and I am here today representing the Maine State Chamber of Commerce. The Maine State Chamber of Commerce is testifying neither for nor against on LD 1959. I have submitted written testimony and stand by that, but I do want to highlight a few comments. I know the committee has received a lot of information on this bill. First, I want to start by recognizing and appreciating where Governor Mills is coming from by putting this legislation forward. We agree that the utilities should be held to a high standard, and we believe this bill is an attempt at a measured approach. We believe that Maine businesses and our utilities welcome performance standard reviews. However, we would like to offer a couple comments of concern with LD 1959 as drafted and caution the committee as this bill moves forward. Our first concern is we feel it is important that performance reviews put forward in Section 1 of the bill are objective and not subjective. Again, we support the concept of performance reviews, but making sure the metrics can produce a definitive answer is critical so the utilities know what they must do to reach the goals put forward by the commission. The next concern I'll highlight is with the potential $1 million fine. We think a rolling average could be a better way to address the standard reviews. Requiring the utilities to report every quarter may be okay, but the assessment and potential fine should be done over a longer period. I believe in the recent PUC case, it was just done over an 18-month period, as we've heard some about earlier today. And the last concern I'll highlight is around Section 5, the divestiture of the asset. It needs to be clear what would cause proceeding from the PUC. Right now, we feel the language is very vague, and we would ask the committee to carefully consider guidelines for this. Our energy infrastructure is critical to Maine businesses. Our businesses rely on the T&D utilities every single day to bring electricity to their business so they can operate. If the PUC is going to potentially require the utilities to be sold, it needs to be carefully considered and not fall victim to some of the political winds that exist around this topic. We would ask the committee to carefully consider this section. I'll stop there with my concerns. And again, I refer to my written testimony. The business community will be watching this issue very closely, as the potential change will have an impact on all businesses in Maine, not just our T&D utilities. We recognize this is targeting 2 specific Maine companies, but in the future, it could be another Maine business. We would again just caution the committee to address some of these concerns and consider the future impact this could have on all businesses in Maine and the people they employ. Thank you for allowing me to testify today and for your time with all the testimony that you have heard. I'm happy to answer any questions, and I will be available for the work session or any other outreach that the committee needs.
Thank you. Are there questions from the committee for Mr. Lucas? Seeing none, thank you very much.
All right, have a good rest of your day.
And we'll go on to, oops, I missed that. Jean Gazzetti. Jean?
Thank you. Good afternoon, Senator Lawrence, Representative Berry, and members of the Energy, Utilities, and Technology Committee. My name is Jean Gazzetti, and I am testifying neither for nor against LD 1959. To provide some context, I served as the OPLA analyst for this committee for 4 years, from 2010 to 2014. And prior to that, I worked at the Maine Public Utilities Commission, where my primary responsibility was to staff 2 boards that were created through legislation, the Energy Conservation Board and the Energy and Carbon Savings Trust. So what jumped out of me in this legislation was the creation of what is essentially a board, the 5-person committee to establish a COU, which is actually a misnomer. The committee doesn't actually establish a COU. What it does is develop a proposal to submit to the commission on behalf of a COU that doesn't quite exist. And so that was the piece that I really wanted to touch on, because the creation of a COU is something that this committee worked very hard on last session. The legislature passed a bill that really brought the idea of a COU to the forefront. And they have over 50,000 citizens in Maine have signed a petition that have really brought a COU to the forefront. I've heard a few people today testify that the pathway outlined in this bill in order to establish a COU is unfeasible, which is in my opinion, very true. One of the key pieces is what the trigger mechanism is. In the other proposals that you've considered as far as developing a COU, the COU is created when the standards are not met. In this case, the COU is not created when the standards aren't met. The COU is created when the commission issues an RFP, which immediately puts it in a competitive process. And one of the first pieces is that the only deadline that is in this bill, I heard a number of people say there are no deadlines in this bill. There is one deadline in this bill, and that is that the governor must appoint the members of this committee within 30 days of the RFP being issued. So that means while the governor is vetting potential candidates for this committee to develop the proposal, the competitors, the energy utilities that will be submitting their proposals if the commission were to divest, which I think this committee has also heard is very, very, very unlikely. Even the OPA described it as the shotgun behind the door. So even if that process were to go forward, your competitors are working on their bid while the governor is still trying to appoint the members of the committee. And then once the committee meets, you all know this because you've served on boards, they will not be jumping right into developing their proposal. They will be figuring out where their funds are coming from, what sufficient funds are, whether or not the PUC determines that amount or the committee itself determines that amount. It will be figuring out who their chair is, who their treasurer is, how often they will meet, which rules and guidelines they have to follow. Will they be subject to freedom of access? Will they be subject to open meeting? Will they be subject to state purchasing guidelines? More likely than not, they will decide that they are subject to state purchasing guidelines, which means that the contractors that this bill contemplates, the lawyers, the investment bankers, and the consultants, this committee will then have to issue an RFP in order to competitively procure those services. And all the meanwhile, your other bidder is developing their proposal, dotting the I's, crossing the T's, and watching what this committee is doing. Likewise, they probably will have open meetings. So at the end of the day, it's hard to imagine that any proposal that this COU committee might bring forward could truly be competitive with with any other entities, specifically an energy conglomerate, multi-million or billion-dollar company that might be submitting a bid to purchase the T&D utility or purchase its assets. Because technically, when this proposal is submitted to the commission, I don't think the COU yet exists, because these 5 members aren't appointed to govern the COU. They're appointed to submit a proposal on behalf of the COU. So it's very unclear to me when the COU would actually come into existence, which I think puts it almost immediately at a competitive disadvantage when it comes to being prepared to acquire a utility or its assets, which at the end of the day is what the RFP is for that is issued by the commission. So in closing, LD 1708 and the R Power proposal.
Oops, did we lose you?
I'm sorry, did you lose me?
Okay.
Okay, LD 1708 and the R Power proposal advocate for a consumer-owned utility in order to keep accountability close to home, decrease rates, and improve customer service. If you as legislators believe that a consumer-owned utility needs to be a serious contender when current large investor-owned utilities drop the ball, this bill as written doesn't get you there. It requires a COU to compete through a competitive bidding process, and then over and over again sets that COU back at a disadvantage as far as being prepared to submit its proposal. And I'm happy to answer.
Thank you very much. Are there any questions for Ms. Gazzetti, excuse me, Gazzetti from the committee? Representative Berry.
Thank you, Ms. Gazzetti. I think you were the analyst for this committee at a time that I was not on the committee, unless my memory is really bad.
No, that is true.
I know it's not as good as it used to be. But I appreciate your institutional knowledge, also from the former PUC experience. And I'm just wondering, are you here as a private citizen now, or in your whatever your new capacity is?
I am here as a private citizen right now. I am currently serving as Register of Probate for Saginaw County. So I'm not involved in the energy field at all in the moment. I was prompted to testify on this bill primarily because I felt, and actually, I can quote you from earlier today, Representative Berry, we all have a duty to report to the public what is real and what is not. And I felt like the fact that a COU was even mentioned in this bill as being viable was extremely misleading. This bill talks about a COU, I think, because of the 2 proposals that have gone, well, the one that has gone through the legislature and the one that is a citizens initiative. But this bill really doesn't do anything to truly bring a COU to the table. And I felt it was really important for the committee and members of the public to know that.
Thank you, and it's nice to meet you.
Nice to meet you.
Any other questions from the committee? Seeing none, thank you very much.
Thank you.
We'll go on to Patrick Scully.
Good afternoon, Senator Lawrence, Representative Berry, and honorable members of the Joint Standing Committee on Energy, Utilities, and Technology. My name is Pat Scully. You may recall, I was appointed to the Public Utilities Commission and began service back in June. And I'm here on behalf of the commission. Chair Phil Bartlett is not available today, and the commission is testifying neither for nor against LD 1959. We've submitted written testimony. I won't read the testimony. I just wanted to cover a couple of points if I could. We do believe that LD 1959 would add to the existing authority that the commission has and provide it with a broader set of tools to act to ensure quality service for the people of Maine. I would note, however, that the commission has substantial tools currently at its disposal. You may be aware that the commission has service quality standards under its existing rules that apply to all T&D utilities in the state, and as well specific standards that were adopted in commission orders that apply specifically to CMP and Versant. About a year ago, the commission started a proceeding to look at significantly expanding the detail and the scope of those service metrics for T&D utilities, and developed a straw proposal mid-year last year, which was reviewed, and we received comments by a number of parties to the proceeding that was mentioned earlier as docket number 2020-344. As a result of all of the input that we've received, the commission is currently scheduled to deliberate its notice of rulemaking in that proceeding next week. And so we look forward to seeing the outcome of that deliberation, and will certainly provide the committee with the proposed rule if the proposed rule is adopted next week at our deliberations. I do want to point out a couple of things about the legislation. One is we think that the rulemaking proceeding that is a part of section 1 of the rule would be really important if we're going to adopt more detailed service quality metrics. It's important that they be specific, that they be objective, and that they be enforceable. And so the rulemaking proceeding is an important component of that. Also wanted to mention that in the section of the bill regarding divestiture in section 5, and in particular the subsection on the consumer-owned option, the last sentence says that the commission shall provide the committee with sufficient financial support to retain lawyers, investment bankers, or consultants as needed to prepare a proposal to purchase the utility or its assets. We are a little bit concerned about the vagueness of that sentence, and in particular, how we would determine what the scope of that financial support would be, whether we would have the ability to control the total cost to be invested in that effort, and also how it would be funded ultimately. So we would suggest that perhaps the committee, if it's going to go forward with this bill, look at perhaps providing a bit more detail on that particular mechanism. Beyond that, I'm happy to answer any questions that the committee has.
Great. Other questions from the committee? Representative Sachs.
Thank you, Mr. Chair. Thank you for joining us, Mr. Scully. I've been waiting to talk with you, so thank you for being here. I do want to drill down just a little bit if I could. My understanding is you just removed the penalty for the PUC meeting, or excuse me, for CMP meeting performance metrics already recently, while you launched a different investigation. How does this bill interface with the work that you're currently doing on the docket and the current performance measures that you have for CMP and Versant?
Thank you, Representative, for the question. So there are multiple different things going on here, all essentially at the same time. One is, as you're aware, before I came on the commission, as a result of all of the difficulties associated with CMP's public customer service when it rolled out its new customer care mechanism and billing system, the commission conducted an inquiry, and as a result of that, determined that there had been some serious failures by CMP in terms of how it rolled out that system and how it responded to all the customer complaints and concerns. And in response, at the conclusion of that inquiry, the commission imposed a penalty in the form of a reduction of CMP's earnings that, given our decision of last week, is now totaled $12,500,000. That penalty, when it was assessed, was tied to some specific performance standards for service metrics. And the commission said, here's the penalty we're imposing, and the penalty is going to remain into place until you can demonstrate that you meet these 4 customer service standards for 18 months. In its decision last week, the commission concluded, after reviewing all the material and comments from the parties, that CMP had in fact met the standard that had been put by the commission in that prior order, and therefore said, CMP, you've done what we told you to do. We're lifting the penalty. What the commission also said in that order is essentially, you're going to continue to report on those service metrics, CMP. And if you fail on a going forward basis to meet them, we're prepared to reinstate the penalty. So if there's backsliding, we'll react in response to it. That's where that issue stands. At the same time, I think, as the committee is aware, the commission ordered a management audit of CMP and its relationship with its parent entities, and the Liberty Group prepared and submitted a report in the fall of last year, which I believe the committee has seen and received and seen. And as a consequence of that report from Liberty, we directed CMP to submit a performance plan to address the concerns that were in that report. CMP submitted that plan, we've reviewed it, and we also deliberated last week and determined that while there were positive elements in that plan, that there was still a need for a further kind of investigation, which we've opened, that really gets at the issue of the financial relationship between the parent and CMP, and whether or not that relationship and the way in which CMP's budgets are established and funding provide sufficient resources for CMP to be able to provide high quality, reasonable service to its customers over time. So we've just opened that investigation, and it'll proceed on its own terms. And then the third piece of the ongoing is the one that I just mentioned, which is this general service metrics proceeding, in which we're scheduled to open a rulemaking next week. That would, if we adopt the proposed rule, would establish much more detailed service metrics for CMP, Versant, and other T&D utilities.
So if I may follow up,
Go
Mr.
ahead,
Chair, just
Representative Sachs.
directly to this testimony. So you've heard, and maybe we've gotten a lot of information today, Mr. Scully, of just not on just customer service with the response time to the phone call, but also things like outages, service grid, et cetera. Is that going to be part of it? And then number 2, this bill also address audits, which if you're doing a full on, is the utility management utilize or per your own words, putting profit over customer service and utility ratepayers. I'm assuming you have pretty strong audit capabilities at the moment, and that's also in this bill. So the speaking directly to your answer, is the scope of this CMP of the PUC's metrics going to be expanded from just customer service and more broadly the service that this utility provides? And number 2, is the audit provisions that you currently have changed in any way from this current bill?
So the scope of the service metrics that we're considering adopting as part of this rulemaking is substantially broader than what we've had in the past, and it covers a whole number of reliability, customer service, billing, a whole range of service indicators, frequency of outages, how long outages last, how quickly the company restores service, what storm response looks like, and how quickly the utility responds to repair damage after storms, what the cost of storm restoration is, whether the reliability upgrades that ratepayers are paying for are helping to actually reduce the consequences of storms. There's a whole number of different metrics in that concept that we'll be deliberating on next week. With respect to the auditing capability, yes, we currently have fairly broad authority to conduct audits. I think the audit that's specifically envisioned in the legislation is a little bit different, and it deals with a situation where the utility has not come in for a rate case over an extended period of time, and it would authorize the commission to go in and look at what utility expenditures are compared to what was in their last rate case. And if it sees that something's seriously out of whack, to then conduct an audit on that issue and potentially to make an adjustment to the utilities rates or disallow some of its expenses if it found an inappropriate disparity there. So it's a little different than what we've done with respect to auditing, but it's a kind of an additional arrow in the quiver, I guess, if you would.
Is that not allowed currently, Mr. Scully?
I think there's a valid question as to whether, I mean, personally, I think we could probably have conducted that form of audit on our own initiative. We certainly have the ability to look at utility rates on our own initiative. I think having an express statement by the legislature that says, here's a tool we want you to be able to pursue is helpful to us, and it helps to head off any potential challenges to our authority when we've got specific authorization from the legislature. But I think, as I said at the outset, a lot of these tools we currently have, and I think this statute adds somewhat to what tools are already at our disposal.
Mr. Chair, if I have one more, if I could.
If I could just interrupt for a second, Representative Sachs, I have to jump off for another meeting. So I'm going to turn the electronic gavel over to Representative Berry, and he can complete. We have Steve Weems up next. That will complete our neither for nor against. And then you will just have to go back and complete the against. And I apologize, Seth, the list is very confusing about who's testified and who hasn't, but I'm sure you and Jason can figure out where to pick up.
We will get through it. Thank you, Senator Lawrence,
Okay,
for
thank
your stewardship here today. And we know you'll be reviewing the video
I'll be back.
as well. Others. Great. Representative Sachs, please proceed.
Thank you. I just had one more, and it's because I asked Mr. Harward this question hours ago, Mr. Scully, and he deferred to the Public Utilities Commission for the answer of so much of this bill, just to your prior statement, feels like it's things that are already in existence, but hopefully the intent was to strengthen or elucidate better. One that I had earlier today from Mr. Harwood is, and he referred to it as well, is the PUC already has the authority to divest an IOU and move to a COU if that were the case. And they have not exercised that authority despite, as you've stated and others have, around monument, historic fines, lowest customer service, if that were the thing we were measuring, lowest customer service consistently. Is there a sense that you can give me as to why that had not been exercised and how this bill would change that to empower the 3-member PUC to divest or start the process to divest to an, if wanted, a COU?
Well, Representative, I'll do my best. I've been on the commission since June, and so I don't have the same history as a commissioner that others do. I think that, technically we do have the authority under certain circumstances to order divestiture. I think what the bill does is to really be more explicit about saying, we're going to set standards, you're going to measure performance. If they fail to perform, you're going to penalize them. If they continue to fail to perform, this is the route you're going to take. So it gives a more explicit roadmap to us than we currently have. Why has the commission not gone that far in the past? I think the most serious issues that we've seen with respect to customer service have been in the last 4 or 5 years, particularly around CMP's rollout of its new systems, as I mentioned earlier. And I think the commission has proceeded with a number of steps to figure out what went wrong, to penalize CMP as it deemed appropriate, with, as you mentioned, the largest penalty ever issued to a utility, and resulting in the lowest ROE to a return on equity to a T&D utility in the country. The management audit by Liberty and the investigation that we've just opened really is getting at the question of, is there a fundamental problem with this ownership structure? With the parent relationship at the Iberdrola and Avangrid level and their relationship with CMP, is there a problem that is going to, no matter what we do with respect to penalties, get in the way of customers being able to get good, high quality, reliable, affordable service over the long term? And that's what we're going to look at. And I think with this legislation, with or without this legislation, the commission might ultimately get to the place where it says, we don't think this is a sustainable relationship. But we've said that publicly. We haven't heard the evidence yet. We haven't completed that investigation yet. So I don't want to prejudge in any fashion, but I think that path is open to us. And I think there's some benefit in this legislation in being more explicit about our authority to move in the direction of a divestiture if the facts support divestiture. And you can be sure that if we were to instruct any utility to divest, we'd be looking at the potential of a challenge. And I think the more clear authority you have from the legislature that says this is something you can and should consider doing, the more that we can move forward confidently.
Representative Sachs, any follow-up?
No, thank you, Mr. Scully.
Representative Foster.
Thank you, Mr. Chair, and thank you, Commissioner Scully, for being here. A couple of quick questions. One is, from what you've said, much of which is addressed in the bill, the PUC has the ability to carry out in some form or fashion. And I'm just wondering if there's opportunity there through rulemaking where that things could be adjusted to increase the amount of what's in this bill, rather than passing the bill, if you will, that would give the PUC that capability that the bill intends. If that's clear, I'm not sure I made that clear, but versus legislation. Yeah, thank you, Representative. I think, as I said, I think that especially with respect to establishing specific, detailed, strict performance standards, we have the ability to do that now. And as I said earlier, we're kind of in the process of we'll be deliberating on a rulemaking to do just that next week. So I think we do have that authority today. We do have the authority to issue penalties to the utility. I think what the bill does is kind of pushes us further in that direction, gives us perhaps a little bit more authority with respect to penalties. It increases the size of the penalties that we could impose from $500,000 to $1 million for each violation of those service metrics. So it gives us a bit more oomph in our authority, but at the end of the day, we have a lot of tools today at our disposal. We intend to use them. We intend to do everything in our power to make sure that customers are receiving high quality service at affordable rates. If I may, Mr. Chair, follow up.
Go right ahead.
Thank you. Thank you, Commissioner. So my second question, and one of the reasons I asked that question is the PUC also indicated in your testimony that you expect, if the bill were passed in its present form, that it would require additional staffing to meet the requirements of the bill. I'm wondering if you have a ballpark number for what that might cost, and also just confirm that it would be ratepayers that would be bearing the additional cost in the end, if you could. And and when I say ballpark, I mean a big ballpark. Yeah, I can't say that I have a number. It's certainly something that we could follow up with the committee on, if you'd like, to try to give you some guidance as to what the staffing requirements would be. I don't think we would need significant additional staffing for the rulemaking itself, because frankly, we're already in that process today with our existing staffing. I think when you look at a divestiture, for example, and the role that the commission would play in the divestiture as outlined in the statute, that would require additional staffing on our part. And I'm sorry to say, as I sit here today, I don't have a good ballpark estimate on what that would require. You know, the way in which we're currently funded, our funding comes from the utilities, but they can obviously ultimately recover that assessment as they currently recover it. So, but again, I'd be happy to follow up with the committee if you want us to provide something more of a, for someone more, enlightened than I, to provide an estimate of what that additional staffing might look like. If I may, Mr. Chair. So that prompts another question. So I'm assuming, for instance, items that are on this bill, such as the quarterly report card and so on and so forth, may require additional staffing. And we don't need to go into that now, although I would be interested in what the PUC thinks that might require. But in regards to divestiture, the PUC already has that capability. And again, it's been mentioned before, if the hoops that you got to go through may be a little different than they might be if this bill is passed. But I would assume that if that day should come under current statute, that the PUC would likely have to hire on staff to manage that as well, even without this bill. Would that seem reasonable? Yeah, I think that's right. I mean, I think if we're going to conduct the kind of proceeding that the statute anticipates, where we're soliciting proposals from different players out there, including a public option, and we're going to set out standards for what we're going to look at in those proposals, we're going to evaluate different proposals, we're going to score them, we're going to try to determine the financial and technical capability of the company submitting proposals to provide the services. That's a significant effort. And so whether we try to do that on our existing authority or we try to do it under the auspices of this statute, it's going to require resources beyond what we already have today, given current workloads. Thank you.
So thank you, Mr. Scully, because I wanted to ask a question of my own on that point. But first, let me just ask see if there are any other members of the committee who wanted to jump in. And seeing none, this matter of not being properly staffed for a possible divestiture is very troubling to me, because it does, the bill contemplates that process, and there is in existing law, as you know, and I know you're relatively new to the commission, so the existence of this statute or the contemplation of its use is perhaps newer. Title 35A, section 1511 contemplates divestiture. And there you go. You've got it right there. So you will find in section 1511 that the commission may this is by the way, a 2003 law. The commission may, in an adjudicatory proceeding, suspend or revoke the authority of a public utility to provide service upon a finding that the utility is unfit to provide safe, adequate, and reliable service at rates that are just and reasonable. And there's a sort of a due process provision. But so right now, and for the past nearly 20 years, the PUC, by a vote of just two of the three members, could at any time have decided, you know what, you guys aren't performing. This is not what we consider fit to serve, safe, adequate, reliable, at just and reasonable rates. So what I'm hearing you say is that, first of all, that this bill is unworkable without additional funding, but more importantly, that the existing underlying statute is not even possible because of a lack of funding or lack of staffing and capacity at the commission at this time. Is that accurate?
Not quite. I guess what I would say is for the commission to do the mere act that the statutory section describes, which is, let's say we've been in an adjudicatory proceeding with regard to a utility, and we've determined for whatever reason, based on some record of evidence, that that utility just is no longer fit to serve. And we could reach that conclusion and we could say, you're not fit to serve, we're withdrawing your authority to serve as a utility in this state. That conclusion by itself, I don't see as necessarily requiring additional staffing. The question is what happens next, and by what process do we replace that utility? And if the commission is going to be required, as the new bill would suggest, to basically run the process by which we evaluate alternative providers, bidders, to become the next whatever utility it is for whatever service, that's not an insignificant undertaking to conduct a process of that nature. And that's where I think our current resources would probably not be sufficient to conduct that process.
So to be clear, it's not the adjudicatory proceeding in determining whether a utility is fit or unfit. It's not the subsequent merger and acquisition process, which is also substantial. It's only the evaluation of a consumer-owned option that would trouble you from a staffing perspective.
No, I don't think it's just the evaluation of a consumer-owned option. I think it's if the commission is being put in the role of deciding what entity ends up being the next provider of service after we've determined that the existing company is unfit to serve, whether we select a for-profit entity or a public entity, whoever it is, simply the running that process to evaluate, to establish the standards, to conduct an RFP, to evaluate the bidding, to conduct all the investigations that are necessary on the bidders to see whether they have the resources to do the job, to determine who's going to provide the best service at the lowest reasonable cost. That's not an insignificant effort. And it really doesn't matter whether the winner in that process is public or private. It's still a big effort. And I'm just concerned as to whether or not we have the resources in-house currently to be able to do that in addition to everything else that's on the staff's plate.
Great, thank you. And one last question. So, and I'll preface it with just a brief story. This bill looks to establish specific criteria for reporting in specific areas, notably doesn't include affordability, although that's been contemplated throughout the discussion today. When I first came on this committee in 2007, I took CMP up on an invitation to go to their corporate headquarters in Augusta, went to a very well-appointed boardroom where the CEO at the time, Sarah Burns, sat us all down, and I'll never forget, she said, it's really simple. Our job is to keep the lights on and to keep the bills low. And I thought, that's great. That's so easy, right? I mean, that really boils it down. I thought it was a beautiful way to summarize what the job of the utility is. And then there was a third aspect, a third leg of the stool, if you will, that she was prominently featuring in the boardroom. The only decoration in the boardroom at all were a number of awards, I should say, for the J.D. Power customer service ranking for the Northeastern region, which at the time were fairly high. And as we've heard discussed today, that all three of those legs of the stool have shortened considerably in the intervening years. So rates, reliability, customer service. Isn't Sarah Burns correct that those are the three standards we should be looking at? And aren't those already in subsection 1511?
Well, I think, fundamentally what we want of our utility is to provide safe, reliable service at the lowest possible cost. So I don't disagree that that's the goal ultimately.
And maybe customer service, customer satisfaction.
Absolutely.
thrown in there, right? So that's helpful. And I'm going to just see if there are any other members of the committee who want to jump in. I'll reserve my additional questions for you later. Thank you very much, Commissioner, for joining us. We'll go next to Mr. Stephen Weems of the Solar Energy Association of Maine. Welcome, Mr. Weems.
Well, thank you. Fascinating discussion. Representative Barry, members of this Committee on Energy, Utilities, and Technology. My name is Steve Weems, Executive Director of the Solar Energy Association of Maine. I just note that in our written testimony is some very interesting material about the legislature holding our utilities accountable. I invite you to check that out over the last 30 years. Back to the case of today, we'd like to support LD 59, but we cannot because it is not enough and we think it's diversionary. The association does support stronger, more effective regulation of larger transmission and distribution utilities. We certainly are in favor of broader and better whistleblower protections to expose aberrant utility behavior. And we have been on the front line of the drive to hold Maine's failing investor-owned utilities accountable for their miserable performance. These are laudable objectives of LD 1959. Yet we cannot support the bill in its present form because we think the performance report card provisions are inadequate, and the accountability provisions of Section 5 would prop up the fatally flawed, unnecessarily expensive investor-owned utility business model, would take too long to navigate, and would work at cross purposes with the excellent work the legislature did to hold investor-owned utilities accountable by enacting LD 1708 last year to create a statewide consumer-owned utility. With great respect for the sponsors of the bill and their intent, log the Solar Energy Association of Maine in as neither for nor against LD 1959. So how do we really feel? The purpose of LD 1959 is fine. The content is off target. Maybe it should be deep sixed, but if you go forward, here's our suggestions. First, rework the reporting requirements to hold transmission and distribution utilities accountable for creating the dynamic grid of the future, not the static grid of the past. Others have commented on this. Most importantly, we advocate holding utilities accountable now. Do not perpetuate the hell we are in, wasting more time in a long, drawn-out process. We have 50 years of more and more investor-owned utility failure. Continue to support the formation of a statewide consumer-owned utility. Build on your great work last year enacting 1708, LD 1708, to accomplish this. If you feel it's necessary, create a process to improve the Pine Tree Power template. Help move this solution for the times forward in any way you can. And thank you for listening.
Thank you, Mr. Weems. Are there questions from the committee? Seeing none, thank you very much for joining us, and we'll hope to see you at the work session. I believe that concludes the neither for nor against testimony. I do just want to double check with Jason.
Yes, that's all I have on my list.
Great. Okay, so at this time, we're going to hear from, I think all remaining testimony is in favor, but I will provide an opportunity at the very end for anyone that is wishing to testify in any category and has not yet done so. I believe there is also a representative who wanted to testify soon or at some point, Representative Grahowski. And I also want to cautiously invite people who really have a major appointment, a major need. This is going to be honor system, folks, to raise your hand in the chats if you really urgently need to testify right away. And I will do my best to get to those of you first who have your hands raised. I will thank in advance those of you who don't raise your hands, because you can wait and let others jump the line, if you will. And we will work through the remaining testimony. It looks like we are getting there and should be done within an hour. So with that, we will go to William Team. I hope I'm pronouncing your name correctly. Forgive me, I should know, because we have met, and ask you to unmute and to go ahead and present your testimony in opposition.
Yes, thank you. Representative Barry and members of the Joint Committee on Energy, Utilities, and Technology.
And if I may, just sorry to interrupt, but we are unable to see you, and we do appreciate having people.
Yeah, I don't have a button for the camera. I'm not sure what's going on there, but.
Okay, and I don't have any way to change that at my end. Sometimes if you go to the lower left of the screen, there's where it says video or stop video or start video. There's a little up arrow, and you may be able.
It doesn't even have that. All I have is a mute button down there.
That is very strange. Jordan, is there any way you can help?
The only thing I can imagine is maybe take him out and bring him back in. I'm not sure.
Well, there is another device associated with your name in the chat, and I just tried to promote that as well. I'm not sure, but there we go. That's the webcam, EOS webcam utility. There we go. We can see you now. Much better.
Okay, thank you.
All right, go ahead.
So, like I was saying, Representative Barry and members of the Joint Committee on Energy, Utilities, and Technology. My name is Will Teamy. I live in Cumberland Center, Maine. My pronouns are he, him, and while I am testifying as myself today, I do want to state for the purposes of transparency that I've been very active in the Pine Tree Power petition process, and I am part of Maine's 600-member strong chapter of the Democratic Socialists of America. Today, I'm here to testify against LD 1959, an act to ensure transmission and distribution utility accountability, although I do want to acknowledge one of its few substantive strengths, which are the whistleblower protections, although they don't go nearly far enough out on their own. My concerns with the bill are that it feels hastily drafted and unlikely to deliver the results promised by the title. It also concentrates power under the executive branch and positions appointed by the governor's office, which essentially are also executive branch positions. The governor's office in recent years has been held by people who have not pushed back very much against the actions of our current investor-owned utilities. Given its late introduction this session, wouldn't really end up surprised if this ends up being hastily amended and turns into something that isn't even gonna be supported by the governor. There's not going to be much opportunity for robust public participation in this process because it is so short, and dropping this into the legislature at this point just makes it feel like this patchwork of political promises and not a methodical reformation of the complicated electrical transmission and distribution system here in Maine. That solution probably was LD 1708, which is why I'm collecting signatures for that. I would also like to point out that the depressingly weak climate protections suggested in this bill convey a startling and alarming misunderstanding of the climate catastrophe that we currently find ourselves barreling towards. Requiring an electric utility to ensure its assets are secure against climate change and the effects of climate change will not hinder its ability, while not hindering its ability to provide service, is not a climate plan. Electrical generation is a contributing factor. It's one of the main factors of this crisis that we find ourselves in, and dealing with it requires substantial changes to our grid and the incentive structures around consumption, distribution, and generation. The climate protections in this bill are woefully inadequate and just aren't going to do what we need them to do. the monopoly aspect of this regulation of this sort is not going to get us out of this hole, because we have ceded our monopoly control to a private company, CMP or companies. CMP and Versant have routinely opposed common sense approaches that we could have taken to reducing our contribution to the climate catastrophe. Leaving the current ownership structure of these companies in place avoids the root of the problem and leaves them primarily accountable to their shareholders rather than the ratepayers, who are left with nowhere else to turn, thanks to the aforementioned monopoly. Just a little bit of something to leave you with. This is a brief list of some of the bills that CMP and Versant have actively worked against in recent years. LD 1146 to encourage the use of renewable energy. LD 1252, an act to improve Maine's economy and energy security with solar and wind energy. LD 1426, an act to improve Maine's economy and lower energy costs through energy efficiency. LD 1073, an act to lower energy costs and increase access to solar energy for agricultural businesses. LD 1263, an act to create jobs and promote investment in Maine's economy through increased access to solar energy. 1444, an act regarding large-scale community solar procurement. And 1504, an act regarding solar power for farms and businesses. And this is not an exhaustive list by any means. They oppose anything that is at all threatening to the profits of their shareholders, despite the benefits that they could bring to Maine people. Thank you.
Thank you. Will Teeny, any questions from the committee? Seeing none, I will remember how to pronounce your name in the future, promise. And thanks for your patience here today. See you later. And up next to testify, also in opposition, is Gary Friedman. I see a lot of patience in the chat, but again, if you have an urgent need, do raise your hand and we'll get to you next. Gary Friedman.
Thank you, Chairman Barry and members of the committee. My name is Gary Friedman, and I'm speaking for Maine Climate Action Now, a coalition of 14 grassroots social action organizations that have a focus on climate issues in Maine. Through advocacy, education, and organizing, we seek to honor, unite, and amplify the voices of youth, frontline communities, and others historically excluded from the climate conversation and from positions of power. We hold social, racial, and economic justice as critical to the transformation to zero carbon emissions by 2030. We believe that not only does LD 1959 fail to meet critical standards for accountability and affordability, it sidesteps the imperative for urgent decarbonization of Maine's economy through rapid strengthening of the electric grid and accelerated integration of renewables throughout the state. In fact, we believe that this bill is simply a thinly veiled attack on the citizens' initiative to establish a consumer-owned utility. Last year, this committee advanced a path towards energy democracy through LD 17808, which was vetoed by the governor after receiving bipartisan support in both chambers. This act is now circulating through petitions to qualify for the November 23 ballot, and we believe that the governor and her corporate sponsors are running scared. They should be. They know that Maine citizens are fed up with the abuse and lies promulgated by CMP and are tired of sending our hard-earned dollars to foreign-owned utilities that continue to demand escalating rates approved by our utility-captured PUC. They know that given the chance, Maine voters will choose to divest themselves from foreign government ownership of Versant and the sovereign wealth funds of Qatar and Norway that hold major ownership shares of CMP. These foreign owners do not care about Maine ratepayers, nor our climate goals. They only have an insatiable demand for increasing profits. LD 1959 has one primary purpose: to muddle the public's demand for real change. By proposing hollow reforms controlled by the governor's appointees at the PUC and the foreign-owned utilities themselves, the governor has promulgated a distracting and superficial reform bill that in effect makes our situation worse. I'm leaving it to the experts on energy policy testifying today to detail the specific failings and weaknesses in this bill. The point I want you to remember from Maine Climate Action Now is that this bill should be soundly rejected for the blatantly political attack that it is on your previous work on LD 1708 and the citizens' initiative to bring the real benefits of a consumer-owned utility to a statewide vote. Thank you.
Thank you, Mr. Friedman. And are there questions from the committee? Okay. And again, it's you're representing Maine Climate Action Now. Is that correct?
That's correct.
Okay. Thank you very much for your testimony and your patience today. It's been a long day already. And next we will hear from Mr. Wayne Jortner, who also I believe has been here since the very beginning, as have many. And we're saving the best for last, folks.
Am I on?
Mr. Jortner, we can hear you but not see you. Are you able to turn on your video?
I'm looking for that.
Lower left, maybe the little up arrow next to the video button. Or there might be start video at the very bottom, at the lower left of your screen.
I'm not seeing a start video.
Oh, we have a similar situation. It looks like there are two devices listed. Hang on. Jason, I don't know what's going on, but we're getting people are being bifurcated into two devices somehow in the attendee panel. That's the second one where that happened. Okay, I think, yes, we can now see you, I think. There we go.
Okay.
All right, go ahead.
Thank you. Good afternoon, Representatives Berry and members of the committee. My name is Wayne R. Jortner from Freeport. I'm a former senior counsel to the Maine Public Advocate, where I was employed for 23 years. During those decades in the field, I was a close observer of utilities, of the Public Utilities Commission, and I was keenly aware of the needs of the rate-paying public whom I represented. Since then, like all of you, I've observed a deterioration of service quality of our major electric utilities. And one of the reasons for that is that Maine has become an increasingly small and distant part of the system from its owners. The PUC has not, the PUC has not seen a merger or acquisition that it didn't like. And as we became more distant from the owners of the utilities, service declined accordingly. And that was true in the energy and telecommunications sectors over many years. So one interesting observation about today is that people and organizations with common goals to reform our service from utilities are testifying both in favor and against this bill. And I think one of the reasons for that is those of us who have observed the PUC over many years believe that it's really incapable of being an effective agent for fundamental change. So here are the reasons for that. First, the PUC, if the PUC were inclined to effectively regulate our two large electric utilities, they would have already done so, because it has always been, it's always had the power to do so. But here's the key fact. Under the current law, the PUC's governing legislation explicitly tells the PUC to equally look after the financial concerns of shareholders as well as the public's interest. And that's the law. LD 1959 does nothing to change that. During my decades in this regulatory environment, I've noticed that the PUC has failed to do anything that would be fundamentally at odds with the interests of utility shareholders. I'm sorry. So as Tony Buxton mentioned, the utilities have a fiduciary duty to their shareholders. That's their primary focus. And as long as the fiduciary duties of shareholders are at odds with the public's interest, fundamental change is not going to happen. The PUC's goals are split. There's a competition between shareholders and the public's interest. So that system is fundamentally flawed. LD 1959 would instill a slow, costly, messy, and expensive process that would at best be a Band-Aid on the current broken system. The PUC is simply the wrong place to entrust fundamental change. The second point is, while this bill facially includes a path toward a consumer-owned utility, the obstacles required to get there make that an enormously unlikely proposition, as Jean Gazzetti well described. Notably, all of the deciders would be directly or indirectly appointed by one person, the governor. It appears that our current governor is not a proponent of a consumer-owned utility, and her successor may be even less likely to be one. This bill provides virtually no opportunity for public participation, even though over 50,000 Maine citizens have already signed a petition favoring the creation of a consumer-owned utility. Maine's own existing consumer-owned utilities already demonstrate a way to effectively improve both service quality and rates, as you've heard earlier. They demonstrate that high-quality electric service does not require funneling millions of dollars every year from ordinary Maine people to out-of-state, often international, often governmental investors. We need utilities with a corporate charter that aligns with, rather than competes with, the public interest. Namely, a commitment to low-cost service, high-quality customer service, a commitment to the prevention of power outages and the fast restoration of service, commitment to renewable energy interconnection, and to mitigation of climate change. Those are the values that should be the core mission of utilities that have the privilege of being monopolies that are exempt from the discipline of a free market economy. If LD 1959 were to pass in some form, I'd suggest that the whistleblower provision and increased penalty authorities would be worthwhile steps, but LD 59 as a whole is really not the solution. Thank you.
Thank you, Mr. Jortner. And are there questions from the committee? Representative Grahowski.
Thank you, Mr. Chair. Good to have you here, Mr. Jortner. And I might have missed something because I had to step away for a little bit, but one thing that I've been just really uncertain about, what the implications are of that, I think, second section of the bill that relates to the PUC looking at how did the rates compare to what's actually been happening for the utilities. I was thinking you might have some experience with rate cases based on your work at the public utility or at the public advocate. Is that section 2 going to benefit ratepayers, or is it problematic?
I think it's problematic. It's sort of a very different system than what we have. Usually rate making is prospective. We have a rate case. Usually the utility comes in to ask for a rate increase, and then we go through a 9-month rate case, and then rates are applied prospectively. As you heard Commissioner Scully mention, the PUC has always had the right to initiate a rate investigation. So this provision in this bill that says, well, if they haven't had a rate case for 5 years, they may be over-earning, and therefore we're going to tell the commission they should go in and investigate the rates. That's always been the case. The commission has always had that authority, and Commissioner Scully acknowledged that. So I just don't think that part of the bill does anything beneficial.
Any follow-up question, Representative Krowski? Okay, Representative Sachs.
Thank you, Mr. Chair. Thank you for being here, Mr. Jortner. I would also ask, along that same line of questioning, you had stated that within the PUC statute itself that it must balance between, and there's an inherent tension between the ratepayers and the stakeholders, and assuring that both are serviced throughout the PUC's activities. So in that way, speaking to the same section that Representative Grahowski is talking about, I'm just wondering, again, I keep going back to the actual bill, and that is in the public advocate's role that you used to have. Upon the finding of a commission that there was a difference of more than 10% between the transmission and distribution, has that always been within their purview? And is there any tension with that figure I should have asked why they picked that figure to spark such an investigation.
Yeah, again, I don't know why they picked that number, but as I said, the commission has always had the authority to bring the company in. So the commission may have information that a utility is earning more than it should be. And in those cases, the PUC, based upon its resources, may or may not decide to bring a utility in. It doesn't do that very often because it's kind of busy with utility-initiated proceedings. And that's part of the basic flaw of our current system. All the information is held by utilities. Everything the commission knows comes from the utility. And so you have to assume the utilities are not being biased or selective or just holding back on providing things. Even the service quality reports that this bill requires is something that comes from the utility. The utility decides how to report its qualitative standards that the commission is asking for. And, you know, we all have to assume that's accurate and unbiased, which is a big assumption to be making.
Right. In your 23 years, sorry, Mr. Chair, just again, given his experience, in 23 years that you were there, had they ever initiated a study such as that? You said that more than expected, that's sort of a broad term, but also that, have they ever initiated that when they see between your expected earnings? Because we've heard, quite frankly, quite a bit about the earnings of the utilities in the past year. And I'll end my questions there. Thank you.
Yeah, I mean, I think there were a few cases where the commission has initiated rate investigations, but they're very rare. I mean, I remember one case, there was a small telephone company that had not been in for many years. The commission assumed they were not coming in because they were over-earning substantially, and they brought them in. I think they may have brought the gas company in once too, as I recall. I don't remember them bringing in the electric utilities, and that may be because they come in pretty often for rate increases. So the commission doesn't need to bring them in that often.
Thank you.
Any further questions for Mr. Jortner? Just what I hope is a quick one. The ability to divest has existed in law for approximately 20 years. The ability to bring folks in for a rate case at any time has always been there, as far as I know. You mentioned mergers and acquisitions generally being warmly received. Is there perhaps a perverse incentive where, for a commission with a limited staff and limited capacity, taking on additional work just doesn't, there's nothing in it for those who have to do that additional work other than additional work, right? So, you know, it may benefit ratepayers, and that's great, but, you know, I'd like to be able to clock out at 5 and get home to my kids. Thank you very much. And it's not going to change my salary, so why should I, right? I mean, is that an issue, do you think? Is that part of what we're up against?
I think that's a major issue because I think if you talk to PUC employees, they'll tell you that they're pretty much stretched to their limit. They all work pretty hard. They don't have a lot of spare time. But the other aspect of it is the political courage it would take to do something that's fundamentally different. To start a divestiture proceeding, that would take a lot of political courage. And, given the general conservatism of these groups, I mean, look who gets appointed to the PUC, and look who gets appointed even the last 2 out of 3 public advocates. These people come from the utility world for the most part. These are not people who are likely to have the political courage, with all due respect to the current, members of those groups. It's just not a likely proposition that you're going to see the PUC pursuing divestiture, even though they technically and legally have the right to do that.
Thank you. Seeing no further questions, Mr. Jortner, thank you very much for your testimony. And Jason, if we could now promote, I believe that there's a landline that has been waiting all day, and that it belongs to someone affiliated with Versant Power, 6590556.
Yes, that would be John Flynn.
Okay, we're going to bring in Mr. Flynn. And Mr. Flynn, if you're on your phone, you might have to, I think it may be *6 to unmute.
Can you hear me?
Yes, we can hear you now.
Yep. Awesome. Thank you. I apologize, Representative. We've had some significant connectivity issues in our office in Bangor today, so I am only available by phone. So my apologies for that.
That's okay. I think that's what happened to the representative for Holton Water, who didn't make it at all. So go ahead.
Thank you, Representative Berry and members of the committee. My name is John Flynn, and I'm president of Versant Power, and I'm here today on behalf of Versant Power in respectful opposition to LD 1959. While we do have some substantive concerns about this bill, which we've detailed in our written submission, we also have a genuine desire to work with Governor Mills and the legislature to continuously enhance the level of service that we provide to our customers and to address the many challenges that lie ahead. At Versant, we know we can never lose sight of the need for continuous improvement. Its reliability, customer service, and affordability are becoming ever more important, as we've talked about throughout today. And Versant Power employees are committed to meeting those customers' expectations. In 2021, Versant Power exceeded every one of the stringent reliability-focused service quality indices set by the PUC following our reorganization in 2019, and we delivered the highest level of system reliability in over a decade. Despite these SQIs being due to expire in 2022, we actually voluntarily proposed to extend them on our most recent rate case, a direct reflection of our willingness to be held accountable for our performance. In 2021, we also significantly exceeded our billing accuracy XQI, limiting billing errors to 0.3%, meaning that 99.7% of our bills were accurate. The company has received 252 Level 4 interconnection applications from renewable energy developers, representing approximately 580 megawatts of generation in our queue, and we've executed 93 interconnection agreements, and we remain committed to working collaboratively with developers and the MPUC in further streamlining that interconnection process. While reliability and customer responsiveness are critical measures, at Versant Power, there's nothing more important to us than the safety of our employees and the public. And in 2021, we recorded the best safety performance in the company's history, including 0 work hours lost to incidents on the job. Just an outstanding achievement. We met all these goals and have invested over $200 million in our transmission and distribution system since the beginning of 2020, while still maintaining some of the lowest T&D rates among New England IOUs, even after our most recent rate case, which was our first in over 3 years. These successes are attributable to the 450 Mainers who show up every day as Versant Power employees and give their best to serve our customers and communities. Whether or not this legislation moves forward, Versant Power believes that we, policymakers, the Commission, the OPA, and the utilities, must do better to work together in a constructive and collaborative manner if we are to make substantive progress on Maine's climate agenda. Decarbonization and electrification of our economy are profound transitions that demand not only our attention, but our willingness to cooperate to ensure that we address the existential threat that climate change represents and the opportunities that we have as a state to forge our position as leader in this journey. In closing, I appreciate your time and consideration, especially by taking me by phone. Versant Power strives to improve every single day and is committed to meeting and exceeding our customers' expectations. We remain ready to work with you to implement an energy future that benefits all Mainers. I'd be happy to take any questions that you have. Thank you.
Thank you, Mr. Flynn. Are there questions from the committee? Representative Grahowski.
Thank you, Mr. Chair, and thank you, Mr. Flynn, for being here despite technical difficulties. I just had I know the answer to this question, but I'm going to ask it because I think it is relevant to my committee members to hear the answer, because I know that other than Representative Foster, who represents a couple towns that have Versant as their electricity T&D utility, I'm the only other person that does have that, and so committee members may be less familiar with the particulars of the purchase of Versant from Emera Maine and the stipulation there, but is it not the case that that stipulation is what prohibited Versant from going to the Public Utilities Commission for a rate increase until it did? That I just want you to clarify that that 3-year delay in the rate increase was not by Versant's choice so much as it was by the actual requirement in the purchase.
You're correct, Representative Grabowski, beginning in February of 2020 when or March of 2020, I believe, when the acquisition approved, we did agree to a stay out period, and Emera Maine had not been in for rates prior to that. There hadn't been a rate change prior to that since July of 2018. So you're correct in that.
Thank you for clarifying that. And another question I have is related to one of the main, I guess I would say, most recent complaints that I hear from constituents. You talked a lot about what your billing accuracy, and I wonder if you can clarify if certain things that I would consider to be billing issues maybe aren't counted in that metric. In particular, I'm aware of people sending payments to your payment processing center, which I believe is in Pennsylvania now, and not having those applied in a timely fashion, receiving, in some cases, late charges. They have to spend then an hour or two on the phone to rectify these issues. So the bill was initially put out correctly, but it's the receipt of the payment that's been a challenge. And then I don't know if the subsequent billing issue of charging a fine counts as a billing error. And I wonder if you could comment on what, if anything, Versant is doing to deal with what I think is experienced by the public as a billing issue, and whether or not those are metrics that you're tracking. I mean, in some cases, we're even talking about 2 checks in the same envelope, one being applied, one not being applied. It's hard for me to understand and sort through this issue with constituents. Thank you.
No, so let's parse that out. You're absolutely right. The billing error metric that we report to the PUC and as established by the PUC in 2019 is in early 2020 is in fact the accuracy of the initial bill. We are aware that we've had a couple of different issues as it relates to processing. One, as you said, has been errors by our processing vendor, and the other has actually been delays due to mail delays, which we've had on both the outgoing and incoming portions of our bill. And we've worked very hard over the last couple of quarters of 2021 and continue to do so to address both of those. The last I talked to our head of customer and communication, we are in really good shape. We believe we resolved most, if not all, of those issues. But I will follow up Representative Gachowski and make sure that in fact is the case. I will say one of the things that's really helped us improve our billing system and improve our billing accuracy and our ability to follow up on a timely basis is we went live with a new customer information system and billing system in August of 2021, which was a very successful go live. And we believe that actually is one of the foundational building blocks as we move forward that will help us provide an even better customer experience, moving beyond just pure customer service to a customer experience.
Any follow-up, Representative Grabowski?
I think I'm all set. I just, thank you for continuing to, pay attention to what might not be within the metrics, but is really important to our constituents. I'm sure that's true in CMP territory as well. And especially, I myself, being a Versant customer, did not notice anything new happen in August of 2021. I don't know if that was both districts or just the main public district, but I'll have to go check that out. And thank you for taking the feedback and improving upon the service quality.
My pleasure, Representative Gachowski. I'm glad you didn't see anything. That was kind of the intent, was that it would be seamless to the customer, but that your overall experience would improve. So I appreciate that, and we will certainly continue to follow up. We do interact with our customers. We did a number of customer focus groups this year, and we know well that the number one element around customer service that bothers our customers most is our errors around their billing. So we do pay a great deal of attention to that.
Any follow-up, Representative Grabowski? Anything else? Okay. Others? Seeing none. Thank you for joining us, Mr. Flynn and Jason.
Thank you.
If we could, I'm going to bring in Mr. Dick Rogers, and I just want to say I truly appreciate everyone who's been waiting patiently. I know that most of you are not paid to be here. You've spent the whole day with us. We greatly appreciate you. But Dick Rogers did have his hand up, so we'll go to him next. And whenever you're ready, Dick. Jason, are we having the same issue?
How about that?
There we go.
Okay.
We got you now.
Okay, Seth, what I was saying was I can stand by. I put my hand up because you said you saved the best for last.
That's
and I thought
okay.
You'd gotten to the
Well,
last.
you're in now, like it or not. So why don't you jump right in?
Okay, Representative Barry and members of the Joint Standing Committee on Energy and Utilities. As was noted, my name is Dick Rogers. I worked for Central Maine Power for nearly 40 years. The last 10 years as business manager for Local 1837, which represents approximately 1,600 workers in Maine and New Hampshire, with roughly 850 to 900 workers at Central Maine Power and Versant. I couldn't be prouder of the work that these utility workers do. I represented them and I was proud to do so. I never intended to be back before you again, as in the past, and with no disrespect, I'd rather be climbing a pole in an ice storm than testifying. But I believe the issue of government control power is an important one, which I believe is bad for the ratepayers and the employees of CMP, Versant, and the many contractors who do utility work in Maine. In full disclosure, while I retired from CMP in October 2020, I continue to be a member of 1837, serving in a part-time consultant's role. I also came fully out of retirement in December of 2021 to work for the Maine Affordable Energy Coalition to oppose the referendum question concerning government control power. I'm supported in that effort by large and getting larger groups of unions across Maine, including the support of the National IBEW, who have come out publicly opposing government controlled power due to the uncertainty and risks that they believe would happen if this were to come to true. I want to be clear that I was not hired to oppose LD 1959, but I, as an informed ratepayer, staff member of 1837, and someone who's been out in the field, felt it was necessary to come forward. I was very involved with what I believe was the prelude to LD 1959, Seth Berry's bill, LD 1708. I was involved in that bill almost since its creation. Seth had contacted me early on and wanted my knowledge, experience, and opinion on his proposal to form a Maine Power Authority. When this was rolled out to the public and the media, my statement was at the time, something had to change at our utilities. Staffing, cess bill, or something, but there must be change.
And Dick, I apologize. I'm just gonna make sure you are gonna come around to this specific bill that's before us, right?
Yeah.
Great, thanks.
You've seen my testimony, so you must know.
I did not see it actually.
Okay. All right. Well, you have it. I did submit it.
Great.
So,
thank you.
Something needed to change, and in my opinion, at least partly due to the bill that Seth proposed and PUC actions, needed changes happened and continue to happen at Maine Utilities. Those changes included increasing the number of customer reps, field personnel, linemen, along with more commitment to updating the infrastructure. It's my opinion the PUC has the ability to make sure the utilities are held accountable and measured against their own record and history, not some contrived industry standards. It's unfathomable of me to think that government trying to run a company at a cost of estimated to be over $13.5 billion is a good idea. We know how deregulation mandated by the state in the 90s has worked out for the Maine ratepayers. Just look at your energy supplier costs in your last bill. Yet the same critics of our utilities are out there now. In addition to increasing the staffing over the past few years, many are not aware of the recent management changes at CMP. You heard earlier from Joe Purington, the new president and CEO of Central Maine Power. I might have remained silent if not for Joe Purington taking the reins. Of all the hundreds of management people that I've found myself dealing with over my tenure as business manager for Local 1837 and my 40 years in the utility world, Joe is the most competent and trusted person I have ever dealt with. Joe is a born Mainer with utility experience and the drive to bring CMP back to the company he reached to know. He's already made major changes, including bringing back all the directors to Maine. Now the decisions are being made here, not in New York and Connecticut. The hiring of Vice President Adam DeRosa was a perfect example of Joe's leadership. Adam has what it takes to make sure the needed resources and to make sure we continue to improve the reliability of our system.
And Dick, I gave you a little extra time.
Done.
Just okay, great. Thank you.
Okay, bear with me. From the union's point of view, Adversant, John Flynn was brought in as president in November of 2021 and brings a vast experience to the electricity industry. To date, John has been interested in all facets of customer service and is committed to working with 1837 to have a great workforce, which in turn makes for great customer service. From the union's point of view, public sector unions also have a more difficult time negotiating fair contracts, which is in part due to the fact that we lose the threat of striking, and there are many other issues that I'll submit in my written testimony.
Thank you, Mr. Rogers. Thank you. Your time is long since expired. We get 3 minutes each. I do apologize for cutting you off, but I had to ask you to summarize there, and appreciate your waiting.
Well, it's 1837's position that it ought not to pass.
Thank you.
That?
That's very helpful. And there are some questions for you, so you've got another bite at the apple.
Awesome.
Representative Grahowski.
Thank you, Mr. Chair. Thanks, Mr. Rogers, for the testimony. I didn't get a chance to read it yet as it came in later this afternoon. I am kind of confused, though. I've heard a couple names thrown around. Exactly who are you testifying on behalf of today? And are you paid to testify in that capacity?
I'm on staff with Local 1837. That's who I'm testifying on behalf.
Okay, not any of the other groups that you mentioned.
There's only one other group other than myself.
Because I think when you signed up to testify, it said something else like Maine Affordable Energy Coalition.
That's what I said earlier.
That's just your own group you've created, or what is that?
No, it's not. Maine Affordable Energy is fighting the referendum question that's out there now. I was hired on to work with them in that effort against the referendum question, not against 1959. I'm here today representing 1837's point of view, along with my own as a ratepayer of the state of Maine. I think
Okay.
I have that right. Yeah.
So it's just sort of an error that you attributed your testimony to that other group, and you're not being paid to testify on behalf of that other group right now on this bill.
I wanted to disclose it so that you knew that I did, work for that group. I didn't want that to be hidden somewhere.
Okay, thank you for explaining that.
Sure.
Thank you. And that is how it's reflected in the record. I don't know if there's a way to change that if you wanted to, but we'll go next to Representative Foster.
Thank you, Mr. Chair, and thank you for extending Mr. Rogers the same courtesy you have other speakers today on going over the 3 minutes. Mr. Rogers, it's good to see you again. Congratulations on your retirement. And I only want to say, today, I wish I had been standing out there watching you up that pole in an ice storm doing your work. So thank you for your testimony.
Thank you very much.
Great. And are there other questions from the committee? I did add some time to the clock, Mr. Rogers, because I want to make sure you did have the full time, but we do have a 3-minute clock, and you ended up with 4.
I appreciate that.
You're very welcome. Any other questions for Mr. Rogers? I want to make sure the whole committee has time to ask. Okay. I have a question regarding government control, because you did refer to that. And I guess with respect to this bill, you're referring to the consumer ownership idea that's in this bill, where if a utility were found by the commission to consistently fail to meet standards, that it would then be ordered to divest, and Section 5 of the bill requires the opportunity for a consumer-owned utility to be proposed as an alternative. And part of your concern, if I understand you correctly, is that that provision of the bill would not provide any protections for workers. Is that accurate?
I think it would give us less bargaining leverage, as indicated by the International, who's done the research to look at this, Seth, and as you know, our own attorney at 1837, who has done the research. We would be private sector employees under this.
Well, we're not talking about LD 1708. With all due respect,
even under the governors.
Thank you. But I just really want to make sure we're talking about this bill before us today.
We are.
So there is no specificity in this proposal, as I read it, regarding whether you'd be in the private sector or public sector, whether the workers would be paid more or less, what the benefits would be. Well, in fact, whether the workers would even have jobs for this utility. The proposal before us doesn't even specify, as I read it, whether the workers that are currently with the utilities would have a job if the consumer-owned utility were created. I want to make sure that you're clear on that, and offer, if you want to come back to the work session and get back to us on your thoughts on that aspect of this bill. It seems to me to be an important question. If we are going forward, including Section 5 of the bill, there's nothing that says that the same workers would have a job if that transition were to happen. What I don't know, and maybe you recall, is whether it's required in any divestiture. The PUC can currently order a utility to divest, and I don't believe there's any guarantee that the workers retain a job in an acquisition. Are you aware of?
I'm not aware of any other than, do you want me to 1708, which you've put certain securities in there for the unions and for the workers. I understand that.
No, I don't mean to
Let me
bring that up.
just say this. I don't know where they'd get the workers. Part of the problem today is we don't have enough line workers in the country. So I'm pretty sure they wouldn't just let them go.
They are valuable. I would strongly agree with that. And I had another question. Oh yeah, on the matter of government, you've spoken about government control, and I guess that's the concern is relating to that Section 5 of this bill. And I just wanted to understand a little bit better. The PUC would oversee this process that we have, that the governor's proposing in this bill. The current utilities that you spoke about are owned by governments right now.
They're private sector unions right now, Seth.
I understand that, but
right.
So
our
the concern,
attorneys,
but
our attorney's opinion is that if this went forward, they would no longer have that protection. They would then become private sector unions.
They are private sector unions right now.
I mean, public sector, excuse me, public sector unions.
Thank you. So when you talk about government controlled, you're not referring to the PUC having control, which it does now. You're not referring to a foreign government owning a utility like Versant or Qatar, Norway owning CMP. You're referring specifically to how the workers are categorized. Is that right?
That is correct.
Thank you. I just wanted to clarify that.
Sure.
All right. Any other questions for Mr. Rogers? All right. Seeing none, we appreciate your joining us.
Thank you.
In opposition to the bill. And we'll go next to hear from folks in order as I see them in attendees, starting with Adam Zuckerman. And Jason, if you could beam him over, followed by Emily Rochford, whose name I'm sure I'm mispronouncing and I should know better. Adam, whenever you're ready.
Great, thanks. Can folks hear me?
Yep.
Fantastic. Great, just pull up my testimony right here. Good morning, Senator Lawrence, Representative Berry, and honorable members of the Joint Standing Committee on Energy, Utilities, and Technology. My name is Adam Zuckerman, and I'm the lobbyist for the Maine People's Alliance. 40 years ago, low-income ratepayers in Lewiston and Auburn founded MPA to fight for reliable, affordable electricity. That's why I'm here today to testify in opposition to LD 1959, an act to ensure transmission and distribution utility accountability. While the word accountability is in the bill's title, it is severely lacking in the actual legislation. It relies entirely on the unelected and unaccountable Public Utilities Commission, which has failed for years to effectively regulate our last in the nation utility. In his testimony, Mr. Purrington referred to a $10 million penalty as supposed proof that the PUC is doing its job. What he failed to mention was the PUC simultaneously approved a double-digit rate bump for the utility, far outweighing the penalty. This bill does not create any new powers for the PUC, but rather reiterates the powers that it has long failed to wield effectively. LD 1959 does nothing to address our state's skyrocketing energy costs and has no path to achieve the kind of cost savings that a consumer-owned utility would provide. It is anti-democratic, consolidating power in the hands of one person. It allows the governor to appoint the PUC, the public advocate, and directly or indirectly, all members of a new group who, if called to, could attempt to create a consumer-owned utility. However, both of this year's candidates for governor are firmly opposed to a consumer-owned utility and have long blocked accountability for our electric utilities. Why should we assume that the members they would appoint would be any more open to reform than they have been as governor? Last summer, the House and Senate both approved a meaningful step towards energy democracy, affordability, and real accountability, LD 1708. 50,000 Mainers have already signed petitions to send the COU proposal to the ballot. This bill undermines a public process that is demanding real change, provides political excuses in an election year, and creates false hope, diminishing the chances of actual progress. This year was the fourth in a row that CMP ranked worst in the nation in JD and Power Associates customer satisfaction survey. The survey ranked CMP dead last out of all 88 major utilities in the nation. Coming in third worst was Versant, with the same score as California's PG&E, which went into bankruptcy after burning down massive swaths of the state. If that is not a wake-up call, I don't know what is. Just like our founding members did 40 years ago, I'm here today asking you to fight for affordable, renewable electricity. Please do not stand in the way of real reform. Thank you, and I'm glad to take any questions.
Thank you, Mr. Zuckerman. Any questions from committee? All right, seeing none, we appreciate your patience. And Emily is next. We're saving the best for last, folks. Emily, welcome, and the floor is yours.
Thank you, Representative Berry, members of the committee. My name is Emily Rochford. I live in Unity, Maine, and I am testifying on behalf of the Maine Youth for Climate Justice, a coalition of over 300 youth from across the state fighting for bold climate action and a just transition to a livable future in Maine. I'm speaking in opposition to LD 1959. While accountability for energy utilities is a desperate need in the state of Maine, the words of Greta Thunberg best describe the practicality of this bill as nothing but blah, 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 empty words with no action. As drafted, LD 1959 provides no new mechanisms to address the needs of Maine people. It lacks basic principles of democracy, justice, and accountability, which ratepayers and Mainers deserve, and which you are obligated to uphold as their representatives. Lastly, this bill lacks any real climate action and fails to meaningfully address the necessary role of utilities in the clean energy transition. Democracy within the energy sector requires giving the people a voice and a direct opportunity for decision makers to hear it. This bill instead puts all trust in the same institutions that have failed us, a PUC composed of 3 political appointees and an appointed public advocate. This system has resulted in consumers paying some of the highest rates for the poorest service in the country. When critical issues arise, both now and under LD 1959, Customers can only rely on a PUC that is, by design, insulated from both public input and accountability. With the skyrocketing rise in electricity prices, including the temporary cost spike and the more permanent delivery increases as seen in August and November from CMP and Versant respectively, many ratepayers are faced with bills they cannot afford to pay. LD 1959 does nothing to address this critical issue of costs, once again leaving the most vulnerable Mainers behind. Ratepayers need and deserve a bold, concrete plan that would effectively lower rates and increase reliability and promote the transition to a clean energy economy, similar to that plan for consumer ownership, which members of this committee found necessary less than a year ago. Lastly, LD 1959 lacks any real climate implications and allows the utilities to continue to act as a roadblock to renewable energy development. Any institution can make claims and plans to mitigate the effects of climate change without following through. The requirements included in this bill centralize protecting utility assets from climate change and not leveraging our utilities to be a climate solution. LD 1959 completely misses the mark on climate, and we cannot afford any more blah, blah, blah from our legislature. On behalf of our own generation and the future generations of Mainers, we urge you to take meaningful steps towards democracy, justice, and accountability in our energy sector, and to oppose LD 1959. Thank you for this opportunity, and I'm happy to answer any questions.
Thank you, Emily. Any questions from the committee? All right, seeing none. Thanks again for your patience and sticking with us and for your testimony. And we will go next, Jason, to, let's see, William Pierce, followed by Sydney Benjamin. And I'm not seeing William Pierce.
William doesn't seem to be accepting the invitation.
Okay.
So
Got it. I will try again at the end. And we'll hear from Sydney Benjamin and then Seth Hall. All right, welcome, Sydney, and please proceed.
Hi, everyone. Representative Barry, committee members, my name is Sydney Benjamin. I live in Biddeford. I'm here to testify as a concerned citizen in opposition to LD 1959. I'll try to keep this brief because I know we've been here for a while and I think most of my points have been already elaborated on. But to be blunt, my biggest problem with this bill is I believe it sets a disturbing precedent for what acceptable accountability looks like writ large. It gives the appearance of recognizing a very serious issue for Mainers today, that our investor-owned utilities are failing us. And yet in practice, this bill does essentially nothing new to address any of those pressing concerns. We don't need scorecards from the Public Utilities Commission. They're just going to tell us what we already clearly know, as has been testified over and over again today. CMP and Versant are ripping off their customers for some of the worst quality service in the nation. This bill attempts to give lip service to that pain without making any true actionable change or upsetting the status quo in any way. LD 1959 appears to have been written to give CMP and Versant a blank slate, one that they clearly don't deserve. While the bill's name is flashy and makes gestures towards accountability, the actual substance of this measure simply gives these utilities more time to continue to act irresponsibly and to do so under the guise of reform. Honestly, after listening to hours of testimony today, this bill feels like exactly the kind of legislation that makes folks not want to trust their government. To try to pitch something like this as any kind of accountability or reform feels dishonest. It feels like a marketing tactic, and I say that as someone who works in marketing, one that's designed to direct the public's attention away from the severity of this issue. In short, this bill sets the precedent that performative acknowledgement of a grievance is a complete acceptable solution for our representatives to provide us with when we call for reform. It makes a mockery of accountability and provides investor-owned utilities with a buffer from further citizen pleas for actual reform. I urge you to put the needs of your constituents first, to not accept this step backwards, and to vote ought not to pass on this measure.
Thank you, Sydney Benjamin. Are there questions from the committee for Sydney? Seeing none, we really appreciate your sticking with us and making sure you had an opportunity to weigh in. Take care. And we'll go next to Seth Hall. And then on deck, we'll bring in Scott Vlon. Mr. Hall, welcome, and the floor is yours.
Thank you very much. Representative Berry, members of this committee, my name is Seth Hall, and I come to you today to speak in opposition to LD 1959, which you're currently considering. I hail from Waldoboro, where I live and operate two small family businesses, both of which have long suffered pretty high electric utility bills from CMP and seemingly ever increasing electricity rates, both on the T&D and the supply side, only recently surpassed by the supply side. I think it's important to mention. I would like to add that I'm generally a supporter of Governor Mills and her administration's actions and policies. That said, for reasons I do not understand, the governor's proposed this legislation, which is undemocratic, structurally deficient, conceptually inadequate for the problems it claims to attempt to solve, and almost certainly will not work if passed into law, if past history is any guide. The lack of adequate provisions for public participation and accountability is also painfully obvious, not to mention anything being said about rate control. Specifically, this legislation proposes to keep virtually all of the power to regulate Maine's investor-owned utilities vested in the Maine Public Utilities Commission, a non-democratic group appointed exclusively by the governor, which has chronically failed to adequately regulate Maine's electrical power distribution utility monopolies for decades. The PUC is, in my opinion, a regulatory agency that is basically captive to the very utilities they are charged with regulating, and has so far shown no effective ability to truly protect the interests of Maine utility ratepayers, which is by law their principal charge and mission, although that's been clearly debated here today. The Maine legislature, largely guided by this committee, has deliberated long and hard about how to help provide reliable, affordable electric power to Mainers, and last year passed landmark legislation in the form of LD 1708, which would have created a nonprofit, independent, democratically accountable consumer-owned utility, the Pine Tree Power Company, as an alternative to the long-existent and largely dysfunctional investor-owned utilities operating under the PUC's largely ineffective oversight. For reasons known best to herself, the governor chose to veto this forward-looking and much-needed legislation. And to add, at least to my confusion, the governor has recently appointed a new public advocate who, notwithstanding his other laudable long work, was for something like 40 years a legal advocate, and I would say a lobbyist for Maine's two investor-owned electric utilities. To say that this represents appointing a fox to watch over the henhouse is at best an understatement. Not surprisingly, the logic informing the governor's behavior truly escapes me. In closing, I oppose LD 1959 because it does not really offer anything new about regulating the truly awful performance of CMP and Versant. Or to make more accountable, as the title of the proposed legislation suggests. Instead, it pains me to say, this appears to me to be a cynical attempt to maintain the status quo, I fear for political reasons, which are definitely not in the best interests of Maine's long-suffering ratepayers. Thanks for this opportunity to speak with you today, and if I can answer any questions, I'd be more than happy to.
Thank you very much, Mr. Hall. And are there questions from the committee? All right, seeing none. Again, we really appreciate you and everyone that's stuck with us here, and you're making sure to weigh in on this important legislation.
Thank you.
Take care. Thank you. And Scott Vaughn, up next.
Hello, Representative Barry and esteemed members of the committee. Thank you so much for your attention and indeed endurance in this hearing today. 2022 finds Maine and indeed the entire planet in an ever deepening climate emergency. To mitigate the most severe impacts of this emergency will require swift decarbonization of our economy, including beneficial electrification of the transportation, housing, and manufacturing sectors, as well as a rapid transition to clean, renewable sources of energy. Thanks in large part to the Governor's Office, Maine's forward-thinking climate action plan, Maine Won't Wait, and the subsequent Community Resilience Partnership will move us in the right direction. Unfortunately, as written, LD 1959 will not. My name is Scott Vaughn, and I'm the director of the Center for an Ecology-Based Economy in Norway, where we've been working towards a just transition to a post-carbon economy for the last 9 years. And whether we're working for favorable community solar policy, trying to get a megawatt solar project on a sealed municipal landfill integrated onto the grid, or simply hooking up public solar-powered EV charging, CMP has either fought us outright, dragged their feet, or simply proved inept. We need better. Maine needs electric utility partners that are less interested in avoiding fines by barely meeting minimum industry standards than they are about leading Maine to meet its ambitious but essential renewable energy and beneficial electrification goals. So whether it's public housing or community solar, CB is committed to a democratic, cooperative model where profits are recirculated in our local economies, where essential enterprises like our utilities and our food system are rooted in community, where accountability is built into the DNA of an enterprise rather than forced upon it by punitive regulations. Rather than fostering cooperation, LD 1959 seems like a hastily constructed outline for an increasingly adversarial relationship, rather than one of cooperation with shared vision and goals. Maine needs visionary leadership guiding our public utilities through this crucial transition, and there is little time to waste. This bill takes us in the wrong direction, essentially rewarding the mediocre and miring us in the status quo of failure. I urge the committee to vote ought not to pass on LD 1959 and work instead towards a meaningful transition to a democratically controlled public utility that serves the needs of Maine while working to ensure a livable climate future for its people and planet. Thank you, and as always, welcome any questions.
And thank you, Mr. Vaughn. Are there questions from the committee? Just quickly, CB, the Center for Ecologic and Biological, I always get it wrong.
An ecology-based economy.
Ecology-based economy, based in Norway, correct?
Correct.
And do you have a large membership? I mean, it's not a major metropolitan area there.
No, we have our mailing list is around 1,500, our electronic mailing list, something like that. And we're part of lots of coalitions, some of which you heard from today. We have 2 full-time staff right here on lovely Main Street.
Excellent. Thank you. I'll have to visit sometime.
Thanks for being here. Please do.
Any other questions from the committee besides my off-topic questions? Okay. Seeing none, I appreciate your joining us. And I neglected to say who was on deck. Randall Parr, if you're able to hear me, you are up next, and we'll go after that to Mark Morissette. And Jordan, why don't you bring Mark right in, just in case Randall can't join us. Randall, can you turn on your video and unmute? If you can hear me.
Can you hear me?
We can hear you, yes. Does video work?
Okay. I don't know. I don't see myself.
All right. If you're able to turn on the video, go ahead, and it would be there might be at the bottom left of your screen a start video button. You're not seeing it?
I don't see it, no.
Okay, why don't you just go ahead and deliver your testimony?
Chairman Lawrence, Chairman Barry, members of the Energy, Utilities, and Technology Committee. I am Randall Parr, Appleton, Maine. I'm a Central Maine Power Net Energy customer and our power supporter. Unless properly amended, I oppose LD 1959 because, number one, it relies on neither elected nor directly popularly accountable Maine Public Utility Commission members to improve CMP and Versant utilities serving Maine. It does not create a new Maine Public Utilities Commission powers. It restates existing powers they did not use. LD 1959 has no public participation requirement. LD 1959 does nothing to address the steadily growing energy costs caused by exorbitant utilities profits. As of January 9, 2022, CMP and Versant charged 49% more per kilowatt hour for residential delivery than Maine's existing consumer-owned utilities, which serve part of all of 97 Maine towns. In contrast, long-term solar energy costs are dropping exponentially, and battery costs are falling mainly linearly. Central Maine Power and Versant delivery rates keep rising. In the last 6 months, CMP was given a 13% increase and Versant a 17.5% increase, despite rapidly declining costs. Of solar and wind energy around the world.
Still with us, Randall?
LD 1959 offers a realistic path to 10% savings on customer bills that a customer-owned utility would bring. It lays out reliability of service, frequency of customer complaints, and invoice accuracy minimum standards, but relies on opaque processes that insiders and utility lawyers can easily manipulate. Leaving affordability out of the conversation, ignores hardships of Mainers struggling to pay electricity invoices. LD 1959 models a process that is demanding real change, provides election year political excuses, diminishing chances of progress toward a customer-owned public utility. LD 1959 does not specify governance, taxation, workers' protections, credit without state debt, other specifics, how a customer-owned utility would be created. LD 1959 mentions a committee that would be convened, appointed by government leaders. Our power referendum, which requires more planning than LD 1959, specifies how the consumer ownership transition would occur. LD 1959 leaves open the possibility of handling off Main electrical grids to other investor-owned utilities that could continue abusing captive Main customers.
And Mr. Parr, I think your 3 minutes has concluded. I neglected to turn on the timer, but if you could just summarize.
Climate change impacts. They talk about a plan in the last section. I just got 2 more points. In reality, this is only a plan to protect utility assets and not climate change. I guess the rest of my testimony is online. I support transforming CMP to a customer-owned utility. This bill as written would make the COU more difficult to accomplish. As currently written, LD 1959 ought not to pass. Thank you for the opportunity for speaking to you today. Thank you very much. Bye-bye.
Thank you, Mr. Parr. Just hang in there one moment. One moment while I see if there are any questions from the committee. And seeing none, we greatly appreciate your sticking with us and chiming in today. And we will send you back over to the attendee space. And next we have Kenneth Colburn. Apparently, Mark Morissette is waiting for the next bill. And we will go next to, might need a little help here. Jason Kendra or Kelly, are they here for this this current bill?
I think in attendance right now, we only have John Browdigam.
Browdigam, yep. And that's it? Okay, here's what I'll do. If you are still here to testify on LD 1959, could you raise your hand? And whether you're for it, against it, neither for nor against, anyone at all who's still wishing to testify, just raise your hand. We are nearing the end for this bill, and then we'll get to 1955 after that. Thanks everyone for your patience. And Ken Colburn, are you able to join us with video? There we go.
I am. Thank you very much, Chairman Barry, members of the committee. It's good to be back with you again. I'm a resident. My name is Kenneth Colburn. I'm a resident of Bar Harbor, Maine. I'm retired, but having trouble doing that, as you probably already know. I'm supportive of some of the provisions of LD 1959, but I appear before you today in opposition to it because I think it's inadequately targeted. It's unlikely to accomplish its purposes, and it may easily create some unintended consequences. The good parts of it, I think, are reasonably obvious. It represents recognition that Maine citizens are fundamentally dissatisfied with the quality of the performance of their electric utilities and endeavors to do something about it. And the provisions in Section 3 of the bill, somebody earlier characterized them as whistleblower protections, I think are useful additions to the statute. My concerns are that LD 1959 misses the mark in several key respects. Primarily, it reflects an obsolete view of the rapidly transforming power sector, and it omits major reliability yardsticks and major areas of concern to Maine citizens. The Section A on its report card only includes the usual yardsticks. It doesn't say anything about climate change. It doesn't say anything about the integration of renewables beyond just their interconnection, how they're run as part of the grid. It doesn't say anything about distributed energy resources or behind the meter generally, or storage, or beneficial electrification. Nothing about the innovations that are coming, and I hope we could spend a little time on that later, or resilience, which is different from reliability. Reliability is how often do you go out and how long. Resilience is how fast do you get back and how do you handle it. Section 1B, the next section, institutes quarterly reporting, but I think quarterly is too rapid a period actually for the kinds of data that we're talking about here. Things don't change that rapidly, generally speaking. In addition, Maine's utilities are, as you've already heard earlier today, demonstrably inexpert in their information systems and certainly in their data transparency. So that means, as Mr. Jordner said earlier, that they have all the information. And as a result of that being the case, and the PUC getting only that which they provide, there's an information asymmetry involved here. There isn't an even hand. And as a result of that, regulatory capture can be enhanced. That's where the commission is more apt to side with the utilities than the citizens. And overall, this information churn is going to create costs, which are going to have to be borne by both the utilities in preparing those reports and in the commission in analyzing them. And those costs, of course, are ultimately paid by ratepayers. Section 1C and section 2 of the bill essentially restate the existing authorities of the PUC. So it raises the question of how do you expect a different result by pursuing the same path? Einstein said something about that once upon a time. Section 5 seems to toss the hot potato of potential divestiture from its proper home in the legislature, proper home with elected officials, over to the PUC. This is, I'm aghast to contemplate that. I think it's irresponsible, and I served as a regulator for many years. We often went back to the legislature to get explicit authorization, even when we had arguably existing authorization, just so it was clear that the public policy was in that direction. In this case, we want to hand a hot potato so we don't have to deal with it. Policymakers should certainly use agencies because of their technical knowledge to help guide them, to advise them, to help implement their decisions. But to make the decision, that's your job. That's why we elect you. And thank God you're all serving, including on today. Section 5.3 takes a similarly obsolete view of the electric power system. It characterizes net benefits for citizens as lower rates and better service. That's not a bad thing, certainly. But once again, what about climate change? What about electrification? What about shaping loads? What about the technology innovation that's coming down the pipe? What about the risks involved? What about resilience? None of this stuff is in there. Section 6 takes a similarly outdated view. That's the one that talks about climate change, but it talks about climate change in the context of maintaining the existing transmission and distribution system. This is like grid hardening provision. It's not a using the grid more efficiently, using the grid with behind the meter distributed energy resources. It's not making things more efficient so you don't have to depend so much on the grid. So it is similarly flawed. The conclusion is that this is a well-intentioned but inadvisable effort. It effectively shifts the burden of these issues away from the legislature, putting them on the PUC. The regulatory processes, the adjudicatory processes that have led to this situation are not likely to be the place where they can be solved. There's a fundamental problem that we face that's been made clear by plebiscite in the state, and there is no fundamental modification here. Are there some things that you could do with a bill like this? Certainly. You could require utilities to become B corporations, or you could undertake other similarly fundamental changes, but they are not included in this bill.
Thank you.
If I could
Mr. Coburn, I just need to ask you to wrap it up, because I think we're at time. Yep.
Let me do so quickly by simply indicating for the last 100 years, we've managed the grid by turning the knobs on the power plants. We have managed supply to respond to demand. You can't do that with wind and solar, and those are the cheapest alternatives going forward. So for the future, we'll have to manage demand. And that means close relationships with customers, because they will soon have the opportunity to defect from the grid, just as we have seen with telephony, mobile phones, and with laptop computers. Power's next. This is not the time to ignore that and perpetuate an existing system. Thanks very much.
Thank you. And other questions from the committee? I actually have one. Mr. Colburn, you are on the Climate Council. You're the co-chair of the Energy Working Group. I understand you're here in your personal capacity today. But I wanted to just ask if you see this bill intersecting in any way, pro or, good or bad, pro or con, with the work of the Energy Working Group. Is there an intersection of any kind there?
I don't think so directly, Representative Berry. I think that the structure of the utilities can help or hurt. I guess one reflection I have is that I see some sense of potential progress on the Versant side. I see less of that on the CMP side. So I worry about painting all with the same brush if that hope is justified. But I'm not sure how to advise you with respect to the goals of the Climate Council in parsing that problem. I don't envy your work. These are tricky and tough issues, and that again is why we put them in the hands of elected officials. Thank you.
Thank you. And the legislature is up for re-election every 2 years, so come on in. The water's fine. And I want to ask also about you mentioned a B Corp. Can you just say briefly how that might work? And, you know, if we were to try to go forward with something in this or some other legislation, just briefly, do you have experience with utilities that are B Corps, and what do you see that's positive in that model?
I'm aware of some, Representative Berry. Green Mountain Power is one and is a good example of working closely with its customers and is regarded as such. I'm not an attorney, so I don't know what would be the legal process for converting a B Corp. I imagine everybody knows there's a fairly new form of legal incorporation, which actually brings in the customers and stakeholders as a party that, as a stakeholder, that is not just the company itself or its shareholders, but actual public and members it serves. So they would have standing, if you will, as opposed to just be the recipient of the bills.
Thank you. That's very interesting. Other questions from the committee? All right, seeing none, thank you very much for joining us, Mr. Colburn. And
thanks for your
patience today. All right, and I will ask before Mr. Brodigan testifies if folks can just raise their hand if they are still here waiting patiently to testify on LD 1959. And that'll be the second to last time I asked that question. And Mr. Brodigan, you are on deck for your 3 minutes. You're up next for your 3 minutes. Go right ahead.
Chairman Berry and honorable members of the committee, my name is John Brodigan. I'm a 25-year resident of Falmouth, and I really do appreciate you staying through this long day. If there's anything of value in my comments, I want to pay homage to Sharon Stas. I learned a lot from Sharon, who I know would have been here today to the end. I served on this committee in the 122nd legislature, and I previously served as a director of the Energy Division of the Public Utilities Commission. I'm a volunteer board member of Our Power, not being paid to spend the day with you here today. There is one specific perspective I would like to offer, and it relates to the fundamental nature of utilities. When most people think of utilities, they think of poles and wires and bucket trucks and transformer stations. But there's a different way to see our utilities. They are the mechanism that we as a society created in order to finance a public necessity when it's not possible to do so through the marketplace. Our utilities are essentially a financial mechanism. They pull together the capital needed for the infrastructure of our electric grid. The amount of capital is enormous. In our lifetimes, our utilities will invest tens of billions of dollars in beneficial electrification. The cost we pay for this capital is a crucial question. Going forward, it will be more relevant to the cost than the cost of fuel was in past generations. From this perspective, the most impactful question to ask in legislation addressing utility accountability is, how much do we need to pay for that capital investment? Historically, investor-owned utilities have always received a handsome return, around 10% rate of return. Consumer-owned utilities don't have to compensate investors, so their rate of return is much lower, around 4%. The numbers vary, but the concept is solid. CMP and Versant ratepayers currently pay this 6% premium. In contrast, ratepayers of a consumer-owned utility never pay the premium. Now, these numbers seem small, 4% versus 10%. Does it really matter? Well, the answer is emphatically yes. When accessing tens of billions of dollars in capital over decades, the difference to ratepayers is enormous. LD 1959 refers to consumer-owned utilities, but sections 1 and 5 do not effectively tap into the value proposition of lower cost financing or affordability. We don't have to send tens of billions of dollars out of state. We could finance our electric grid with low cost capital if section 5 of the bill had a realistic consumer-owned utility option. There are other limitations in the bill, but my time is short. I think the biggest problem is that sections 1 and 5 will not capture the value proposition of low cost financing. LD 1959 is well-meaning, but I don't believe its consumer ownership provision would ever work, allowing us to actually access a substantial benefit of low-cost financing. And that absolutely has to be part of any discussion regarding what we can and should require of our utilities. Thank you.
Thank you, Mr. Brodigan. Well timed. And are there questions from the committee? Mr. Brodigan, were you involved at the Efficiency Main Trust as well? I know you mentioned a couple other roles.
I was at the Public Utilities Commission Energy Division when the Efficiency Main Trust was being created. It was Efficiency Main was a division of the PUC before it was sort of spun off to become the trust.
Great, thank you for that reminder. Other questions from the committee? All right, seeing none, really appreciate your sticking around.
Thank you.
And your words for us. We do have Matthew Cannon from the Sierra Club who has joined us, and this will be the final call for folks to please raise their hands if they are here to testify in favor, in opposition, or neither for nor against LD 1959. Okay. Matthew Cannon, the floor is yours.
Thank you, Representative Berry, members of the committee. Thank you for all your work on this bill on this long day. I will be very brief. My name is Matt Cannon. I speak on behalf of Sierra Club Maine. I live in Portland. We represent over 22,000 members and supporters here in Maine, and we work diligently to amplify the power of our 3.8 million members and supporters nationwide as we combat climate change and to help create a just and sustainable future. To that end, we urge you to vote ought not to pass on LD 1959. You've heard many reasons today. I'll just highlight a few of them. LD 1959 fails to address the fundamental problems of our investor-owned utilities and covers actions the PUC can already take. We see this bill as a distraction from the much-needed large-scale reforms that are needed to address our climate crisis and hold our utilities accountable. This bill fails to provide enough details on how to reach the governor's own stated climate goals and rapidly decarbonize our grid. The plan mentioned in the last section of this bill is really only a plan to protect the utilities' own assets, not to meet our urgent climate needs. As written, LD 1959 does nothing for energy affordability, energy democracy, or even real accountability. By creating false hopes, it detracts from meaningful reform. We cannot support this bill at this time, and we urge you ought not to pass. Thank you very much.
Thank you, Mr. Cannon. And questions from the committee? I may have missed it. I got a bit distracted there, but how many members do you have here in Maine at this point?
Over 22,000 members and supporters in Maine.
Impressive. Thank you. Any questions from the committee for Mr. Cannon? All right, seeing none. Thank you for joining us. And that does conclude testimony. You wrapped it up, Matthew. And we are, I made a big mistake, huge oversight. I apologize. Representative Grahowski has waited very patiently for her opportunity to testify on this bill. So Representative Grahowski, I did say we were saving the best for last. So I guess you knew exactly what you were doing.
Thank you, Mr. Chair. I would just say that I know that you all know how to read and that you will read the testimony, and I will spare us the out loud performance of reading my testimony to you all. So I'm happy to conclude with that, and please do feel to direct any questions to me after you've read it if you like.
Thank you. And I know I'll be sure to read it. There is quite a bit of written testimony posted from folks that were unable to testify, or even people who attended most of today and just had to hop off because it was a long day. So we assure you that we will be looking at all of the written testimony. We're very grateful to everyone who did testify in person or in writing or both. And with that, I declare the testimony and the hearing on LD 1959 to be closed. And at the request of the sponsor, and because she has a 5 o'clock meeting, we're going to jump right into LD 1955. I know this committee has the stamina to keep that going. So without ado, we will begin the public hearing on LD 1955. And thank you very much, Senator Vitelli and everyone waiting to testify on this bill. I don't have the title in front of me, and Jason, I know you have a list of folks to testify. I'm going to look for it right now. But Senator Vitelli, I'll let you remind me the title, and I know it has to do with net energy billing. So please proceed.
Thank you, Chair Barry, and thank you to my esteemed colleagues on the Energy, Utility, and Technology Committee. You do indeed show great stamina after this long day of testimony. It's been fascinating. So thank you for allowing me to proceed. I'm here to present LD 1955, an act to facilitate net energy billing. I will be brief. I am Eloise Vitelli, representing Senate District 23, which includes all of Saginaw County and the town of Dresden and Lincoln County. The legislation I'm here to present, again, LD 1955, is the result of concerns brought to my attention by NextAMP and challenges it was having working with CMP and Versant to get the necessary information about customer usage data to create timely and accurate bills. The objective of this bill is to facilitate greater communication and data sharing between transmission and distribution utilities and shared net energy billing project sponsors to ensure that customers participating in these projects are billed in a timely and appropriate manner. This bill is also intended to give customers greater access to their own energy use and billing data for stronger transparency. I thank you immensely for your time and consideration. I apologize for the phone ringing in the background. I'd be happy to take any questions, but you may refer others today who can speak in greater detail about the specifics and the technical issues around this bill. Thank you.
Thank you. And other questions from the committee for the sponsor? Okay, we're letting you off easy. And are there other legislators wishing to testify? For, against, either for or against? Seeing none, we will go right into the members of the public who are here to testify. And this is a relatively short list, so we'll be able to move through it fairly quickly, I think. I have first on the list, and as always with public hearings, we'll go with those speaking for the proposed legislation, then those speaking against the proposed legislation, and finally those speaking neither for nor against. We will not need to bounce around as we did with the previous bill. I have on the list I'm looking at Kelly Friend next to speak in favor of the legislation. So Jason, if you could bring over Kelly, and then
Representative Barry, I believe Toby McGrath is going to be speaking for Kelly.
Got it. Okay, we'll bring over Toby, and then on deck we'll have Caitlin Kelly O'Neill if she's still with us.
Oh, she is here now. My apologies. I will promote Kelly Friend now, I guess.
Great. We'll get to Mr. McGrath later. Kelly, welcome.
Hi there. Apologies to Toby for the audible. I wasn't sure I'd be able to stick around to my turn, but I'm grateful I was. So thank you.
Great.
So thank you, Chair Lawrence, Chair Barry, and members of the Energy, Utility, and Technology Committee for the opportunity to testify today. My name is Kelly Friend, and I am the Vice President for Policy and Regulatory Affairs for NextAMP. NextAMP is a vertically integrated clean energy company based in Boston. We were founded in 2007 by 2 U.S. Army veterans, and we manage the complete project life cycle of solar plus storage assets, from design and construction to customer acquisition and management, operations, and maintenance. We are proud to bring our fair and flexible community solar program to Mainers, offering residents and small businesses guaranteed energy savings with no sign-up costs, no credit checks, and no long-term contracts. We believe that all Maine residents, regardless of where they live, should be able to reap the benefits of solar, both the savings and the feeling of being a part of the state's clean energy movement. I am testifying today in support of LD 1955, an act to facilitate net energy billing. This legislation is crucial to ensure that the full promise of LD 1711 is achieved. As Senator Vitelli mentioned, we raised several concerns with the existing billing systems and how it related to our ability to ensure that our program met the needs and interests of our customers. This committee spent significant effort reviving the net energy billing program in 2019, recognizing the importance of a vibrant clean energy economy to the state of Maine. In response to that legislation, companies like Nexamp have invested significant capital to deliver on our commitment to bring local solar to all. We are proud to have hundreds of megawatts under development in the NEB program. Those megawatts not only represent significant investment in private capital, but thousands of jobs for local contractors, engineers, and small businesses, plus real meaningful energy savings for subscribers. As more NEB projects come online, Mainers are beginning to experience the benefits that come from supporting a cleaner electric grid. One reason why community solar is so important in the fight against climate change is because it allows a broader population to feel the benefits of supporting clean energy, which creates more advocates for accelerating our transition to a decarbonized future. The success of the shared NEB program hinges on whether Mainers see and easily understand the value of their subscriptions. Unfortunately, as we've been acquiring and serving NEB customers, it has become clear that the utility's existing billing systems are not designed to provide the best possible customer experience for shared NEB participants. NEB project sponsors need timely and accurate utility data to bill customers in a way that provides them a positive, transparent, and easy to understand experience that makes a shared NEB project feel like rooftop solar. In considering the importance of this bill, it's helpful to remember that the sole mechanism by which a community solar subscriber experiences the benefit of their participation in a community solar program is through the receipt of an electric bill that clearly identifies the savings from their subscriptions. This is not currently possible for NEB customers in Maine because neither CMP nor Versant are currently able to provide NEB project sponsors with customer-specific data detailing how NEB subscribers' credits interact with their electric charges. This presents two problems for project sponsors. First, for companies like Nexamp, we offer a fixed percentage savings discount. We need access to the monetary value of credits applied to customer bills in order to provide our customers with that fixed percent savings. So if you get $100 worth of credits and we offer you a 10% savings, you would pay $90 for that.
We're almost at time.
Okay, thank you.
Yep.
Second, without knowing how many credits were applied to customer charges, project sponsors will have to bill customers for all credits generated, not just those offset by charges. My testimony is in the public record, but I'll close by simply saying LD 1955 solves that near-term problem of access to customer data to improve and enhance and make sure that the NEB program is as accessible as possible for shared customers. But it goes beyond that to think about a future where customers have ownership over their utility data to make sure that they're empowered to seek additional opportunities to participate in the clean energy economy, further accelerating Maine's transition to a cleaner future. And thank you very much for consideration of this important matter.
Thank you, Kelly, and really appreciate your patience today. A question from Representative Foster.
Thank you, Mr. Chair. Thank you, Ms. Friend, for being here today in your testimony. I'm wondering, you mentioned earlier in your testimony that it's important for your consumers, customers to know the benefits that they are getting through their membership. And I'm wondering, does Nexamp sell RECs out on the open market?
Do we sell RECs on the open market? So we participate in any number of community solar programs, and our participation in REC markets is determined based on the rules of the existing program. So in some markets, RECs are the exchange that we get for generating our electricity. Where in Maine, that's the case, we're selling those RECs as opposed to selling them to the utility in other markets, which is how other markets are sometimes structured.
And if I may, Mr. Chair.
Sure.
Thank you, Ms. Friend. So are your customers made aware of who buys those RECs that comes from the green power that they're buying and what that goes to?
Yeah, our sales team spends a ton of time educating our customers on exactly what their subscription agreement is giving them. I actually listened into the hearing that the PUC had. I'm sorry, this committee had. I'm sorry, not this committee, that the PUC had on the rulemaking for RECs back this summer. And I went back to my marketing and sales team and I said, you know, these are the concerns in the marketplace. Let's go through our marketing materials with a fine tooth comb to make sure that we're being incredibly transparent, both on the front end in terms of how we market our product, but then also on the back end when we're actually educating customers who are executing contracts. And we spend a lot of time explaining to them that they're not actually getting, quote, green electricity. We can't guarantee that to them. What we can guarantee is that they're supporting clean energy, they're supporting the deployment of solar in the state of Maine, and that they're getting the savings that result from that support.
All set, Representative Foster. Okay, any other questions for Ms. Friend? Seeing none, thanks for joining us and
Thank you.
testifying. And Jason, can you move Ms. Kelly O'Neill over now? And while you're doing that, up next after Ms. Kelly O'Neill, we have Stephen Weems registered, but I believe he will not be speaking on the bill, but did submit written testimony. So that's what I have in the for category. We will then go to testimony against, beginning with Mr. William Harwood. So he'll be on deck. And Ms. Kelly O'Neill, welcome.
Thank you, Representative. And thank you, members of the committee. I'm Caitlin Kelly O'Neill. I'm the Northeast Regional Director for the Coalition for Community Solar Access. I appreciate you listening to the testimony on this bill after what I know has been a long day of testimony. So I'll try to keep it brief. The net energy billing program is a subject of frequent discussion before this committee. And when we talk about the program, we often talk about aggregate impacts and aggregate benefits. Yet net energy billing is at its core exactly what its name implies. It's billing. Successful implementation of the program means successfully interacting with thousands of individual customer bills on a daily and monthly basis. The program's larger goals are to build more clean energy, deliver savings to customers, and increase our supply of clean energy and decrease our reliance on fossil fuels. But to get to those larger goals, the administration and interacting with and touching customer bills on a monthly basis must be as smooth as possible. So the process of tracking generated credits from eligible solar facilities and then applying those credits to customer bills has to be seamless. The intent of this bill is to facilitate greater data and information sharing between the utility and the community solar project sponsor. In an age of justifiable concern for customer data sharing, the bill is careful to ensure that any data sharing is done so with the explicit consent of the customer. The customer is making a decision to participate in net energy billing, and the provisions of this bill ensures the customer has the best experience possible in joining. Having been active for many years in markets across the country, CCSA's members have learned that the ability to receive this information from the utility about the customer's bill and the customer's usage enables them to assign the right number of credits to that customer and provide the customer with the best experience. Receiving detailed customer level data also helps the project sponsors to troubleshoot any issues that can arise during the course of the monthly crediting process. Based upon years of experience in this matter, I can confidently say that mistakes are going to happen, despite all best efforts by both the utility and the project sponsor to avoid them. For example, a number of common errors that we see in other markets that have an expansive crediting process are bill credits are not applied to the right customer, bill credits are applied at the incorrect rate, customers are rebilled and double credited, or customers are not enrolled in a community solar project on the plan schedule. You know, this is just four of a number of common mistakes that we see across markets and utilities. Mistakes happen, and when they do, it's in the best interest of the utility to share as much information with the project sponsor as possible so that they can work together to help their mutual customer through what could be a confusing and frustrating issue. And the bill ensures that community solar providers have all the information they need to provide the best experience for that customer. So we're not only achieving the larger benefits of the net energy billing program, but also ensuring that those customers who choose to participate in community solar will not only have the benefit of helping to expand clean energy and receive savings on their bills, but also as seamless and frictionless of a customer experience as possible. So I thank you for your time. Again, we urge the committee to vote in favor of LD 1955, and I'm happy to answer any questions you may have.
Thank you, Ms. Kelly O'Neill. Questions from the committee? Ms. Kelly O'Neill, and if I apologize if I missed it in your testimony, I just had a family member come home. The proposal before us would require some additional things of our utilities. Is there a state that you would consider a model in this respect, in terms of the policies that are advanced here?
Sure. So I'll be honest, no state market has quite perfected this, but I will say in New York, there is a report that's provided by the utilities to, they call them the host customers, or the hosts of the projects on a monthly basis, that does detail a number of these data points that we are seeking. And just generally speaking, in New York, there's also a monthly working group that's focused purely on billing and crediting issues. I mean, it is not exciting at all, but it's the technical details can really clog up the program. So just being able to have the technical experts and to get the information and data enables working through problems.
Thank you. This is a question that you may or may not be able to answer for me, but there was someone who was hoping to testify on the previous bill and was unable to. And the motivating factor for this individual was that they were a solar customer. They have rooftop solar, and they were getting very high bills month after month. And they then decided to switch to an analog meter, which you have to pay extra for. And suddenly the bill dropped to, rather than several hundred a month, it was $29 a month, and it's been $29 a month consistently. There's been, if anything, overage in the production. So they're just paying for the cost of the meter plus the minimum monthly cost to use the grid, right? So that's the 29. So I'm just wondering if you think that there might be anything to that. Do you have any experience with metering problems when it comes to net energy billing and these more presumably sophisticated AMI systems?
I can't speak to that specifically. I mean, certainly there are metering problems, I think, with any sort of forward-looking update to how customers interact with the grid. And just when you do a massive rollout of a type of technology, there tend to be problems. So I in terms of like how an analog meter might, may or may not help or not help the resolution of some of those problems, I can't really provide an answer to that specifically, just beyond the fact that meters are certainly always complicated.
Mm-hmm. And it matters to your business model how the customer's usage is measured as well, right?
Right. I would say it's more just the ability to know what the customer's usage is really important, because when a community solar project is assigning credits to a customer, oftentimes they're providing an estimated allocation to what that customer will likely be able to use in that month. But I mean, customer usage changes. the production changes on an annual, over the course of the year. You get more production in the summer, you get less production in the winter. And so just having the ability to make sure, like having that customer level information ensures that the community solar provider is providing the customer with the amount of credits that they will be able to use, that they're not receiving too little or too much.
Thank you very much. Any other questions? Seeing none, we appreciate your joining us
Thank
and
you very
sticking
much.
around for the whole day.
Thank you.
All right. And speaking of sticking around for the whole day, William Harwood, welcome. And after Mr. Harwood, we will hear from, whoops, I lost it. Stephen Hudson, if he's still with us. Jason, if you could bring him over. Welcome back, Mr. Harwood.
Thank you. Thank you, Senator Berry, members of the committee. I know it's been a long day. I am the public advocate, and I'm here today in opposition to LD 1955. Given the late hour, I'm not going to read my testimony. You have it. This is a very technical area. I just want to say a couple of things. That this is something that is very difficult to sort through, and I urge you to think about sending these issues to the PUC, who has the resources, the time, the expertise to resolve these. It's going to be very difficult to sort through them here in a legislative committee. I do think you need to be careful whenever you see language in legislation like this, that it shall be the changes shall be at no cost to the program, or no cost to the solar developer, or no cost to the subscriber. That means the costs end up on the utility, and that means the costs end up on the ratepayers that I'm charged with representing and your constituents. I think we've really got to be very careful about adding additional costs to the net energy billing program. I will tell you, in the 3 weeks that I've been privileged to hold this position, nothing has caught my attention more than net energy billing. Nothing keeps me up at night more than net energy billing. It is incredibly complicated. I've tried to explain it to friends and colleagues. I don't know about you, but it is difficult to understand. It is a moving target of multiple parties. And 1955 is an example of how we're trying to fit some square pegs into some round holes in terms of our traditional utility model. And when you do that, you have resistance, and eventually you have to have additional costs and additional resources. This program is a very expensive program. You've heard from the PUC that if the entire program is built out, that's under development, we could be looking at rate increases in excess of 40%, over $360 million a year of additional costs on ratepayers. That is a lot of money. And I want to make it clear, I am all in favor of more wind and solar. We have to have more wind and solar and less fossil fuel. But let's be really smart about how we buy it. Let's make sure we get the most wind and solar we can for the dollars. And I believe that for $360 million, we can do better than this. So I look forward to working with you. I would be happy to answer questions about my testimony. This is incredibly technical, how the solar developer, the subscribing customer, and the utility interact under all of the different programs and adjustments that go on between them. And it's not going to be easy to sort out. But my basic point is, please don't add these costs onto the utility, because they end up being charged to the ratepayers as a whole. Thank you, and I appreciate your patience today. It has been a long day.
Thank you, but we're not done with you yet. Representative Foster.
Thank you, Mr. Chair, and thank you, Public Advocate Harwood, for your testimony. I've read your written testimony. I just want to clarify what I think I've read, that LD 1955 will add costs to make these net energy billing to work through this the way that the bill describes. It will add costs to other ratepayers. That's your position?
I'm confident of that, Representative Foster. I don't see, if as written, if it's implemented, it will impose additional costs on Versant and CMP, which will be passed on to ratepayers.
And Representative Foster, any follow-up? All set. Representative Sachs.
Thank you. And Mr. Harwood, I understand you said you would be available for the work session, or
Yes.
I can questions. So I also read your testimony ahead of time, and barring that, so say the sponsors were responsible for the procurement of this data. It sounds like you had additional concerns, not just related to cost. Is that correct? So if we were to change this, that's not just the simple fix of doing the sponsors paying the cost. Is that correct?
Yes, there's a number of concerns. The solar customers' eligibility for EMT and LIAP funding is just another complication when you start saying that we're going to have a LIAP funded customer now participate in the net energy billing. You've now got multiple special programs, and it's not clear how it's going to be sorted out. That's some of what the solar industry is bringing forward with this bill. It eventually will need to be sorted out, but these aren't easy questions.
Okay, thanks. I look forward to speaking with you further, but not today. But thank you, Mr. Harwood.
Thank you.
Thank you, Representative Sachs. Mr. Harwood, just quickly, I hear you on the future potential impact of the net energy billing policies and the concerns that you have there. I just wanted to check, sort of fact check one thing, or ground truth one thing. I referred to it earlier. The PUC has given me a calculation which I think is pretty comprehensive of all of the renewable energy costs, whether it's net energy billing or long-term contracts, RPS, associated with Maine's renewable energy policies. So at present, they say that the aggregate cost of that, not counting the benefits, not counting the 15% off or whatever, the costs alone are 2% of our current bills. Does that square with your understanding? And am I clear that should we be clear that your concern is for the future?
Yeah, I have no reason to doubt that numbers, but Representative Berry, I'm at the risk of taking more of your time when we're all tired. You can't underestimate the size of what we are facing. Think about what we're facing. There are over 700 net energy billing projects out there representing over 2,500 megawatts, 2,500 megawatts. Now, that's a number that's hard to process. It's bigger than Maine Yankee, It's bigger than Wyman 4 and Yarmouth. It's bigger than Wyman 4 and Maine Yankee combined. It's bigger than the Seabrook nuclear power plant, the biggest capacity we have in New England. It's twice as big as the Seabrook nuclear power plant. This is a lot of capacity, a lot of energy. And right now,
I'm sorry, I interrupted. Go ahead.
And right now, we're looking at paying something in the order of 20 cents a kilowatt hour. This is a huge amount. Can you imagine if the owners of Wyman 4 or Maine Yankee came forward and said, we'll give you all the power to the ratepayers at 20 cents a kilowatt hour? We'd say, no, thank you. That is too expensive. We can buy power. We can buy green power for 5 cents a kilowatt hour. This is a growing problem. I don't have easy solutions. I don't know the answer, but please, we all need to focus on this. This is going to be a huge problem. And it doesn't matter what the utility looks like 5 years from now. These costs are going to come home to roost. And the sooner we get on top of it, the better.
And thank you. And I was asking about the present.
Understood.
But I fully understand the concern about the future. Representative Foster.
Well, thank you, Mr. Chair. Just to follow up on your question, Mr. Howard, just to clarify, my understanding is it's been mentioned a couple of times today that one of the benefits that net energy billing offers is 15% off some ratepayers' bills. My understanding is other ratepayers are paying that freight. Am I incorrect, or am I somewhere near right?
Absolutely. Look, the subscribing customers are going to come out okay. They actually may come out slightly worse off too, depending on how you play with the numbers. But those aren't the concern. The concern are the overwhelming number of ratepayers who, for one reason or another, are not in a position to participate in net energy billing. they are going to pick up most of this $360 million a year that the PUC has estimated could come home to roost. And that's going to be a very painful result.
Any other questions? Okay, seeing none. Mr. Harwood, thank you very much for your testimony and for sticking with us until the late hours of the day. We have next in the queue Mr. Stephen Hudson, and then after Mr. Hudson, I have Mark Morissette, and finally Kendra Overlock. I think that's it for testimony against, and we'll then go to the Governor's Energy Office. So, Mr. Hudson, welcome.
Thank you very much, Representative Barry, members of the EUT committee. I'm Stephen Hudson. I'm with Pretty Flaherty. I'm here today on behalf of the Industrial Energy Consumer Group. I'm also not going to read my testimony. I do want to recommend to everyone, both the committee and those listening online, to read the excellent testimony submitted by our new public advocate. It's very, very compelling testimony. I also want to note that even though the IECG has in recent times been a critic of the current net energy billing system, I want to remind folks that the IECG fought against the elimination of net energy billing under its prior format. And in fact, my partner, Mr. Buxton, who was here earlier, testified in front of the law court, provided the argument to support net energy billing and to keep it alive in Maine. So I hope everyone realizes that the IECG does support renewable power. But we are here today testifying in opposition to this bill, not because we oppose the concept that a customer's energy data belongs to them, but rather because the consumer protections in this bill are directed to only one subset of customers, those participating in net energy billing. We are also concerned that the broad protection against disclosure may risk disadvantaging Maine's energy regulatory agencies. I'm not sure what that broad prohibition on disclosure to third parties does in relation to the PUC and OPA's authorities, but the committee should be very sure about what it does before it enacts any legislation like this. We've already heard about costs being shifted. I'm not gonna actually repeat that, but we certainly support that. But the precept that customer energy data belongs to the customer is one of the IECG's fundamental principles. Just as customers have the right to self-generate energy for their own usage, so too do they have the right of unrestricted ownership of their data. However, if a bill is to be enacted that codifies this right, it must include all ratepayers within its protections. The right of ownership and the right to privacy extends to all ratepayers, not just those receiving NDB subsidies, nor their out-of-state developers. If these rights are not confirmed for all, they should not be confirmed for any, as the exclusion of some risks compromising their right. Pardon me.
It's quite a ringtone, Mr. Hudson.
Yes, exactly. It's late, and I've been here as long as every member of this committee.
It's okay. You woke us all up. Go ahead.
Yeah.
Proceed.
Yeah.
Yeah.
Finally, we offer to our testimony an attached amendment. This committee, as everyone here knows, has spent incredible amounts of time dealing with NEB-related issues for more than 6 years. While some of that time is necessary, this bill and other bills like LD 19 illustrate that the committee is being asked by out-of-state developers to write increasingly detailed tweaks to the NEB regulatory scheme. Our proposed amendment would explicitly give the PUC the authority to make changes to that scheme, as long as such changes are designed to meet the PUC's purposes under 35A MRS Section 101. I've quoted that section, but it includes, in addition to safe, reasonable, and adequate service, assisting in minimizing the cost of energy to the state's consumers, ensuring that rates are just and reasonable to consumers and utilities, and the reduction of greenhouse gas emissions to meet the state's greenhouse gas emission reduction levels. We would suggest that the committee, if it is interested in proceeding with this bill, strongly consider the inclusion of this amendment. We'll be glad to answer questions now or at the work session. Thank you.
Thank you. And Representative Foster.
Thank you, Chair Barry, and thank you, Mr. Hudson, for your testimony. I won't be long on this, but I believe from your testimony, your written testimony, what you've just said, that as written now, this bill, you believe will cost your members, i.e. CG members, more on their electric rates.
Right.
And with that in mind, I believe in the 129th, you or Mr. Buxton provided for the committee a number of how much your total membership, and again, there were proprietary issues there, but if you could get us the number for a 1 cent per kilowatt hour increase in rates for your members, what that would mean overall to those employers in the industry in the state of Maine, I would appreciate that.
That would be for a roughly 100,000 megawatt hour a year customer, which is roughly a decent size, but not the largest paper mill in the state. For example, that if my quick numbers are right, that would be that's $10 a megawatt hour. So that would be $1 million a year.
And that is for your entire group, all of the.
No, that's for each individual large customer.
Okay, what I was wondering is, can you provide us with that number if what that
As
1 cent
applied.
increase, how it affects all of your members? Thank you.
Yeah.
That'd be very helpful. Other questions from the committee? Okay, seeing none. Thank you, Mr. Hudson.
Thank
and
you.
Appreciate your sticking around. We'll go to, whoops, who did I say was next? I apologize. I know that you know. Mark Morissette from Central Maine Power.
Good afternoon, Chairman Barry and members of the committee. My name is Mark Morissette, Manager of Billing and Revenue Recovery for Central Maine Power Company, testifying today in opposition to LD 1955, an act to facilitate net energy billing. CMP is committed to working with net energy billing project sponsors to determine the best and most efficient practices surrounding NEB arrangements. The industry is currently expanding exponentially, as evidenced by the immense growth of community solar projects. In turn, these projects will go a long way in positioning the state of Maine to meet, if not exceed, its clean energy goals. However, this proposed legislation is not the right methodology or at the right time. LD 1955 proposes very prescriptive details at a time when the industry continues to evolve. Details as outlined in the proposed legislation are normally reserved for rulemaking rather than statute. Determining this level of detail in statute ties the hands of Maine regulators, namely the PUC, detrimentally impacting its ability to manage utility billing through rulemaking. Working with stakeholders to determine long-term, sustainable best practices for community net energy billing projects through the PUC's rulemaking process would be more advantageous to the long-term benefit for all Maine customers. Many of the details within LD 1955 appear to be designed to promote community NEB projects through utility billing systems and functions, unreasonably transferring such costs from the actual projects themselves to all Maine utility customers. In particular, Section 8D has the potential to increase utility costs by directing when and how customers should be billed without regard to and potentially in conflict with the efficient processes established by utilities and approved by the PUC. In addition, customers who sign up for more than one community solar agreement who each want to bill on a certain cycle could be caught in a state of limbo. Instead of a focused priority on customers, this legislation shifts the primary benefit to the community NEB project developers. CMP supports the review of rules and regulations where our customers are and will remain the priority. This proposed legislation has the very strong likelihood of increasing overall costs for all customers, whether they participate in a community solar agreement or not. Instead of rushing into further changes around net energy billing, CMP recommends letting the overall market continue to evolve and mature and taking a more holistic approach to the most effective and efficient means of accomplishing net energy billing. Both Ms. O'Neill and Mr. Hardwood before me said it best. The technical details around NEB are immense. Thank you for your consideration. I'd be glad to answer any questions you may have.
Thank you, Mr. Morissette. Questions from the committee? Mr. Morissette, really appreciate your testimony. And it was brought up earlier today by another representative for IECG. I don't know if you were present for that discussion, but that Central Maine Power had not testified, I think actually testified in support of the bill that moved community solar forward. Is it my understanding that position has changed at this time?
I really can't comment on that, Mr. Berry. I wasn't involved in those discussions previously, but CMP is definitely a strong proponent of expanding community solar projects and helping to assist Maine meet its climate goals.
Great, thank you. And any other questions from the committee? Seeing none. Appreciate your joining us and sticking with us all the way through this long day. And Kendra Overlock, you're up next.
Hello, good afternoon, Representative Berry, members of the committee. My name is Kendra Overlock. I'm a 26-year employee of Versant Power and its predecessors. Very proud to say that. I'm born and raised in Bangor, and I live currently in Glenburn, and I'm here today to speak in opposition to LD 1955 on behalf of Versant Power. Just to be clear from the outset, we remain committed to working with NEB stakeholders and faithfully implementing policy changes. In this case, we do question whether the significant cost of making the changes to our billing system proposed in LD 1955 are justified by the benefit of the change, which would accrue solely to NEB project developers and not the non-NEB customers who would fund the necessary upgrades via their rates. The other testifiers today did speak to the complexity of these changes and the impacts on billing systems. And I actually very much like the idea of Ms. O'Neill's around the monthly working group, because I think that that's a great way to work through some of these technical issues and come up with solutions that we can move forward, that we can provide customers and developers with the transparency that they need to make these programs a success, but also do it in a way that doesn't negatively impact other ratepayers. So I did put some detailed considerations in my testimony, which I hope you will take the time to read. But I will just wrap by saying that in light of all those considerations, we believe the most productive way to resolve the proposals is to encourage stakeholder discussion at the stakeholder group managed by the Maine PUC, which is currently discussing and evaluating NEB proposals for the future. Sorry, lost my place. And to direct that group to bring consensus-based recommendations back to this committee. We think it makes sense to incorporate necessary changes into the NEB 2.0 framework and take a holistic approach that will ensure that to the extent changes are needed, such changes will be implemented more efficiently and accommodate the NEB 2.0 requirements and thus benefit all customers, NEB and non-NEB alike. So as I said, other examples of questions and considerations are in my testimony. Thank you for your consideration, and I'd be pleased to answer questions as I'm able or bring back information to the work session. Thank you.
Thank you very much, Ms. Overlock. Are there questions from the committee? And I do have one. This is specific to section 8 of, section 3 of the bill. Number 8, under MRSA 3209 sub A would read just at the very beginning, net energy billing data is the property of the customer to which it relates. I found that to be a really interesting concept because it seems sort of obvious that our usage data should be our own. Can you comment on that? Whose property is that data at present? Do I, as a net metering customer in the state of Maine, currently own or have a right to my net energy billing data. So in other words, would enacting that alone in law be a problem from Versant's point of view?
I don't think it's a problem. I think for Versant customers today, you currently have access to your information through our online user portal, which is secure. You can log in, you can access that information and download, and then you could share that in any way you wanted to with a developer or third parties, but it is your data and your information.
And as a follow-up, to what extent is that data currently protected? So is my usage data, net energy billing or otherwise, able to be bought and sold by third parties in any way?
It is protected by us. If customers give permission and are willing to share that data, that is within their purview to do that, but we do not share or sell any customer information.
Great, thank you very much. And are there other questions from the committee? Seeing none, really appreciate your sticking with us. And we will go next to Melissa Winnie from the Governor's Energy Office, followed by Michael Stoddard from the Efficiency Main Trust. And I'll also ask if anyone else is here to testify, you can just raise your hand. If you're an attendee, patiently watching and waiting for your turn. Melissa Winnie, Michael Stoddard, and the PUC. Okay. We see you, Deirdre. Melissa, thank you for waiting.
Yes, good evening now, Representative Berry and members of the EUT committee. My name is Melissa Winnie, and I am an energy policy advisor for the Governor's Energy Office. And we are testifying today neither for nor against LD 1955. And I did submit written testimony for you to review, and I'll just mention some of the highlights here. First, to say that we do appreciate the overall intent of this legislation around streamlining processes for data sharing that allows for improved customer experiences, particularly for those involved in the energy billing program. We recognize that this is a complex challenge, and it has been discussed or brought up in various venues, including the DG stakeholder group that we are running that was established by legislation passed last session. And it does try to address challenges that are part of larger discussions around data transparency, which is a vital component of meeting our clean energy and climate goals. So while we recognize the importance of data sharing to ensure successful clean energy programs, we do have a few questions and concerns about the potential consequences of this bill. First, I think as you may be getting at with some of your questions here tonight, trying to better understand the implications of establishing the ownership of data by utility customers and making sure that if that is done, it is with adequate consumer protections. We'd like to better understand the implications of how this would impact the qualification of customers for Efficiency Main Trust, Main Housing, and other assistance programs. Do recognize that there's language in the proposed legislation around this, but want to make sure that that's clearly understood. And finally, whatever is pursued as a solution to these data sharing issues, to make sure that it's done in the most cost-effective way. Similar to the public advocate, given the complex technical nature of these proposed changes, and to make sure that these efforts around data sharing work in coordination with existing regulatory rules, we do suggest that the committee consider this to be taken up through PUC processes rather than through statute. So thank you for your consideration. Happy to take questions, and we can be available for the work session as well.
Thank you very much. Other questions from the committee? Seeing none, really appreciate that testimony. And Ms. Winnie, I wonder if your testimony, I apologize, I haven't seen the written testimony, but would it be possible to take from that and actually amend this bill? Do you see an amended version of the bill that you would be able to help us to shape based on that testimony?
I think we'd be open to having that conversation. Again, we do think that this is likely better handled just because of the technical nature of this all through PUC processes. And I will note, we do have the DG stakeholder group. And as you know, that is really looking at future successor programs. So to the extent that this issue is contemplated in this legislation relates to the development of a successor program, I think that group will be discussing this. But given the scope and timeline and the apparent intent for this to really be more related to existing net energy billing programs, that's another reason where we were suggesting that the PUC, rather than through any existing program or processes that we're managing, but would be open to having that conversation if helpful.
Got it. Thank you.
Thank you.
Other questions from the committee? All right, seeing none. Did I see a hand? I guess.
I just thank you. I just wanted to thank you, and I did read your testimony. Thank you so much, Melissa. I just wanted to clarify so that the PUC, the place within the PUC that you see this residing is within the DG stakeholder group, correct?
Thank you, Representative, for the clarifying question. So the DG stakeholder group is what the Governor's Energy Office is managing. And what I'm saying is that I think that this is actually better handled through the PUC. So whether that's, an NOI that's followed by a rulemaking, again, I think that the DG stakeholder group recognizes that this is a challenge and is talking about it in terms of future successor programs, but that's not quite what this legislation is directing.
Thank you for the clarification.
And seeing no other questions, thank you for your testimony.
Thank you for sticking out through the long day.
That's why we get the big bucks. Mr. Stoddard, welcome. And we'll go with on deck is Deirdre Schneider. Go right ahead, Director Stoddard.
Good afternoon, Chairman Barry, members of the committee. My name is Michael Stoddard. I am the Executive Director of the Efficiency Maine Trust, and I appreciate the opportunity to testify before you this afternoon. Our organization is neither for nor against this bill. My only comments pertain to Section 2 of the bill, and I'm quite concerned by what I perceive as heavy-handed infringement on the authority and the discretion of the Efficiency Maine Trust in designing its programs with regard to eligibility and the amount of financial incentives. I can't think of a bill that's come before you in recent years that came right out and directed us who should be or must be eligible or ineligible and how much we must or must not pay them in incentives. It feels like it's not a good precedent, and I think we've been able to do a good job of finding the balance of equity and fairness in making those determinations. And this feels like it could end up being quite problematic in the outcomes. So I have some serious concerns about Section 2. I don't have other comments on the rest of the bill. I'd be happy to answer any questions.
Thank you, Mr. Stoddard. And just to clarify, your testimony is neither for nor against, or is it in opposition?
It's neither for nor against, because I think that section appears to me to be sort of an anomaly to the rest of what the bill is about. Perhaps I'm misreading it, but the rest is really about exchanging data in order to implement net energy billing. At least that's how I understood it from the proponents. This kind of comes out of left field. None of the proponents of the bill explained why this particular section should be in the bill. They didn't say anything about what they were trying to address. They may have their reasons, I'm sure they do, but they weren't put forward. And I can tell you from our perspective, it would result in, I think, some quite awkward outcomes. We currently offer as much as 50% incentives on behind the meter distributed generation programs. Are you telling me that somebody should get the benefits of the subsidies of the net energy billing program, and then we are required to also give them another 50% incentive on the cost of their project. I can't imagine that that's really what policymakers want to happen.
Got it. That's helpful. So that specific part of the bill. Okay, Representative Foster.
Yes, thank you. Mr. Stoddard, I don't think I saw that you had written testimony submitted. Do you have, are you going to, or?
I could pull something together, but I had not to this point.
If Representative Grochowski were here, Director Stoddard.
I know. And I would point out that the whole thing's recorded on YouTube. So it could save us both a bunch of time. We've all invested quite a bit of it today.
That's true. Although you're a lawyer, I'm not. I don't know if the courts would be able to determine legislative intent from YouTube, or if there's a precedent for that.
Oh, I'm sure they can.
Okay. All right. We heard it here first. Any other questions? Seeing none, appreciate your testimony. And Deirdre Schneider.
So I'm the person holding up you adjourning for the day, correct?
It's
so
all your fault. Right, exactly.
So Representative
welcome.
Berry and members of the Joint Standing Committee on Energy, Utilities and Technology, my name is Deirdre Schneider, and I'm here to testify neither for nor against on behalf of the Public Utilities Commission. I won't go through my testimony verbatim. It is online. I will just sort of echo some of the other concerns you heard, that while we don't know what the costs of this could be, we imagine they could be substantial and that those costs could be passed on to ratepayers. We had some concerns with clarity regarding the Commission's requirement to post information about complaints received from a project sponsor regarding the utility's compliance with this section. It uses this term of useful information. We're not really sure useful or what exactly this is getting at. And we already have a process established for project sponsors to provide complaints for utilities not complying with Commission rules. So we were not 100% sure what the intent was there. On the assistance program piece that Mr. Stoddard just mentioned, we understand there is a potential issue there as far as somebody who's participating in an energy billing program being able to use any assistance they qualify for the project sponsor. And at the current time, they can't do that. We don't know if this is what that was trying to get at and just didn't get at it successfully or not. So our thoughts are, if the primary goal of this legislation is to enable low-income customers to participate in the benefits of distributed generation programs, we would suggest carefully studying the program designs for these customers, given the challenges potentially diverting money from other low-income programs. So in conclusion, I think we see that it's possible that the changes contemplated in this bill could result in benefits to customers participating in an energy billing program, but we would caution against making those changes at this time. And specifically, the Commission suggests looking comprehensively at this issue with a focus on the customer and how those costs may be allocated in a fair manner that does not result in significant ratepayer impacts. We think it may be more efficient and cost effective to require that the distributed generation stakeholder group established by Public Law 2021, Chapter 390, to explore this issue over the interim include recommendations in its final report due in January of 2023. For us, this approach seems especially prudent since that group is exploring the framework for a successor net energy billing program. And that successor program could require different or additional needs for the handling of net energy billing data, which could lead to making undue changes now that would then result in having to do additional changes later and add additional costs. So I know that the GEO suggested that we send this to the PUC to look at further, and we're sort of suggesting that the GEO and that stakeholder process look at it further. And I think our reasoning there is mostly in the context they're looking at a successor program. So it would be beneficial to look at what that program may look like and what those needs may be together with what the existing needs are. So it's a comprehensive look as opposed to siloing it separately or not having that information available and making decisions now without knowing what that program would look like. So I'd be happy to answer any questions and provide additional information for the work session.
Questions from the committee. Representative Sachs.
Well, Ms. Schneider, you hit on my question directly. Having read both of your testimonies, PUC says go to DG, and as you noted, I just asked Ms. Winnie, same thing. So you're saying go to the PUC, and then proponents of the legislation just said we really like the idea of maybe a stakeholder working group. So I'm hopeful that perhaps there can be some conversations about this in the interim before the working group, because there at least seems to be alignment around the fact that this is a complicated issue and that it needs further discussion. So as for me, the most important one of the factors around this is the impact upon low-income folks and their programs. So I don't know if that's a planned conversation now that you've both seen each other and heard each other's testimony at this late hour, to talk about that and to see if there's a way forward in that way.
Yeah, we would be more than happy to work with the GEO and see if we can figure something out. And I think it's a timing thing too. If the committee wants to send us to the PUC, maybe not have us make a decision until we know what that new framework would look like, so we can look at it at the big picture, because we don't want to suggest, okay, we go down path A and then a new program comes out that's enacted next year that requires something completely different. And then we're adding additional cost burdens or complications to the system. So I think it's a timing thing, but we would be more than happy to work with whoever to try to figure out a path forward for this conversation to continue. Thank you for that question.
Any further questions?
No, thank you very much.
Okay. So I think we're all set with you, Deirdre. Thanks for sticking with us. And
Thank you.
I think that may conclude our work today. Let me just ask if there's anyone who is still an attendee, patiently waiting to testify, if you could raise your hand, if so. And Jason, do you know of anyone who's still waiting?
I do not.
Okay. So that may conclude our work for today. I will declare the public hearing on LD 1955 to be closed at this time. Our committee will schedule a work session on both LD 1959 and LD 1955 in the coming days and advertise it through our committee clerk, Jason, and you can always contact him via the legislative website at legislature.maine.gov. Lindsay, is there anything else that you have for us before we adjourn for the day?
Not for today.
Okay. Well, I'm especially grateful to the 4 members that are still with us, and to Lindsay and Jason for getting us through this very full day. Looking forward to seeing everyone tomorrow in person at the State House. And with that, do I have a motion to adjourn? It's been moved by Representative Sachs and seconded by Representative Ziegler. All those in favor? All right, it's unanimous. Excellent. And with that, nice to see